All right, good morning. The Colorado Energy and Carbon Management Commission convenes yet again on Thursday, November 20th at 10:30 a.m. We start with a roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
and Commissioner Robbins.
Here.
Mr. Chair, you have five commissioners present.
Five is a quorum, therefore we exist. We are taking up one matter today and tomorrow. It's docket 241200313, an oil and gas development plan. The applicant is Crestone, and this we have a couple of others that are stakeholders in this. Let's go ahead and elevate the three lawyers, please. Good morning, council. Let's start with entries of appearance. Ms. Jost.
Good morning, Chair. Jamie Jost of Jost Energy Law for Crestone Peak Resources Operating LLC in the State Sunlight Long Oil and Gas Development Plan application this morning.
Thank you. Mr. Prescott.
Good morning. Thank you, Chair. Good morning, Commissioners. Stephen Lewis Prescott on behalf of petitioner Maverick Mineral Partners 2 LLC.
And Mr. Foote.
Good morning, Mr. Chair and Commissioners. Michael Foote appearing on behalf of Save the Aurora Reservoir, or STAR.
All right. We have this set up for hearing today and tomorrow. Just for the record, we took public comment yesterday. Assume all of you listened into that. My agenda says we're starting out with opening statements, but before we get to that, does any attorney have any procedural issues that we need to discuss? Ms. Jost?
Thank you, Chair. Nothing here.
Mr. Prescott?
Nothing, Chair. Thank you.
Mr. Foote?
Nothing from STAR.
Oh, excellent. Oh, we're starting out on a really good approach here. All right, then the way I've got it set up, and let me just make sure we're all on the same page. I've got opening statements from Crestone, followed by Maverick, followed by Star. We then have the case in chief by Crestone. We then have the case in chief by Maverick, then have the case in chief by Star. Any rebuttal presentations, if any, and then closing statements by Maverick, Star, and Crestone in that manner, with deliberations by commission to follow. Oh, here we go. I also just want to confirm I've got time allocations. Crestone is allotted 6 hours, Maverick 3 hours, Star 3 hours. The presentation time includes any opening and closing statements, presentation of cases in chief, as well as witness cross-examination and rebuttal. Presentation time does not include time associated with commissioner Q&A or deliberations. Does anybody have any concerns with any of that? We're all on the same page?
Respectfully, Chair, I don't think it's likely, but there's a chance that Maverick may request some additional time, but that's a bridge that I'd prefer to cross if and when we get to it, and I don't think we will.
Great. That's the way I like to approach those sorts of things as well. Let's cross bridges when we get to them. Hearings Manager Thomas, are you with us?
I am.
Yeah.
Mr. Chair.
Will you or someone on your staff be responsible for timekeeping?
I will be keeping time.
Okay.
And we'll provide checks.
Attorneys, if at any point in time you want a time check, just call out time check. All right. Well, with no further ado, let's get into it. Ms. Jost, your opening.
Yes, Chair. Thank you. Mr. Thomas, can we elevate Mr. Jeff Annabelle because he'll be sharing our screen today before I start?
Oh, actually, Ms. Jost, before you start, do we want to go ahead and swear in witnesses now to sort of get that taken care of?
That might be great, Chair. We have several. So if we want to do it for all parties, is that what you're talking about?
Let's just do it. Let's just knock it out and get everybody done. So let's bring your witnesses to the fore first, and then we'll go with Mr. Prescott's and then Mr. Foote's, and that way we'll have taken care of that.
Wonderful, Chair. That sounds good. Oh,
I apologize, Chair. I'm not certain that my witnesses are here right now.
Okay.
So we may have to hold off on swearing them in maybe at the start of our presentation.
Yeah, that's fine.
Apologies.
Let's pivot accordingly. Let's bring in Ms. Jost's witnesses first, and then we'll do yours and Mr. Foote's at the time that you guys start out your case in chief.
Okay, please give us one moment, Mr. Chair, as we elevate the witnesses for Crestone.
Okay.
Great. Thank you, Mr. Thomas.
While that's happening, Ms. Jost, does Randy Dan need to be sworn in?
Yes, he will be, Mr. Boudreau.
Thank you.
You're welcome.
I have a long list here, so if I miss anyone, please let me know.
I will. I'll keep track on my end as well.
Thank you.
Believe we've elevated everyone, Ms. Jost. I know it's a large panel. If you could confirm if we're missing anyone.
I believe we need Tracy Green uploaded. I think. And then Logan McConnell. And Julie Jenkins. And Scott Farkas. Okay, I see Scott on. All right, I see Miss Green. I see Mr. McConnell. Wonderful. So I think we just need Mr. Thomas, Julie Jenkins. Oh, there we go. And then let's see here. Do we have Vince Ginter on? Maybe one more, Mr. Thomas.
Okay, we found Mr. Ginter. He should be elevated shortly.
Okay, perfect. And I see him on. Mr. Dan and Mr. Ginter, can you come on video if you have the option to do it? Same with you, Miss Dell, and there we go. And then Mr. Farkas, can you have the ability to come on video?
I changed it to video, but for some reason it's not.
Okay, there we go. We
you're
see
there.
that. There we go. Wonderful.
Mr.
Okay.
Boudreau, start the swearing.
Thank you, Mr. Chair. I'll ask each of the witnesses to be visualized when I call your name. Please raise your hand, state your first and last name, and swear to tell the truth. We'll start with Dan Harrington,
I, Dan Harrington, swear to tell the truth.
Nathan Bennett,
Good morning, Nathan Bennett. I swear to tell the truth.
Kathy Stearman,
Good morning, Kathy Stearman. I swear to tell the truth.
Scott Farkas,
Morning, Scott Farkas. I swear to tell the truth.
Lila Hooning,
Lila Huning, I swear to tell the truth.
Julie Jenkins,
Julie Jenkins, I swear to tell the truth.
Jeff Annable,
Good morning, Jeff Annable. I swear to tell the truth.
Jeremy Saunier,
Jeremy Saunier, I swear to tell the truth.
Rich Coolidge,
Coolidge, I swear to tell the truth.
Casey Decker,
Casey Decker, I swear to tell the truth.
Emily Swanson,
Emily Swanson, I swear to tell the truth.
Brian Puckett,
Ryan Puckett, I swear to tell the truth.
Vincent Ginter,
Vincent Ginter, I swear to tell the truth.
Tracy Green,
Tracy Green, I swear to tell the truth.
Linda Dell,
Linda Dell, I swear to tell the truth.
Logan McConnell,
Logan McConnell, I swear to tell the truth.
Randy Dan.
Hi, Randy Dan, I swear to tell the truth.
Did I get everybody, Miss Jost?
You did, Mr. Boudreau. Thank you for that.
Thank you.
Thank you, Mr. Boudreau. So if the witnesses can unvisualize, we'll probably have screen sharing going on here. And with that, we will start with the opening statement from Crestone.
Wonderful. Thank you, Chair. All right. Well, good morning, commissioners, staff, council, members of the public. My name is Jamie Jost of Jost Energy Law, and I, along with my partner, Kelsey Wazelinski, represent Crestone Peak Resources Operating LLC on the State Sunlight Long Oil and Gas Development Plan application. Thank you for the opportunity to present to you today. Crestone would first like to thank the Colorado State Land Board, Arapahoe County, and the City of Aurora for their partnership and engagement to progress this OGDP. Their written comments illustrate the high bar that each of these entities maintain to best protect the public and are helpful to ensure that the Commission has all of the necessary information before it in order to make an informed decision on this OGDP. Crestone has worked tirelessly with each of the three governing bodies for the last 18 months, and as a result of the continued positive working relationships with each, has achieved successful results by executing a formal surface use agreement for the State Sunlight Long location from the Colorado State Land Board, obtained an approved administrative use by special review permit from Arapahoe County, and engaged in consistent discussions with the City of Aurora regarding the development within the vicinity of the Aurora Reservoir. The ECMC director and staff also engaged in a thorough and detailed review of the OGDP application, the Form 2A, over 45 sets of plans and exhibits, the voluntary alternative location analysis narrative, and the Form 2B cumulative impact data identification, Form 2C, and OGDP hearing application documents, including the drilling and spacing unit application and detailed Rule 505 land, geology, and engineering testimony. Reviewing an OGDP, all of the corresponding documents, and numerous public comments is no small task, and it's not one the ECMC staff takes lightly. Crestone recognizes the amount of time spent on each document and is appreciative of the effort that went into the completeness determination and technical review process, as well as the preparation of the director's recommendation for conditional approval of the OGDP. Crestone appreciates the CDPHE and Colorado Parks and Wildlife engagement on the development of best management practices and mitigation measures that confirm the protection of public health, safety, welfare, the environment, and wildlife resources. Through these various consultation with these state agencies, Crestone will apply over 90 best management practices and mitigation measures to the location, including some never before seen wildlife resources BMPs. These BMPs and mitigation measures are in addition to the many avoidance factors Crestone applied to the location. Finally, Crestone is grateful for Last Chance DJ Holdco LLC, a 450-acre leasehold owner of minerals within the OGDP, and the Colorado Association of Mineral Royalty Owners, the premier trade association representing thousands of mineral owners and their real property rights in Colorado, including mineral owners in the OGDP, for their public support of this application. Each of the 8 referenced entities have provided substantial evaluation and input into this OGDP application. As a result, each has provided this commission with various types of documentation that reach the same conclusion. The OGDP application is supported, is compliant with the Colorado Energy and Carbon Management Act and ECMC rules, and should be approved by this commission. It's important to level set where this project is in the process of development for the benefit of the listening public. The 7,682.10 acres of land and minerals covered by the application are located entirely within the 32,000-acre Rule 314 Lowry Ranch Comprehensive Area Plan and are governed by the recently upheld Order Number 535-1490. Order Number 535-1490 granted Crestone several incentives, but more importantly, after a detailed review and evaluation of cumulative impacts associated with the Lowry Ranch CAP development, required Crestone to comply with several best management practices to ensure the protection of public health, safety, welfare, the environment, and wildlife resources exist. The Lowry Ranch CAP is effective and applicable to this OGDP. In this docket, Crestone is seeking approval of the State Sunlight Long OGDP, the location, and 2 drilling and spacing units for the development and operation of the Niobrara Formation. The final step to the development of the OGDP is to obtain Form 2 applications for permit to drill through a separate future process under ECMC Rule 308. This slide illustrates the location of the OGDP and the 2 proposed drilling units within the governing Lowry Ranch CAP. Crestone has currently obtained approval for the State La Plata South oil and gas location, the State Harvard Yale and State Wetterhorn Handy's oil and gas locations, and the State Blanca OGDP is currently pending completeness review. The State Beaver Pad shown on this map will not be developed, and Crestone has confirmed this fact publicly for several months. The OGDP proposes the use of 1 new oil and gas location for the development of up to 32 horizontal wells to be developed in 2 drilling and spacing units, the State Sunlight DSU and the State Long DSU. The location avoids each of the Rule 304B2 alternative location analysis criteria and is over 3,000 feet from the nearest residential building unit. Crestone proposes 2 3,840-acre drilling and spacing units for up to 16 wells each. Crestone was cognizant of Maverick's drainage concerns noted during the Lowry Ranch CAP hearing for the State Sunlight DSU and intentionally utilized ECMC Rule 401A's statewide subsurface setback of 600 feet for lands adjacent to Maverick's offsetting and outside of the OGDP mineral interests, despite technical analysis demonstrating that a reduced setback is appropriate. Crestone has been working on the ECMC OGDP and Arapahoe County permit since early 2024. The OGDP was filed on December 11th, 2024. It received completeness in July of 2025, with that completeness letter and notice of hearing being sent certified U.S. mail to 3,542 interested parties, was open for a 52-day public comment period, received a director recommendation for conditional approval on October 29th, 2025, and is now scheduled today for final hearing. Arapahoe County approved the local government permit on May 30th, 2025, after a year of detailed review and public input. The OGDP and corresponding drilling and spacing unit application is in compliance with and meets all the criteria of the Act and the applicable ECMC rules. Crestone will provide substantial evidence during hearing to support its requested relief and to meet its burden of proof of compliance with the applicable statutes in the Act and ECMC rules. Crestone will show that while no 304B2 alternative location criteria was required, Crestone acknowledged STAR's concerns in the Lowry Ranch CAP hearing regarding the then 3-pad plan, the State Long Pad, State Sunlight Pad, and State Beaver Pad, which has now been consolidated to the one proposed pad, and conducted a voluntary alternative location analysis. Crestone will also provide testimony through detailed subject matter expert and third-party experts regarding its compliance with Commission Order 535-1490's conditions of approval and its full commitment to develop the location with a grid-powered drilling rig and 3-phase takeaway, as well as its compliance with Arapahoe County's state leading regulations by siting the location over 3,000 feet from a residential building unit and over 3,000 feet and topographically isolated from the Aurora Reservoir with confirmation of the location from Aurora water. It will provide testimony on its robust emergency response plan and wildland fire mitigation plan that's been approved by Arapahoe County and supported by Bennett Watkins Fire Rescue. It will provide testimony on its multiple consultations with CPW and CDPHE, its use of the avoid, minimize, and mitigate hierarchy evaluation and analysis, and the hierarchy's application to the 90+ best management practices and mitigation measures applicable to the location, as well as detailed noise mitigation plan testimony and acknowledgement of mitigation measures that result in full compliance with Rule 423, as well as Crestone's voluntarily adopted continuous air monitoring program that will continue through production operations for the life of the wells, with this program exceeding the CDPHE Air Quality Control Commission's required 3-month monitoring and Arapahoe County's 3-year monitoring requirement. We will also discuss public health protections and expert testimony on certain public health studies, as well as geology and engineering analysis regarding Crestone's proposed subsurface setbacks and drainage calculations that prevent waste and protect correlative rights, along with other information that supports full approval of this OGDP. Crestone has received overwhelming support for this OGDP from the entities listed on this slide. Most importantly, not one of the 3,542 interested parties are here today opposing the OGDP. Neither Save the Aurora Reservoir nor Maverick Mineral Partners II are interested parties entitled to notice under Rule 504. With the support of the entities listed on this slide, along with the fact that not one Rule 504 interested party is here today petitioning the application, Crestone affirms that the OGDP has met the expectation of the stakeholders, has complied with the law, and is an approvable application. During the presentation today, Crestone will utilize over 100 exhibits and will provide scientific and technical testimony by 11 total subject matter experts and third-party experts to illustrate to this commission that it's met its burden of proof, along with 8 other subject matter experts available if needed. As Crestone began preparing for the contested OGDP hearing, it engaged in a detailed evaluation of each party's affected person status under Rule 507. Crestone did not and still does not believe that either STAR or Maverick truly holds affected person status under this rule. However, in light of this commission's past precedent of allowing STAR to participate as a party, and the commission's position taken in the Denver District Court proceeding with respect to Maverick, Crestone determined that in order to promote administrative efficiency and to reduce delay in getting this docket to hearing, everyone would benefit by Crestone stipulating to party status for both Star and Maverick. Crestone's stipulation clearly provided, however, that it does not stipulate to any claims, assertions, or positions taken by petitioners, and that Crestone did not waive its rights to address all petitioners' claims, assertions, or positions at any point in this process. Star's positions and exhibits fail to show that Crestone's OGDP is not compliant with the Act or ECMC rules. Star, through its members, are continuing what it started in the Lowry Ranch cap hearing, which is an attempt to influence this commission with scare tactics, verbal threats of litigation, and unfounded positions in the hope that the commission ignores or contravenes the very statutes and rules it must abide by. Star will present witness testimony relating to purported noise impacts to residents over 3,000 feet away from the location, but as in the Lowry Ranch cap hearing, Star's witness is not reliable nor credible because his assumptions are incorrect and misleading, and they'll also present purported habitat impacts to northern leopard frogs on the 26,000-acre Lowry Ranch, but Star's witnesses are relying on a one-day survey which cannot compare to Crestone's almost 14-year history of wildlife surveys on the ranch. Star will discuss perceived failures in the Arapahoe County permitting process, but they fail to understand that this ECMC hearing is not the appropriate venue to collaterally attack Crestone's approved Arapahoe County local government permit. They will bring up purported air emissions and air monitoring concerns, but use a known unreliable oil and gas activist witness with late filed scare tactic videos and non-disclosed exhibits that misconstrue the facts, with this activist witness presenting similar testimony to the Air Quality Control Commission in February of 2025 without success. And they will also heavily rely upon the number of public comments submitted from the Star community, yet will fail to disclose to this commission that those comments only represent at most 3.5% of the residents in the subdivisions near Aurora Reservoir, and that they're not individualized comments, but boilerplate comments drafted and circulated by Star with the directive as to how and when to submit to the ECMC. Star's own leader, Randy Willard, who you improperly heard from during public comment at yesterday's hearing, has publicly stated to Fox 31 News that, and I quote, "I think ultimately these things will be permitted. I am hoping that between delays in getting into the ground, delays in some of the legal processes and whatnot, the price of oil comes down to a point where these things no longer make sense," end quote. Mr. Willard has also publicly and gratuitously stated that he, quote, "greatly values the contributions," end quote, of other known anti-oil and gas activist groups in Colorado, including 350 Colorado, Colorado Rising, and Climate Movement Colorado. Star is also associated with Climate Defiance, the oil and gas activist group whose mission it is to end fossil fuel extraction, where both groups of members interrupted the State Sunlight Law 511 hearing with chants and screaming, which led to intervention of on-site law enforcement officers. Star's activist intent is considerable, as are the lengths it will go to attempt to influence this commission by engaging in ex parte communications, by having Star members give public comments during commission hearings, including yesterday, after becoming a party to this case in violation of ECMC Rule 530, including directly telling its Star members, quote, "If you decide to speak, please do so as a concerned citizen and make no mention of Star," end quote. Star has successfully obtained its desired delay in the development, but now it's time for hearing. By the end of this hearing, it will be clear that Star did not meet its burden to support its claims in its petition, and the commission will have more than enough scientific, technical, and regulatory evidence to approve the OGDP. Maverick's positions and exhibits also fail to show that Crestone's OGDP is not compliant with the Act or ECMC rules. Maverick is also continuing what it started in the Lowry Ranch cap hearing and the Denver District Court proceedings by claiming that Crestone will drain its offsetting leasehold interests and that the ECMC is mandated to bring Maverick's leases into the State Sunlight DSU, all while failing to disclose that it has not made any attempts to develop its offsetting 59 acres of interest in any way. Maverick will present testimony relating to purported drainage calculations from Crestone's proposed horizontal wells in the State Sunlight DSU, but such testimony will fail to disclose that Maverick has already accepted similar or even smaller subsurface setbacks in other join and spacing units in the area, and has also expressly elected to participate in larger spacing units from Crestone. They will also purport or attempt to testify to purported impacts to Maverick's oil and gas leases, but that testimony will also fail to disclose that Crestone holds zero privity of interest in those leases, nor will Maverick disclose that it negotiated no surface occupancy leases, which immediately puts its own leases at risk of non-development by its own actions. It will also discuss its purported concerns that Crestone holds a, quote, monopoly on the development of the surrounding surface lands, but will fail to acknowledge that Order Number 535-1490 and Rule 314b1 only conveys the exclusive right to develop the oil and gas formation or formations that are subject to the cap. This is subsurface exclusivity and not surface. They'll also testify to its purported concerns that there are no surface locations from which Maverick could develop its 59 acres and lands outside of the cap, but will fail to acknowledge that Crestone, in an effort to assist Maverick, conducted its own due diligence and found at least 4 potential alternative locations from which Maverick's minerals could be developed. It will also continue its misrepresentative attempts to construe dicta, meaning statements in a court's written opinion that are not essential to the final decision of the case, in the Denver District Court's order as mandates on the ECMC, but will fail to acknowledge that the court's holding did not in any way mandate this commission to find in favor of Maverick. Maverick has also continually abused the Rule 509 pre-hearing process and has violated the hearing officer's binding case management order at almost every turn by submitting its exhibits 10 days after they were due, and then after being admonished by the hearing officer, introducing at least 6 new exhibits just days before this hearing. The facts relating to Maverick's violations are captured in the November 14th, 2025 final pre-hearing order. While the hearing officer did not apply any sanctions to Maverick under Rule 501A, the commission is free to do so on its own volition should it find them appropriate during the course of this hearing. Like Starr, at the end of the hearing, it will be clear that Maverick did not meet its burden to support its claims in its petition, and the commission will have more than enough scientific, technical, and regulatory evidence to find in favor of Crestone and approve the OGDP. To close, Crestone respectfully requests that this commission approve the approximate 7,683.1 acre OGDP for up to 32 new horizontal wells developed from 1 new oil and gas location, and find that the OGDP, with the approved Lowry Ranch cap, will protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, or biological resource in compliance with CRS 3460-106.2.5A. They request the commission approve the 2 drilling and spacing units as proposed in the OGDP application and deny the Star and Maverick petitions. Thank you for your consideration of Crestone State Sunlight Long OGDP application, and we look forward to presenting our case.
All right, thank you, Ms. Jost. We now will hear from Mr. Stephen Lewis Prescott on behalf of Maverick.
Thank you, Mr. Chair. Allow me to figure out how to share my screen here. Are you able to see the slide?
No.
All right. Right, and now are we able to see the slide?
We can see the slide. It is not in presentation mode, if that matters. Now it is. Now you're good.
Right. Thank you. Thank you, Commission. Stephen Lewis Prescott on behalf of Maverick, a petitioner in this case. And thank you for the opportunity to present. This is an important case. One thing you're going to be asked to do is compartmentalize in this case. We heard public comment. The public clearly has its concerns. Star is another petitioner. Star will present its concerns. These are not Maverick's concerns, and they are separate. Then there's Crestone's case involving all the great things it did to try to protect public health and safety with OGDP. Maverick applauds this, but it is not relevant to Maverick's case. Maverick's case is highly technical, involving geologic concepts like drainage, waste, and correlative rights. Maverick's case is also highly legal, relying on explicit language in your rules and the Energy and Carbon Management Act, and even direct guidance from the Denver District Court. Maverick will ask for you to compartmentalize, and when Maverick presents, to put on your scientific hats and your judicial robes. Please know the importance of Maverick's case. Statutory and constitutional rights are implicated. Millions of dollars are at issue. The property of Maverick, its lessors, the city of Aurora, and E470 are at risk. And Maverick's proposed fix to all this is so incredibly simple, you'll likely ask Crestone why it did not present the fix itself. Maverick is a non-operator. Non-operators are a very important part of Colorado's oil and gas industry. They provide a competitive market for mineral owners seeking to lease. Often their lease terms are better than the terms offered by the operator. They have obligations to their lessors, such as protecting their minerals from drainage and ensuring the operator develops prudently and diligently. They help fund the operator's drilling operations. In return, non-operators are entitled to a return on their investment. For this, they rely on operators to adhere to the rules of the game. They rely on the commission to ensure that operators comply with the rules in the act. Maverick is here because Crestone has gone way out of bounds. Crestone is proposing to do things in this OGDP that operators don't do, and the act and rules do not permit. Crestone's proposal is a unicorn with no legitimate precedent. Maverick acquired leases in the Lowry Ranch cap when it was pending. After Maverick informed Crestone of its lease ownership, Crestone modified the cap boundaries. Crestone created an unprecedented island, cutting out Maverick's leases and the oil and gas resources of others, such as Aurora and E470 and countless mineral owners. Now, as Crestone develops the cap, it is maintaining its plan to exclude and surround the mineral owners in the majority of Section 18, where Maverick's leases are located. Recall Maverick challenged the Lowry Ranch cap. Maverick warned Crestone and the commission that Crestone's plan would drain Maverick's leases without compensation. Maverick also warned Crestone's plan would preclude Maverick or anyone else from developing Maverick's leases in the surrounding minerals. This causes illegal waste and violates correlative rights. In the Lowry Ranch cap hearing, you determined this DSU would be when Maverick's waste, correlative rights, and drainage concerns would be ripe, and therefore dismissed Maverick from the cap hearing. You recognize the seriousness of Maverick's concerns, and essentially warned Crestone about proceeding with this very DSU as planned. Crestone did not heed your warnings. Allow me to simply identify the three issues Maverick brings to your attention for the State Sunlight DSU. First, approval of the State Sunlight DSU will preclude Maverick from developing its leases. The evidence will show that there are no viable surface locations due to Crestone's cap design and OGDP proposals. This is waste, the unnecessary stranding of Mavericks and other mineral owners' oil and gas. Waste is prohibited by the rules in the Act. This violates correlative rights, Mavericks and the mineral owners' right to obtain their just and equitable share from a common pool, which is prohibited by the rules in the Act. Importantly, even if there was a viable surface location, the DSU cannot be approved. It would require the drilling of unnecessary additional wells, which the Act and the rules do not allow. We heard from the public yesterday. Nobody wanted any wells anywhere near the Aurora Reservoir or communities in Aurora. Excluding Maverick's leases from the State Sunlight DSU would require Maverick or someone else to drill additional wells near the Aurora Reservoir and communities in Aurora. Second, the evidence will clearly show that Crestone's wells, as proposed, will drain Maverick's leases, even though Maverick's leases are outside the proposed DSU boundaries. This is theft. This is an uncompensated taking. This is unjust enrichment. This violates the Act. Crestone has stated that its wells will be diverted so they are 600 feet from Maverick's leases. And Crestone is relying on Rule 401A, which states that wells cannot be less than 600 feet from a lease line. Crestone hasn't told you and won't tell you that Rule 401A was drafted decades ago when vertical wells were the only type of wells. Crestone won't tell you that while 600 feet may be workable in the Wattenberg field, where oil and gas has historically been developed, The evidence clearly shows Crestone's wells here are in the Watkins area, where the proposed DSU is located, and they actually drain beyond 1,300 feet, not 600 feet. Crestone hasn't told you that 600 feet is the minimum distance, not a presumptively safe distance under the rule. Rule 401A provides the Commission no guidance here, except informing the Commission that vertical wells in the Wattenberg drain approximately 600 feet. And this is simply an absolute minimum drainage distance. The cold hard evidence of Crestone's own development in the Watkins area proves wells in the area drain 1,300 feet. Wells drilled 600 feet from Mavericks leases as proposed will materially drain Mavericks leases and the mineral owners' oil and gas. The solution for these two issues is simple. Expand the state sunlight DSU boundary by 80 acres to include Mavericks leases in the south half, south half, south half of Section 18. It's also important to understand that Maverick does not need to be correct on both of these issues. Simply one necessitates the proposed fix that Maverick is providing to you. If Maverick is precluded from developing its leases, waste and correlative rights exist, and the DSU can't be approved unless its leases are included. Even if Maverick weren't precluded, additional unnecessary wells would be drilled. Again, this can't be permitted. Maverick's leases must be included. Alternatively, drainage will occur. Again, this can't be allowed. Maverick's leases must be included. The third and more separate issue that Maverick raises is Crestone's proposal to drill two sets of state sunlight wells, one set to the west and one set to the east of its surface location, but to combine all of the wells and their associated production into a single giant DSU. This makes no sense, particularly when looking at the geology. The western acreage, where Maverick's leases are, is much more productive than the eastern acreage. Thus, combining all the acreage into a single giant DSU, as proposed, dilutes the western mineral owners by sharing the revenue derived from their productive acreage with the owners of the less productive eastern acreage. This is another violation of correlative rights. The solution to this issue is also simple. Divide the state sunlight DSU into two DSUs. One for the wells drilled to the west and one for the wells drilled to the east. This is how Crestone has developed the rest of the Lowry Ranch cap. None of Maverick's proposed fixes require any modification to Crestone's actual drilling plans. The surface location can remain. The well paths can remain. No changes. The fixes pertain to the DSU boundaries and merely make Crestone's proposed DSU compliant with the rules in the Act. This depiction helps show what Crestone is doing. None of what Crestone is doing in this case is normal or standard industry practice. This is a unicorn proposal that carves out and surrounds minerals from proposed development, drains those minerals, but does not compensate the owners of them. Again, none of this is normal. Operators don't surround and exclude non-operator leases from DSUs. They don't drain oil and gas owned by others outside the DSU. They don't allow oil and gas to be stranded and undeveloped. They don't consolidate development from two sets of wells draining vastly different acreage into a single giant DSU. Something operators like Crestone do, which Crestone is refusing to do here, is extend their wells beyond cap boundaries to ensure oil and gas is not stranded. This is a reminder of the rules and the laws in play here. Rule 305B, which you called out in the Lowry Ranch cap order in the dismissal of Maverick, identifies 4 reasons for denying a DSU. Crestone's state sunlight DSU as proposed violates 3 of those 4 reasons, as bolded on this slide. The Act governs your rules and your orders. The Act repeatedly advises you that waste is prohibited. Correlative rights must be protected, and you're empowered to modify the boundaries and the size of a DSU in order to prevent waste, protect correlative rights, and avoid drilling unnecessary wells. Maverick is very simply asking you to enforce and comply with the rules in the Act. As Ms. Jost referenced, the CAP order was appealed, and the Denver District Court provided some pertinent guidance in its findings. Some of the court's statements and guidance is on the slide for you. Most notably, the judge found that you have not protected Maverick's correlative rights as recorded by the Act if Maverick is precluded from developing its leases. 510A makes very clear that the burden is on Crestone to show you that the OGDP and the DSU complies with all of your rules and the Act. You'll hear from two witnesses for Maverick, Mr. Kevin Herringer and Mr. Tom Smith. Both are very knowledgeable with regard to oil and gas development. They'll show you that Crestone's development removes from the board all potential surface locations, and that Crestone's rebuttal to this cannot be taken seriously. They'll show you why Crestone's evidence related to drainage is not evidence, but consists of unreliable assumptions that are proven false by Crestone's actual drilling in the immediate area. The disconnect in interpretation of drainage distance between Crestone and Maverick derives from Maverick relying on real observed production data, which shows drainage profiles in which drainage is highest near a well and drops off gradually, exhibiting partial drainage at greater distance. Crestone, on the other hand, relies solely on volumetric models that assume uniform drainage from the wellbore out to some much lesser distance where wells abruptly go from high drainage to no drainage. This is unrealistic and doesn't happen in nature. If any real observed production data supported this view of drainage, Crestone would have provided it among their exhibits, but they haven't. I'm going to try to use my hands to show Crestone's presentation on drainage versus Maverick's presentation on drainage, hoping that symbolizing it is helpful. It may not be, in which case I will rely on our expert to better explain it. So the thumbs are wellbores. The fingers, the hand, the rest of the hand is drainage from the wellbores. In the Crestone volumetric model, the wellbores, my thumbs, and drainage is uniform from my thumbs out to a drainage distance that is the outer edge of my pinkies. The space between my pinkies represents reserves left behind. Ideally, to drain a reservoir efficiently, the wells which are my thumbs would be 2 times the drainage distance apart, and my pinkies would be close together, leaving little or no reserves behind. This does not happen in nature without an impermeable boundary encapsulating the drainage field of both wells. In reality, again, the thumbs are the wells here. Nature has gradients. In Maverick's parent-child study observations, drainage is highest at the back of my hand, near my wrists, close to the wellbores, which are again my thumbs, and they taper off to 0 at my fingertips. So the drainage is essentially my hand, and it becomes less as we go this way. Spacing wells at 2 times the drainage distance, as Crestone erroneously implies in its evidence, will leave much of the middle region, the space between my fingers, undrained. Moving the wells closer together allows both wells to partially drain the middle area of the reservoir and achieve more uniform drainage. This tapering down of drainage efficiency away from a well is what occurs in nature and is why operators space wells at less than the maximum drainage distance. This explains why drainage occurs in this case, as much greater distances than 600 feet. In this instance, Crestone's northernmost well will indeed drain Maverick's leases, which start where my fingers begin. So the 600 feet of drainage, the most drainage will occur in the DSU, but there will still be this drainage into Maverick's leases. That's nature, that's reality. The drainage data that Maverick will show may look different than much of what you've seen before. That's because it is different. The Watkins area has a very different geological history than the rest of the Wattenberg. Because of this, the reservoir in Watkins is much tighter and less porous, and drainage occurs 3 times farther from wells in the Watkins area than it does in the rest of the Wattenberg. If you do not understand that, that's what our witnesses and our experts are for, but I wanted to signpost what our evidence will show. Our witnesses will also show you why Creststone's unique proposal for a single giant DSU for 2 sets of wells will cause dilution. That is well known within the industry that the geologic formation in this area is less productive as you go southeast. Creststone doesn't bother to refute this. Its own evidence confirms it. This means the proposal to split the DSU into an eastern and western DSU stands uncontested. Notably, the State Land Board did not argue against this in its public comment. Creststone, of course, will have its presentation and present its evidence. Creststone will attempt to refute Maverick's evidence, but it will be either irrelevant or unreliable. For example, Creststone will suggest that Maverick can find a surface location northwest of the Aurora Reservoir near the Arapahoe Fairgrounds, the Arapahoe Horse Park, and the Event Center. Aurora's public comments express concern about its groundwater. The proposed locations are on or near land owned by Aurora, under which Aurora's precious groundwater sits. One of Creststone's proposed site is on an intermittent stream. We all heard the public comments regarding Creststone's proposed surface location in this OGDP, which is southeast of the Aurora Reservoir. Creststone is proposing to you that Maverick drill additional wells closer to homes, schools, and Aurora groundwater and streams. Creststone knows the proposed surface sites that it proposes can never get approved for countless reasons. In short, Creststone's proposed solution for violating Maverick's correlative rights and causing waste is for Maverick to drill wells, additional, unnecessary wells, that threaten Aurora's groundwater, nearby surface water, and the people of Aurora. This is a highly technical case. There will be a lot of high-level concepts discussed. Maverick will do its best to help you understand the science. If you understand the science, then you'll see that you cannot approve the DSU without modifying it. The proposed DSU violates your rules in the Act. It would allow Creststone to produce Maverick's oil and gas and other mineral owners' oil and gas without permission or compensation. Again, Maverick's proposed fix is incredibly simple. Enlarge the DSU to include the south half of Section 18 and Maverick's leases, along with the minerals owned by others. This is an additional 80 acres. Second, split the DSU so wells drilled west have a DSU that is separate from the DSU for the wells drilled east. This simple fix solves all Creststone's rule and act violations, protects property rights, protects investment-backed expectations, and maintains sensible oil and gas development in Colorado without the need to drill additional wells in this area. Thank you.
Thank you, Mr. Prescott. We now will hear an opening statement from Mr. Foote on behalf of STAR.
Okay. All right. Thank you very much, Mr. Chair, and good morning, commissioners. Thank you for the opportunity to preview what you're going to hear from Save the Aurora Reservoir, or STAR, during this OGDP proceeding. Just for some background, first of all, STAR is a grassroots, volunteer-led organization that advocates for its Southeast Aurora community against neighborhood oil and gas development. It currently counts about 2,400 members, which is amazing given how it was not even 3 years ago. Creststone describes STAR as an activist group in a pejorative type of way, and wants this commission to give little weight to what actual community members think about Creststone's proposal. In fact, it should be the opposite. STAR has informed and organized neighbors to band together, advocating for what's best for their community in their opinions. They truly represent the public in the commission's charge to protect public health, safety, and welfare. It's difficult to get people involved in community groups in today's world, and a successful example of that should be commended rather than marginalized and attacked, as Creststone will attempt to do. Of course, Crestone has made it a lot easier for thousands of people to gather and speak through STAR by submitting this Sunlight Long OGDP. It's a 32 well megapad that will take 2 years to drill and complete at the doorstep of hundreds of homes. The application falls short on many types of public protections, including noise, wildfire protection, emissions control, evaluating and addressing cumulative impacts, and health standards. Despite hearing over 1,000 negative comments about the location of Sunlight Long and even previous skepticism by subcommissioners during the Louder Ranch CAP proceeding, Crestone has stubbornly insisted to keep the proposed location where it decided way back in the spring of 2024. It even completed a faux alternative location analysis that included 2 per se unpermittable locations in some kind of an effort to confirm what they had decided long ago. STAR asks that the commission deny the Sunlight Long OGDP as currently submitted because its proposed location is not protective. In its place, Crestone should come back with a better, more protective location. STAR's not even asking this commission to deny Sunlight Long forevermore, just to move it. This photo on the right side of the slide was actually taken from Crestone's exhibits. Again, it was introduced by Crestone in an apparent attempt to disparage STAR, but in reality, it sums up a core premise of Senate Bill 181, mission change, and STAR's advocacy in this OGDP pretty simply. Just don't do it near the neighborhood. So going into some of the substantive issues with the OGDP, the first thing I want to highlight is noise. This is because the impacts on the public welfare of excessive noise from oil and gas operations is one of the biggest problems people have to deal with. We know this through the hundreds of noise complaints the ECMC has received even after the implementation of its mission change rules. Crestone says they've modeled the noise impacts of Sunlight Long and local residents have nothing to worry about because Crestone's model says they'll comply with ECMC's noise regulations. But Crestone didn't disclose any of the data associated with the noise sources and sound power ratings from which the modeling was based. There's no way for community members or agencies like the ECMC to double-check Crestone's analysis. Instead, we're all asked just to take Crestone's word for it. And that's hard to do for many reasons, but especially because of the noise experts Crestone has hired and is asking the commission to rely upon. Their response report, labeled Crestone Exhibit A87, just to put it as straightforward as I can, is easily the most over-the-top expert opinion I've ever seen. It goes above and beyond in an effort to deny and attack the ambient noise findings from STAR's noise expert, which in fact, the ambient noise findings from Crestone's expert and STAR's expert are pretty similar. On top of that, the Crestone noise experts don't even address the main point STAR is making throughout its entire noise presentation, which is if you move the thing farther away from people, those people are going to hear less noise. That's one way to protect the public. An out-of-control grasslands wildfire is one of the biggest risks to STAR community from this OGDP. At 3,000 feet away, it would take just minutes on a windy, dry day for a fire to spread to the nearest residence. Yet Crestone's treatment of this issue falls somewhere between indifference and cavalier. They submitted a 3-page document they call a wildland fire mitigation plan and a couple of letters from the Fire Protection District with jurisdiction in this matter. None of the information submitted by Crestone answers some fundamental questions, like what kind of plan does the Bennett-Watkins Fire Protection District have in place? What kind of response time are we expecting from the department? Do they have adequate equipment and training for this kind of event? STAR will tell you they did ask for records from Bennett-Watkins detailing those things. They got back very little in response. It appears Crestone has not bothered asking the same questions, or maybe they did, but they chose not to submit the answers to the commission. Either way, the place where Crestone has chosen to locate Sunlight Long is particularly susceptible to wildfire. It's located on tall Piedmont grasslands, which is the same type of grassland that caused the 2021 Marshall Fire to spread so quickly. It could be built on a much less flammable brush type of landscape if it were located somewhere else, but that's not what Crestone wants to do. And again, Crestone continues to overlook the most obvious answer to the dilemma posed here, which is that the farther you locate the facility away from a neighborhood, the more likely it is to be protective of public health, safety, and welfare. In this case, moving Sunlight Long to a different location farther away could mean the difference between a fire spreading into the neighborhood and one that's contained before it starts burning down homes. Next is cumulative impacts. Frankly, there's not a lot to talk about here because Crestone has done very little to evaluate and address cumulative impacts as required by the Act. It has filed what it describes as a cumulative impacts plan as Exhibit A16, but the plan does nothing to describe how Sunlight Long is going to contribute to the cumulative impacts of all the other oil and gas facilities going in and around the reservoir at the same time, and what they're going to do to try to avoid, minimize, or mitigate those cumulative impacts. Crestone filed a Form 2B, which does the same thing. They restate the BMPs they're planning on putting into place for this OGDP, but that's about it. They declined to further elaborate in their pre-hearing filings or today's opening statement. Instead, you'll hear from STAR about what the cumulative impacts actually looks like to them, the people who are on the ground that will live through this thing. And when combined with the facilities already going in with this one and the other ones planned in the near future, we see years of cumulative impacts to the residents. One way to minimize or mitigate those cumulative impacts on the residents, you may be able to guess by now, is to move Sunlight Long farther away from the neighborhood. Emissions. Emissions from a big 32 well pad are going to pose a problem, regardless of the air quality monitoring program Crestone puts into place. First, we already know, and you'll see examples of dangerous emissions events and leaks still getting through undetected, even assuming an operator's air quality monitoring program is compliant with AQCC's Reg 7. Crestone is not an exception to that rule, as you'll see during STAR's presentation. Second, the only thing an air quality monitoring program does is maybe inform the operator about emissions once they actually occur. They can't put the emissions back into the bottle. So even assuming Crestone complies with the rules, which is far from assured, and even assuming the air quality monitoring program detects an emissions event, bad stuff still gets into the air. Depending on wind direction, it could settle right on top of a densely populated neighborhood just 3,000 feet away from the proposed location. And more evidence continues to show how dangerous these emissions are. The most recent studies, which you'll hear about from an epidemiologist who is testifying for STAR, continue to point towards oil and gas emissions adversely impacting public health. One particular concept you'll hear about during this hearing is called the inverse distance weighted, or IDW concept. It studies the impact of oil and gas operations in two planes, not just one. It looks at how far oil and gas operations are from people, plus the density of those oil and gas operations. So while having a lot of oil and gas wells around where you live can negatively impact your health, and while having oil and gas wells close to where you live can also negatively impact your health, having both a high density and a close location can have an even worse impact on your health. As it happens, that's what we have in this case. Sunlight Long itself will be a 32 well pad put in just 3,000 feet away from people's homes. But on top of that, it is just one of several new oil and gas locations in the area that will be in pre-production around the same time. The people in the nearby neighborhood are getting the worst of both worlds. And this may sound a little redundant at this point, but one of the best ways to minimize and mitigate adverse impacts of emissions is to move the emissions source farther away from people. Another way to reduce emissions, of course, is to commit to full electrification, and Crestone has not done that in this OGDP. The Commission's Lowry Ranch cap order was clear on this point, indicating, quote, Crestone will use electricity to power all operations through the drilling and production phases at all locations within the Lowry Ranch cap. Crestone seems to interpret this as an order to electrify just the drilling and production phases, not completions. At the very least, Crestone should be required to comply with the Commission's cap electrification order. Next, all of the timing restrictions designed to minimize and mitigate ozone and wildlife impacts don't matter if the timeline from which those restrictions originated completely changes. And as you can see from this table, Crestone's timeline for its construction, drilling, and completions has been all over the map. Of course, as time goes on, there are typically adjustments in the timeline for any kind of project. But comparing what Crestone has put out shows much more than the usual adjustments. First, starting at the top of the table, Crestone's third amended application and its notice of completeness that went out to thousands of people were completely at odds. They are 6 to 12 months different in some cases. But then further down the table, we get into the Colorado Parks and Wildlife Consultation Report. That came out on October 2nd of this year. According to the timeline in the CPW consultation, which is important because that forms the basis for CPW judging whether the proposed operations will protect wildlife, Crestone will be constructing the location from September 2026 through January 2027, then drilling from January 27 through August 27, which somewhat overlaps with completions from May 27 through November 27. But then we see a big switch according to the director's recommendation that came out later on in October. It's not clear where the director's recommendation timeline information came from, but assuming it was from Crestone, that's a huge change in less than a month. Finally, we have Crestone's Exhibit A90 at the bottom of the table that was introduced on November the 3rd. Crestone's A90 does throw in the disclaimer that the timeline is, quote, subject to change. Boy, is it ever. Now this timeline is something different than the director's recommendation and also makes some material changes to the CPW consultation report information. Construction starts earlier and drilling and completions in later than what was discussed in the CPW report. For example, under Crestone's newest timeline in Exhibit A90, they will now be engaging in road and pipeline construction between April and September of 26. That conflicts with breeding season of the northern leopard frog, which the CPW indicated in its report was their highest priority related to protecting the frog. It also now directly conflicts with the burrowing owl's nesting season, which was identified in the CPW report as March 15th through August 31st. CPW assumed Crestone would not begin construction on Sunlight Long until September of 26. But CPW's assumption appears to have been overridden by Crestone's latest timeline in Exhibit A90. The same goes for the swift fox denning season, which was identified as March 15th through June 15th. Since Crestone now says it will construct roads and pipelines between the second and third quarter of 26, that timeline now conflicts with the height of the swift fox denning season. As the Commission is aware, an important component of protecting wildlife is avoiding certain activities during certain times of year. But what CPW indicated Crestone would do seems to no longer be valid under Crestone's latest timeline, and that calls the entire CPW consultation report into question. Next, STAR covered Crestone's so-called extensive alternative location analysis quite a bit in its pre-hearing filings. The most obvious way to tell Crestone's alternative location analysis was lacking in substance was seeing how they discussed two locations that would be impossible for them to locate in. The only remaining location, that's Alt 1, showed they could locate further out away from the neighborhood, but they wouldn't be able to access some unspecified amount of minerals within the DSU. Left unsaid by Crestone was the clear provision within the Act that allows some minerals to go unaccessed, if for the purpose of protecting public health, safety, and welfare. Now, Crestone has since disclosed some more information about their alternative location analysis, but that was on November 3rd in its response statement, which was too late for ECMC staff to consider it in the director's recommendation. But Crestone's iterative analysis, or perhaps it was an iterative disclosure of an existing analysis, is still quite minimal. Its latest information discusses why locating the project at Alt 1 would be inconvenient for them, but it fails to analyze any other new potential location that may not have as many difficulties. Basically, what the Commission has in front of it is Crestone's insistence that the proposed Sunlight Long location is the only location possible without anything resembling a rigorous analysis to back that up. This Lowry Ranch area has the benefit of having virtually no surface structures, which makes it even more feasible to find an alternative location away from a neighborhood. In other words, there's space to find something that truly minimizes and mitigates adverse impacts and is more protective of public health, safety, and welfare. It may be more expensive, though, something that Crestone would likely want to avoid. This slide is a bit of a segue because it highlights Crestone's self-characterization of its alternative location analysis, which is actually far from extensive and doesn't do anything to confirm, rather, the original location is protective in the first place. All it does is show Crestone was not very interested in doing a real alternative location analysis, and on the other hand, it remains completely insistent that its proposed location is the only place where they can put Sunlight Long. But the bigger picture of this quote and the ones that follow is Crestone's credibility. Crestone makes a lot of assertions throughout this application accompanied by a whole lot of exhibits, but in the end, they depend on the commission taking their word for it. Like the noise issue I highlighted at the beginning of this opening statement, where they didn't provide data to back up their modeling. In many places, Crestone requires leaps of faith, and leaps of faith aren't very comforting to the people who will actually deal with the consequences of something going wrong. Here's another example. Crestone said in its pre-hearing statement that CDPHE commended Crestone for all of Crestone's proposed best management practices. That doesn't appear anywhere in the CDPHE consultation document. The CDPHE consultation says nothing about a commendation of Crestone's best management practices. Here, Crestone is trying to accuse STAR of undermining and ignoring the order from the Lowry Ranch CAP. On the contrary, STAR stipulated to the CAP order in the statement of facts early on in this process and believes the order speaks for itself. STAR never asked the commission not to follow or ignore its CAP order, particularly when it comes to the issue of electrification. So it's difficult to figure out exactly where this accusation is coming from, just that it's not true. Here it says Crestone can state with certainty that the Sunlight Long OGDP is an approvable application, is compliant with the Act, ECMC rules, and Arapahoe County regulations, and is protective. Given the issues you've already heard from the public and the issues we'll be discussing during this hearing, Crestone being able to state their application is compliant is far from certain. But most importantly, that's not their determination to make anyway. That's the commission's job. The commission is the body that determines whether it's protective, not whether Crestone feels it is certain that it is. Next, Crestone claims STAR is attempting to force the ECMC and the commissioners into making explicit determinations on the various health studies relating to oil and gas development near residences. This, like so many of Crestone's pre-hearing filing statements, is not cited, and it's not cited for a good reason. STAR never asked for that in its filings. You're going to hear about recent epidemiology studies that, among other information brought forward by STAR, will currently show the currently proposed location is not protective. STAR is not asking the commission for a definitive finding on each of the studies presented to it, but instead to evaluate the information found in the studies, among other information, to paint a clear picture that the Sunlight Long OGDP is not protective. Next, we see a claim that STAR attempts to persuade this commission that Crestone did not submit an air quality mitigation plan with the state Sunlight Long OGDP, and that in and of itself should result in a denial of the OGDP. That's not anywhere in STAR's pre-hearing filings, and it's not what you'll hear from STAR in this proceeding. Instead, STAR wrote, a review of the AQM plan raises additional concerns about the impact this proposed development could have on nearby residents, and then went into further details. Again, some of these quotes are not among the biggest issues the commission will have to sort through during their deliberations. But when an applicant has the burden to prove its application is protective, and it can't accurately depict how others are saying it's not protective, that should give the commission pause. Here's another one, and I'll wrap up the comparisons after this one. STAR ultimately concedes that Crestone's noise mitigation plan meets the ECMC Rule 423 requirements. But nowhere in STAR's pre-hearing filings did we indicate that. In fact, as I said earlier, there's no way STAR or the commission for that matter could know Crestone will actually comply with Rule 423 because it never disclosed its modeling data or assumptions. Its approach has been to put the model out there and say the model shows compliance, therefore take our word for it, we'll comply. But that shouldn't be good enough for this commission, and it doesn't meet Crestone's burden. The commission is familiar with the Act and the ECMC rules, but Rule 301 is up here as a quick reminder that the standard by which the commission judges an application is whether it's protective or not. If it's protective, it may be approved. If not, it can't be. Another example of this is Rule 307, which governs the approval or denial of OGDPs. That rule says the commission may approve an OGDP that, quote, complies with all requirements of the commission's rules and protects and minimizes adverse impacts. So the commission is aware this is not a check-a-box type of exercise, even though Crestone tries to make it sound that way. The application must meet the rules and it must be protective. It must meet the Act. It must, at the end of the day, minimize adverse impacts as evaluated by the unique circumstances of that particular OGDP. And in this case, the Sunlight Long OGDP is not protective because it is simply too close to a densely populated neighborhood. It needs a different location. Star is asking this commission to either deny the OGDP outright or order Crestone to locate Sunlight Long in a different spot. Thank you very much, Mr. Chair.
Thank you very much, Mr. Foote, for the opening statement. Let's take a few minutes for a quick break and return at 11:50. And at that point in time, we will start with the presentation of case in chief by Crestone. Just if you want to go ahead and get your slides up and running. Looks like
Great,
we
thank
have
you,
all the
Chair.
commissioners are here. So we're back on docket 2412-00313, Thursday, the 20th of November, and it is 11:51. We will now reinitiate with the case in chief by Crestone.
Great, thank you, Chair. Prior to starting our time, I do have a procedural question, if I may. Okay, so we have our presentation broken down into 3 parts. We have it in the OGDP background, OGDP cumulative impacts, and the drilling and spacing unit application. For purposes of efficiency and time management, would it make sense to allow our witnesses to present each individual part and then allow for cross commissioner questions at the end of each part instead of immediately after each witness, because we do have a couple that will go back and forth? We think this might help better with the flow of information for everyone involved and would also help for time management of all parties as well as the commissioners for any breaks that might be necessary.
Fine with me. Mr. Foote, Mr. Prescott, do you guys have any concerns about approaching it in that fashion?
I don't have any issues with that. Thank you.
I guess I'm not totally clear what we're talking about. So it's broken up into 3 tranches, and then we cross at the end of tranche 1, tranche 2, tranche 3 of what was covered in those tranches.
Yes, Mr. Foote, that's what I'm proposing.
Okay. Well, no objection.
All right, let's approach it that way.
Wonderful. Thank you, Chair. All right, if Mr. Dan Harrington can join me on screen. All right, good morning, Mr. Harrington. Can you please state your full name and business address for the record?
Yes, my name is Dan Harrington. I am an employee of Civitas Resources at 555 17th Street in Denver.
Okay, and what is your title?
Asset Development Manager,
Okay, and how long have you been in your current role at Civitas?
approximately 4 years.
Okay, and where did you attend school and what degrees do you possess?
I attended school. I have a bachelor's from Amherst College and a master's from the University of Texas in Austin in geosciences.
And are you familiar with Crestone's approved Lyon Ranch Comprehensive Area Plan as well as the state Sunlight Long OGDP application up for hearing today?
I'm very familiar.
Okay, thank you. Will you please present your first portion of your testimony today to the commissioners?
Yes, thank you. Good morning, commissioners, and thank you for allowing us to present our state Sunlight Long OGDP today. This is an overview of the OGDP. We're proposing a 32-well oil and gas site in southern Arapahoe County on state land in Lowry Ranch. That pad site will be tankless with full oil, gas, and water takeaway, and will be electrified for the drilling and production phases. Additionally, this OGDP includes an existing oil and gas location that will be used for produced water offloading up near Quincy Avenue. The OGDP contemplates development of 2 DSUs and a single pad occupation. The site was approved by Arapahoe County under the revised oil and gas regulations in May 2025. The site has been reviewed by CDPHE and CPW, who provided feedback that we incorporated into the plan. This is the 4th of 7 Lowry Ranch CAP sites we brought before you. As stated, we're proposing 2 DSUs, 16 wells each for the development of the Niobrara Formation. We're planning to drill 8 wells in each DSU in each direction. Consolidation of operations to a single site for both DSUs is efficient in terms of land use as well as operations time frame, and allows for a site that is fully compliant with both county and state siting regulations. There are a limited number of legacy wells within the OGDP. On the east side, there's a single producing horizontal well and several producing vertical wells operated by another operator, and we'll work with that operator during development to prepare those wells. There are also some offsetting Civitas-controlled horizontals to the north. These were just drilled and are anticipated to produce through operations at Sunlight Long. And there are also a handful of legacy vertical P&A wells, which will be evaluated as part of the OWE process. Please see here our proposed operational timeframe. We plan to begin pipeline and road construction in early 2026, pad construction in later 2026, with drilling in mid-2027, again to be completed in a single rig occupation. We are also planning to conduct partial simultaneous operations between drilling and completions to shorten the overall operational duration. The site will go into production in early 2028 and is anticipated to produce for 20 plus years. I would like to note that road construction needs to be complete prior to pad construction, which is a significant part of the longer construction operational duration here. To address Mr. Foot's opening slide about changes to our schedule, it is correct as he noted that operational changes are common in our industry, and they're often driven by externalities such as regulatory timelines, which is why we always note subject to change. It's true that our operational timeline changed significantly after our third amended application for State Sunlight Long, and that's in part due to the OGDP approval timeline as influenced by the very petitions we're addressing here today. Regardless of what was submitted with the original OGDP application, we remain committed to our wildlife-driven timing COAs, and we consult with CPW on an ongoing basis regarding our plans. Next, I'd like to review some of the siting factors. We have no RBUs within 2,000 feet, and in fact, the closest RBU is nearly 3,200 feet from the pad, which is compliant with a county setback of 3,000 feet. We have no schools, childcare centers, HOBUs, or state DOAA within a mile. We are not in a DIC, and the pad is not an HBH. Approximately 1.3 miles of existing access road near Quincy Avenue is within Mule Deer HBH, and that access road does need to be improved. We've consulted the CPW on this road segment and will prioritize road improvement outside of mule deer wintering season. CDPHE has reviewed and supports our proposed BMPs as means to remain protective of public health, air, and water resources. Next, I'd like to discuss pad visibility. Part of the driver in choosing this site is the existence of a significant ridge with roughly 90 feet of relief above the graded pad surface. That ridge will aid in both visual and sound mitigation for this site. Our surveyors conducted a photo rendering of what operations will look like from the west at the edge of Lowry Ranch. At the top here, you can see a rendering of the drilling rig. As you can see, the derrick is anticipated to be visible above the ridge, but the base of the rig is not. And below, you see a rendering of the site during the production phase. And as you can see, no equipment or facilities will be visible. We also conducted a drone flight to help demonstrate the lay of the land. And Mr. Hannibal, switch over. Thank you. Here we're starting at the western edge of Lowry Ranch facing south. The drone is turning east here to face into the ranch. It's going to start flying. It's going up approximately 60 feet to crest the ridge here. You can track the position of the drone on this topo map in the bottom left. It's good orientation technique. As we get up over the ridge, you can see the power lines along the existing north-south access road. That's the road that will be improved in order to access the site. And as you can see, the site we're seeing is a relatively low point in the surrounding topography. Again, about 90 feet below the ridge line. You can also see Black Shack Creek to the southeast, which we'll talk about later. And in a moment here, we'll see a short rendering of the short access road and the Sunlight Long site itself. There we go. And with that, I'll turn the presentation over to Mr. Nathan Bennett to discuss the alternative locations we considered.
Wonderful. Thank you, Mr. Harrington. Mr. Bennett, can you please join us on screen? Thank you. I see you. Can you please state your full name and business address for the record?
Good morning. Nathan Bennett, 555 17th Street, Suite 3700, Denver, Colorado.
Okay. And who is your employer and what is your title?
I'm employed by Civitas Resources. My job title is Director of Permitting and Compliance.
And how long have you been in your current role at Civitas?
About 3.5 years.
And where did you attend school and what degrees do you possess?
I have a Bachelor of Arts from St. Bonaventure University and a Master's of Science from Shippensburg University.
Great. And are you familiar with Creststone's approved Lowry Ranch Comprehensive Area Plan as well as Creststone State Sunlight Long Oil and Gas Development Plan up for hearing today?
Yes.
Thank you. Will you please present your first portion of your testimony to the commissioners?
Thank you, Ms. Jost. Good afternoon, commissioners. I would like to take a few minutes to review the Alternative Location Analysis, or ALA, that was conducted for the State Sunlight Long location. A voluntary ALA was conducted to address perceived concerns stemming from the siting of the proposed oil and gas location. This ALA is considered voluntary as the proposed location does not trigger any Rule 604B2B criteria. 3 alternatives, including AL1, proposed by the petitioners, Save the Aurora Reservoir, were analyzed. Due to technical challenges associated with drilling and completions operations, 2 of the alternative locations, AL1 and AL3, would not fully develop the proposed mineral development area, thereby requiring an additional location to realize full development. Arapahoe County's Land Development Code for oil and gas facilities establishes strict siting criteria relative to public water reservoir setbacks. Notably, these setbacks apply to, quote, existing or planned public water reservoirs with a capacity of 100 acre-feet or more, and used or to be used for a potable water supply, end quote. As has been mentioned previously, proposals have been put forth that contemplate future catchments, which meet these criteria, thereby eliminating 2 of the alternative locations, AL2 and AL3, due to the aforementioned criteria. The county also mandates a 1,000-foot setback from the edge of a riparian area unless an exemption is approved. However, the Land Development Code expressly states, and I quote, "In no case may the setback be reduced below 500 feet," end quote. This provision eliminates the viability of AL number 3 as wetlands were identified at distances less than 500 feet on the northwestern and eastern extents of the alternative location. Additional variables taken into consideration during the ALA include, but are not limited to, Rule 411 buffer requirements associated with the existing Aurora Reservoir, access considerations relative to terrain, hydrology, and wildlife, and past, present, and future land uses within Lowry Ranch. It is important to note that the 26,000-acre ranch has a colorful history. As many know, the ranch is part of a former Department of Defense military installation that served a key role in training artillery and air crews for overseas conflicts, beginning with the onset of World War II through the resolution of the Vietnam War. Oil and gas development is not new to Lowry Ranch, as portions of the ranch were drilled in the 1920s. Present-day uses include agricultural grazing, recreation, various forms of mineral extraction, and renewable energy projects, among others. The revenues generated from these uses flow to Colorado's public schools. According to the State Land Board's website, this lease, which includes site-specific stewardship requirements and stipulations, has generated more than $200 million through bonus and royalty payments. I would like to take a few minutes to focus on AL number 1, which was the alternative proposed by external stakeholders. As a reminder, the original Comprehensive Area Plan application proposed a total of 3 locations along the western extent of Lowry Ranch: State Sunlight, State Long, and Beaver. Mr. Harrington will review the evolution of these changes in later slides. I note this evolution to underscore the constraints identified when analyzing the potential for AL number 1 as a substitute for the proposed Sunlight Long location. By consolidating and/or eliminating locations, it is necessary to ensure the result will still achieve prudent reservoir development. A robust technical feasibility analysis was completed by our drilling and completions team to assess whether the alternative development was possible. Due to the extended step-outs and resulting wellbore geometries necessary to realize full development, our technical team concluded that AL number 1 was not technically feasible and therefore would require a total of 2 locations to reach that goal. 3 other issues were identified during the analysis of AL1 that ultimately rendered this a non-viable location. The access road necessary to get to AL1 would conceivably require crossing previously designated non-surface occupancy areas within Lowry Ranch, the crossing of either Black Shack Creek or Coal Creek, both of which have been identified as having important roles in known wildlife populations. or improving existing access along drainages. Similarly, pipeline routing and construction would be required in and through designated no surface occupancy areas within the ranch, as well as a pipeline crossing of Coal Creek that would also be required. Lastly, our comprehensive biological analysis and monitoring that has occurred since 2012 has documented a swift fox population proximal to AL number 1. A new disturbance at this location could disrupt the habits and tendencies of this skulk. Given the demonstration discussed herein, alternative location number 1 was determined to not be a viable alternative for the proposed Sunlight Long pad. I will now turn the presentation over to Mr. Harrington.
Thank you, Mr. Bennett. Mr. Harrington, can you pick up on your second portion of your testimony?
Thank you, Mr. Bennett and Ms. Jost. Here, I would like to address our transportation plans for produced water. Originally, we planned to truck produced water away from the site, and after feedback from ECMC and from CDPHE, we developed a plan for full 3-phase fluid takeaway. As you're aware, there are no commercial water disposal facilities in Arapahoe County, and the construction of 20+ miles of produced water line to Weld County would be operationally infeasible, as discussed during other OGDP hearings. Our solution here is to pipe produced water from the state Sunlight Long site to an existing oil and gas location to the northeast, sited along Quincy Avenue. Produced water pipeline will be installed in the same trench as the oil and gas pipelines, here marked in black, and generally following the access road except for the last mile south of Quincy. From the offloading site, water will be hauled away eastward towards Watkins Road and I-70. It's important to note that this plan will ensure that no produced water hauling will occur along the access road, and no oil field traffic will go westward near any Aurora neighborhood. I'd like to cover the potential UXO, or unexploded ordnance, at Lowry Ranch. As Mr. Bennett noted, parts of Lowry Ranch were used during the Cold War as a bombing and gunnery range, and the state Sunlight Long site does overlap the area where there is potential for UXO to be found. Construction here requires support from expert UXO detection and mitigation consultants. It's important to note that similar support methods have been conducted along with other construction in the area, including residential development to the south and to the west. Inactive munitions have been found and they've been safely removed. A UXO plan has been developed, and that plan has been reviewed with CDPHE. It incorporates detection methods, both geophysical and mechanical, and protocols for dealing safely with anything found. UXO clearance within our construction areas constitutes a benefit to Lowry Ranch, as the state will ultimately have to clear less land. Next, I'd like to move into stakeholder engagement. First, any site on state land requires extensive review with the State Land Board. We visited the state Sunlight Long with State Land Board staff, including surface and wildlife experts, on numerous occasions. As you can see here, we have an excerpt from our original siting approval letter in April 2024, along with the final executed SUA from October 2025 on the right. We'd like to reference briefly the letter submitted by the Colorado State Land Board to the ECMC earlier this week and as read into the record yesterday. In that letter, the State Land Board summarized stewardship and responsibilities associated with state lands and the long history of oil and gas operations on the ranch. As summarized, the Lowry lease itself has built-in protective requirements. The State Land Board went on to describe their criteria for evaluating SUA requests, including the tier map, consultation with other Lowry lessees, wildlife assessments, both by internal SLB experts as well as CPW, consultation with other regulators, and numerous site visits of alternative sites as well as the final proposed site. The State Land Board takes its leases and stewardship of Lowry Ranch very seriously, and we're happy to have met their siting criteria and secured the state Sunlight Long SUA. Lastly, I'd like to refer specifically to the surface use allowance under Lowry lease, which is 650 acres, here weighted as referenced in the letter. Due to Creststone's efforts to consolidate our pads and reduce surface impacts on Lowry Ranch, we anticipate using only roughly half of that allowance on a tier-adjusted basis. These pads are extremely efficient in terms of mineral acres developed per pad, which is important to preserving the land. Next, I'd like to touch on some additional stakeholders. Two key stakeholders in this area include the controllers of the water systems. Rangeview Metro District controls certain water rights on Lowry Ranch itself. We reviewed the state sunlight long pad, road, and pipeline corridor with Rangeview, who indicated no opposition to our plans. They have requested some additional water and soil sampling data, which we've agreed to provide. Further, we consulted with Aurora Water, who control Aurora Reservoir. You've already heard Aurora's comments on the state sunlight long site. Aurora Water analyzed in particular our proposed road and pipeline route. Here on the right, in a letter to Arapahoe County, Aurora Water notes that the road and pipeline corridor maintains a minimum 1,000-foot setback from Aurora Reservoir and that it remains down gradient and primarily on the opposite side of the ridge from the reservoir. Aurora Water concluded that they are agreeable to this plan. Arapahoe County is the relevant local government at the state sunlight long site. It's important to note that the county's review process is exacting. From our original pre-application through our neighborhood meeting to the county's public comment process to final approval was a 20-month timeframe. The comment letter submitted to the ECMC from Arapahoe County yesterday summarizes that review process well, and we appreciate those comments. We'll go into further detail on the county's approval in a few slides. While there are no proximate local governments for this site, we also consulted early and often with the City of Aurora, including the Energy and Environment Division, Aurora Water, and other officials. We'd like to thank Aurora staff for their analysis and collaboration on this project, and in particular for their comment letter provided to the Commission earlier this week, in which Aurora confirms that the Sunlight Long site poses no risk to the Aurora Reservoir, aquifers, or the water supply, no risk to the Aurora Reservoir Dam, and no risk of seismicity. All right, this is a busy slide, and I'd like to spend a little bit of time on it. This covers the site evolution of the state sunlight long and state long pad sites. They've both changed multiple times. Our initial sightings from early 2022 for sunlight and long are marked here with ones. Red is sunlight and blue is long. As you can see, the original sunlight site was about 1 mile north, significantly closer to Aurora Reservoir, and the original long site was west, closer to the Aurora neighborhoods. In early 2023, Civitas heard early feedback on these sightings and modified each to the sites marked in 2 to improve setbacks relative to the reservoir and the neighborhood. Next, Arapahoe County entered its 2023 rulemaking, I believe it was the second quarter, which, among other things, established setbacks of 3,000 feet from RBUs, 3,000 feet from reservoirs with demonstration of topographic isolation, and 1 mile from reservoirs without topographic isolation. Reservoir setbacks apply to both existing and planned reservoirs. As a result of this rulemaking, both sites too had to change. Long moved further east, and Sunlight moved southwest, first to Site 3, and then to the final siting as the Arapahoe County rulemaking finalized. As part of this evolution, the 2 sites merged, which is why we're proposing the hyphenate Sunlight Long site here today. I'd like the Commission in particular to note the overall movement of the Sunlight site. Over the course of its evolution, it moved about 1 mile south. If we could jump briefly back to slide 4, I'd appreciate it. Thank you. The original Sunlight site was here in central section 22, again, about 1 mile north of where it is now. That site was originally intended to develop the south half of sections 1718, which is the area in which Maverick holds its leases and at issue in their petition. It was the southern movement of the Sunlight pad that put those lands west of the Aurora Reservoir out of the reach of our well bores and led us to excluding those lands from the Lowry Ranch Cap and the Sunlight Long OGDP. I'd like to reinforce here that the root of the exclusion is compliance with Arapahoe County pad siting requirements. We go back. Thank you, sir. Next, I'd like to cover ultimate Arapahoe County compliance. This is what the resultant setbacks look like from the combined Sunlight Long site. We are 3,074 feet from the DA to the nearest RBU to the west, 3,220 feet from Aurora Reservoir, and more than 1 mile from planned Reservoir B to the northeast. The establishment of these setbacks was a key component to Arapahoe County's permit review and did lead to their approval. As part of that approval process, we provided detailed setback and topographic maps to the county. A key point here is topographic isolation of the pad from Aurora Reservoir, necessary to allow for the 3,000-foot setback. Again, the ridgeline is key as it lies between the Sunlight Long site and Aurora Reservoir. We also brought in an external hydrogeologist who noted that the Sunlight Long site and Aurora Reservoir are in separate sub-watersheds bounded by this yellow line in the lower right. And you did see the city of Aurora's analysis of the same, which looks very much like this hydrogeologist map. And lastly, we'll note that the state Sunlight Long site greatly exceeds the ECMC reservoir setback of 1,000 feet. Next, we'd like to go through Arapahoe County's approved USR permit. I'd like to highlight the incredibly detailed work the county staff conducted in their analysis of this project. Here we're including excerpts from the Arapahoe County approval letter, which is dated May 2025 and which was referenced in their comment letter submitted yesterday. You'll note numerous findings of fact, and in particular how the county enumerated each pertinent regulation and how the state Sunlight Long site specifically matched each. These include residential setbacks, floodplain and riparian area setbacks, and reservoir setbacks. And here, compliance with requirements around site design, tankage, air quality and groundwater monitoring, noise and odor mitigation, access road standards, lighting and visual mitigations, traffic, and wildlife protections. Of note, and this is our highlight in the lower right, the county also noted areas where the state Sunlight Long site exceeds county requirements, including being over 1 mile from the nearest school, being completely tankless and utilizing a reduced number of separators, which improves emissions and site footprint, the piping of produced oil, gas, and water from the site, improving traffic, installing a full wrap sound wall, despite modeling showing it isn't strictly necessary, compliance with 2023 and late 2024 Arapahoe rules, despite being submitted prior to their adoption, continuous air monitoring for the life of the wells, exceeding the county's 3-year requirement, reduction of pad size and well count during the consolidation of the Sunlight and Long sites, a single pad occupation for the drilling rig, and our plans to abandon development of the Beaver site to the south. The county also included certain conditions of approval. I'd like to highlight in particular number 11. There seems to be some misconception that the county has provided a waiver for electrification of the drilling rig. I want to note here that Crestone is fully committed to rig electrification at this site and is well along in the Excel process to permit and construct line connections. As you can see in number 11, the county included a clear COA that the site be electrified prior to drilling, and this, of course, matches Crestone's obligation in the Lowry Ranch cap, as well as the BMP's proposed with this OGDP. Next, I'd like to go over Bennett Watkins Fire emergency response comments in their will serve letter. We engaged Bennett Watkins Fire early and shared our site design and fire mitigation plans with them. Here, in a letter dated February 2025, Bennett Watkins outlined their review of our site. And off to the right, you can see the will serve letter, which is signed by Bennett Watkins staff, and it is an important prerequisite to county approval. Lastly, I'd like to summarize our community outreach over the life of the project. To date, we've seen a county community meeting in February 2024, a town hall. That's the images you see to the left. A Lowry Ranch CAP community meeting in April 2024. The Sunlight Long OGDP conducted by the commission, 511 hearing conducted by the commission in September 2025. Extended public comment periods for the Lowry Ranch CAP, Sunlight Long OGDP, as well as county process. Civitas replied to over 800 public comments as part of this process. While the majority of these were negative and some were repetitive, it's important to note that 800 individuals represent at most about 3.5% of the individuals in the neighborhoods proximate to Sunlight Long. And that assumes all commenters are local, which we know isn't the case. Finally, I'd like to address the narrative that Crestone hasn't been responsive to stakeholder feedback. As you saw a few slides ago, this site has evolved markedly over the past 3 years in response to concerns. We've moved the sites to improve setbacks from RBUs and reservoirs, first voluntarily and then in reaction to county rules. We've added produced water takeaway and gone tankless, guaranteed rig electrification, modified our access road and pipelines, and even eliminated one whole site and reduced total well count by 20% from the original 40 well plan. We appreciate the feedback and the fact that we now have a more protected location, and the STAR membership in particular should be proud of its influence on this project.
Thank you, Mr. Harrington. Mr. Bennett, would you like to come on and take over your second portion of your testimony?
Thank you, Ms. Jost. The upcoming slides are intended to provide an overview of the best management practices, mitigation measures, and conditions of approval that will apply to the proposed Sunlight Long location. When applicable, the practices employed will be structured relative to the mitigation hierarchy as a demonstration of the commitments Crestone has made for this project. We believe the state Sunlight Long OGDP and the associated BMPs comply with the Act and meet all ECMC rule requirements. This belief is supported by the director's recommendation, which states in part, quote, "This OGDP complies with all applicable requirements of the Commission's rules," end quote, and goes on to recommend conditional approval. Colorado Parks and Wildlife supports approval of this OGDP, having consulted with Crestone on this location and associated projects over the course of several years. Colorado Department of Public Health and Environment supports approval of this OGDP, having consulted with Crestone on this location and associated projects over the course of several years. Importantly, the state Sunlight Long OGDP has an EnviroScreen percentile score of 14.69%, which, to the best of my knowledge, is one of the lowest EnviroScreen scores achieved to date. The Environmental Justice Summary confirms that the proposed location is not located in a disproportionately impacted community. The BMPs that will be discussed and applied to the state Sunlight Long location, however, were incorporated in the project as if the location is in a disproportionately impacted community. Such incorporation is a result of Crestone's commitments to the protection of public health, safety, welfare, the environment, and wildlife resources, and is also a result of substantial community input during the local and state permitting processes. Three important distinctions were contained in the director's recommendation, which are worthy of reiterating. One, confirmation that none of the Rule 604B siting conditions apply in this OGDP. Two, the closest residential building unit is located approximately 3,188 feet to the west of the proposed location. And three, the proposed location is not located in CPW designated high priority habitat. Crestone has committed to several BMPs aimed at avoiding, minimizing, and mitigating potential impacts to air resources. From an avoidance perspective, Sunlight Long will be a tankless location, thereby eliminating emissions associated with on-site tanks used to store oil and water. Drilling operations will use grid power, thereby eliminating emissions associated with other forms of power generation. Many of the other BMPs that are listed focus on reduction strategies centered around the generation and transport of fugitive dust. Produced water will be piped from location in a dedicated pipeline, and the production facility will also utilize grid power. Crestone will employ full life cycle air quality monitoring beginning before commencement of drilling activities at the location and continuing until the last well is plugged and abandoned. This commitment far exceeds any state or local regulation applicable to state Sunlight Long. The monitoring will be performed using 4 continuous monitors and SUMA canisters. If triggered, SUMA canister analyses will include speciation analysis of volatile organic compounds, including benzene, toluene, and xylenes. The continuous monitors will monitor for and identify 7 pollutants, including total VOCs, methane, and ethane, if present. Crestone understands and appreciates the concerns voiced by stakeholders throughout this process and would like to take this opportunity to review those practices that will be implemented during the development of Sunlight Long. There are 5 key avoidance measures that have been and will be employed. The proposed location is more than 3,000 feet east of the nearest residential building unit. The proposed location is more than 5,280 feet east of the nearest high occupancy building unit, child care center, or state designated outdoor activity area. Non-essential traffic will be restricted between the hours of 7 to 9 a.m. and 4 to 6 p.m. Fresh water will be transported by temporary water line, while produced water will be transported by a dedicated produced water pipeline. Mitigation measures include the use of a full wrap 32-foot tall sound wall during the drilling and completion phases to aid in sound attenuation. Additionally, required lighting will be affixed to the interior sound walls and angled downward, to mitigate light spillage. It is important to note that certain lighting is required on the drilling derrick, which extends above the top of the sound walls. This lighting serves two distinct purposes. One, provides safe illumination for those working on the drilling rig and working in the drilling derrick. And two, ensures that the derrick is visible to overhead air traffic associated with Buckley Space Force Base, the Colorado Air and Spaceport, Denver International Airport, and other regional airstrips. There are a number of best practices related to soil and water resources that will be incorporated throughout the development project. The implementation of diversion berms will avoid any changes in the existing flow direction of stormwater or other surface flows. The relocation of the access road and pipeline corridor eastward away from Aurora Reservoir will minimize, if not eliminate, the potential for impacts to the water body from erosion and sedimentation. A more detailed and thorough review of the wildlife best practices will be provided later in the presentation. However, I would like to take this opportunity to briefly stress our commitments to wildlife resources. The proposed location is outside designated high priority habitat, and avian surveys will be conducted to avoid conflicts with nesting migratory birds. As a refresher, State Sunlight Long is subject to several conditions of approval contained within the approved Lowry cap. These are included on the Form 2A submitted as part of this OGDP. Crestone reaffirms that three-phase pipeline will be constructed and commissioned prior to first production. Importantly, Crestone will use utility grid power for the drilling and production phases at the proposed location. Contracts have been signed with the utility company, and the permitting necessary to electrify the location is underway. There has been considerable dialogue focusing on the potential for wildfires resulting from the proposed Sunlight Long oil and gas operations. Much of the rhetoric on this topic appears to be mis- or partially informed. For example, ECMC 600 series rules establish safety requirements for facilities and operations which include fire protection. While the regurgitation of the Commission's rules may not be warranted, these requirements include adhering to industry standards and practices from leading authorities like the National Fire Protection Association and prescribed standards like the National Electric Code. From a company standpoint, not only does Crestone comply with these rules, we've developed and employ best practices and procedures to ensure our operations are done safely and, most importantly, in a manner that protects our neighbors and communities from harm. Crestone's emergency management team consists of subject matter experts with education and training necessary to respond to an incident. We are extremely proud of our relationships with local first responders, especially Bennett Watkins Fire Rescue. We are regularly engaged with these agencies in training exercises and tabletop drills. Crestone has made investments with local first responders to ensure preparedness in the unlikely event fire suppression services are needed. The investments include donations for equipment purposes, donations of actual oil field equipment for use in hands-on training, as well as educational roundtables to share learnings and further collaboration between organizations. Key Crestone safety personnel receive training and education in relevant fire mitigation principles, including instruction from the National Wildfire Coordinating Group on wildland fire behavior. Field employees receive annual training on wildfire protection using FEMA and National Interagency Fire Center course materials. One of the tenets of the Wildland Fire Mitigation Plan is the implementation of defensible space. The FireWise program is a cooperative endeavor between the National Fire Protection Association and the U.S. Forest Service. This program has been adopted by the Colorado Forest Service as a mechanism to minimize fire intensity and its ability to spread by reducing the fuels needed for a fire to continue to grow. The use of defensible space in the context of an oil and gas location means that vegetation adjacent to the improved surface of the well pad will be managed in accordance with Forest Service guidelines. Once in production, the working pad surface will be approximately 273,500 square feet of non-flammable aggregate, rimmed by at least 30 feet of defensible space as a best practice to eliminate the likelihood of a wildland fire being started as a result of Crestone's operations. STAR has called into question the qualifications of Bennett Watkins Fire District personnel. This is an unfounded attack on the highly professional and well-trained firefighters and support staff of Bennett Watkins Fire. This training and professional readiness includes the ability to respond to hazardous materials incidents, wildland fires, industrial emergencies, including oil and gas emergencies, and residential structure fires. The fire district holds all oil and gas operators, including Crestone, to very high standards during the development process with consistency and without bias. Operators are required to address planned site operations and ensure that wildfire risk is appropriately evaluated and mitigated accordingly. Further, it has been our experience that Bennett Watkins Fire only issues approvals or permits for locations that comply with all applicable district requirements that adequately address development standards, public safety requirements, and wildland interface risk. While there is a recognition that oil and gas activities do present some wildfire ignition risk, there are other sources of ignition on and adjacent to Lowry Ranch, which already exist and are also commonplace. These include power transmission lines, lightning, arson, vehicle operations, be it for ranching, hunting, or renegade ATV usage, the use of illegal fireworks or similar incendiary devices, and other human recreational activities. All of these activities have resulted in wildland fire ignitions on or immediately adjacent to Lowry Ranch throughout time. Crestone has confirmed that the professional firefighters from Bennett Watkins Fire, along with regional partners, stand ready to respond to wildfire incidents on Lowry Ranch no matter what the source of ignition is. These first responders train, prepare, and respond to wildfire incidents routinely and share excellent working relationships with neighbor agencies, including Arapahoe County Office of Emergency Management, Aurora Fire Rescue, Rattlesnake Fire Rescue, South Metro Fire, Buckley Space Force Base, Sable Altura, Stroudsburg, Byers, and Deer Trail Fire Districts. A copy of the Wildland Fire Mitigation Plan submitted to and approved by Arapahoe County is shown on this slide. This plan codifies and outlines the preventative steps Crestone will employ to reduce the risk of wildland fire resulting from potential future operations. I will now turn the presentation back to Ms. Jost.
Wonderful. Thank you, Mr. Bennett. Chair, this is kind of our first tranche. If we think this would be a good point to maybe allow for cross-examination or commissioner questions to Mr. Bennett and Mr. Harrington on their portion of this presentation.
Okay. We also need to take a break at some point for a short lunch. Why don't we try to get through cross-examination by Mr. Prescott and Foote, and then maybe take a break, and then we'll come back and have commissioners with questions. Mr. Prescott, any cross?
This will be quick. I may touch on a couple of these slides, but it really won't make sense until we get into some additional testimony and slides. So I'm going to preserve my cross right now, and I don't have anything to ask.
Okay, Mr. Foote?
Yeah, thank you, Mr. Chair. Let's see. Let's start with Mr. Harrington, slide 22. If you could turn over to slide 22. Okay. Mr. Harrington, I noted from your testimony that you indicated timelines change. And I think one of the explanations you gave is because sometimes there's a regulatory delay or regulatory issue. Is that right?
That's correct.
Okay. And in this case, you're aware that this hearing was originally scheduled for October the 29th. Is that correct?
That's correct.
And now it started on November the 19th. So that was like a 3-week delay, correct?
That's correct.
Okay. So did you not build any time into the schedule for a 3-week regulatory delay?
From initial submittal to even the original hearing date was a pretty long delay, which I don't have at my fingertips, but I can pull up as well. So it's not simply the petition delay, but the overall time to get to hearing that kind of ran a little longer than what we anticipated in our original submittal.
How many OGDPs did you submitted prior to this one to the commission?
At Lowry Ranch, 2.
And how many OGDPs in general from Crestone to this commission prior to this one?
Dozens.
Okay. And you still didn't have a very good sense of what kind of timeline you'd be looking at for, I guess, for lack of a better term, regulatory delay?
In our experience, it's pretty variable. We have averages, and we can try to guess what the duration will be. But we know commission staff has other obligations. We know that some sites are more complicated than others. This was one of the longer ones.
And some of that was because your initial application that you turned in, was back in December of last year, right?
I believe that is correct.
And staff came back two separate times saying that you needed to turn in more information because your first and second amended applications were not complete.
That's very typical. I think that happens with literally every OGDP.
Okay, so not unusual, something you would typically build into your timeline from submission to approval.
That's correct. Not necessarily two, but
Okay. And you would agree then the CPW report, the consultation CPW report was turned into the commission at the beginning of October. Does that sound right to you?
I don't think I have that at my fingertips. That sounds right, though, if you say
Okay.
so.
And does it sound right to you that the CPW consultation report indicated that, at least it was their understanding, that construction of the site would begin in September of 2026? Does that sound right to you?
That's correct.
Okay. And then the slide you have in front here indicates that actually construction of the area would begin in 2Q of 2026, so like a 4-month difference, right?
Well, you did say site, and pad construction here is starting fourth quarter 2026 as opposed to road and pipeline construction.
Okay. So the difference in beginning of construction, as noted in the CPW report and your exhibit A90, is actually a 4-month difference. Is that fair to say?
No, the CPW report refers to site construction, and we're contemplating starting road and pipeline construction 4 months earlier, so that's different.
Okay. But the CPW report anticipated, did it not, that the beginning of construction of everything was set for September of 2026?
Again, I don't have it in front of me, but you said that the CPW referred to site construction, and site is pad, not road.
Okay. And I guess going to some of the restrictions that have been listed through CPW, one of the timing restrictions is that there's the breeding season of the northern leopard frog, right? That's between April and September 26th. Does that sound right to you?
Can you repeat the question? I'm sorry.
No problem. It is the case that the breeding season for the northern leopard frog is known to be between April and September of 2026, correct?
I'd like to defer to my wildlife expert to confirm the actual dates.
Okay, that's fair enough.
Mr. Foote, if I may, the wildlife expert will be up during our next tranche. She's first.
Great, okay. So let's, for the purpose of this question though, so that we're not going back and forth between the tranches, let's assume that what I just said is correct, subject to check, Mr. Harrington, that that's the case.
Yes, sir.
Wouldn't it then be that your road and pipeline construction beginning in 2Q would conflict with that?
The area closest to my understanding, and again, let's revisit when we have a wildlife expert up, is that the pad construction is more critical to the northern leopard frog wintering season, and that is what's being prioritized for the overwintering season.
Okay. The next question I'll just say is, again, let's kind of use the same format here since we're, to try to avoid going back and forth between tranches, but let's just assume subject to check that the burrowing owl's nesting season is recognized to be between March 15th to August 31st. Would your A90 timeline then, particularly beginning with road and pipeline construction in 2Q of 2026, conflict with that?
This one I'm gonna have to defer to our wildlife expert on, I'm afraid.
Okay. You're not aware of Crestone doing any kind of reconsultation with the CPW once the timeline changed between the CPW consultation and now your current A90 exhibit?
We talked to them in November with our new time frame, so yes, I think it's safe to say they're fully aware of this time frame that you're seeing in front of you.
Oh, was there anything submitted on the record about that, or is that the first we're hearing about that?
I am not sure if CPW has submitted anything, but I will say that we talk to CPW on an ongoing basis relative to our operations, and we don't file something every time.
Okay, I'm going to try to go in some kind of a chronological order for slide numbers, and so that would mean that I would need to ask Mr. Bennett a few questions next. And turning to slide 25. Okay, Mr. Bennett, are you there?
Yes.
All right, great. Okay, so we pulled up slide 25. You testified this in your direct examination about the alternative location analysis, correct?
Yes.
And just to be clear about this, you agree there's no requirement under the Oil and Gas Act or ECMC rules that the operator must be able to access all of its minerals within a DSU, correct?
No.
You think there is a requirement in the act that the operator has to access all of its minerals in a DSU?
The rules and regulations provide for technical feasibility as it relates to mineral development as part of a consideration with an oil and gas development plan. That's my understanding.
Okay. Is it also your understanding that if there are public health, safety, and welfare considerations that some minerals can go unaccessed within a DSU?
Projects are location specific. So without a series of variables, I can't comment on that question.
Okay, can we go to slide 27? Now on slide 27, the main issue you identified with alt one on this particular slide, at least, was that you wouldn't reach all your minerals, right?
I believe there were several issues identified with AL number 1 during my testimony.
Okay, but on this slide, you've identified one issue. We'll get to the other slide later, but this issue is you weren't able to access all the minerals, right?
With the slide that's shown in front of me right now, the issue at hand, in addition to issues that were brought up in subsequent slides, was the inability to access the totality of the minerals we choose to develop with this OGDP.
All right. And we haven't seen any information about the quantity that you're talking about or anything about the types of amount of minerals you're not able to access based on alt one. But what is that? How much are you not able to access?
As I mentioned in my testimony, the analysis was done by our highly technical drilling and completions team, and I do not have that result in front of me.
Okay, so you don't know. It could be anything, a small number, a large number, anything in between, as far as you know.
I refuse to speculate on that.
And do you know why that hasn't been disclosed to the commission or anybody else at this point?
It's not part of the application, is my understanding.
And do you know how many wellbores under alt one would not be able to access the full number of minerals within the DSU?
Not off the top of my head.
Okay, and so as far as you know, that information has not also been submitted to the commission or anybody either, right?
To the best of my knowledge.
Okay, so all locations number 2 and 3, that's not on this particular slide. It might have been on slide 25, if you go back to slide 25. Right, okay. So all locations number 2 and 3, you testified that you removed those locations from, or you found those locations to not be feasible based on Arapahoe County setback regulations, right?
I believe there were several variables attached to both locations, but yes, one of those variables was the Arapahoe County Land Development Code and the setbacks that are established within that code for the purposes of oil and gas facilities.
Okay. And then under Alt 3, I think you also indicated in your testimony that, again, you would not be able to access all of the minerals within the DSU from Alt 3, correct?
I believe that was the case.
Okay. Now, Civitas has completed 4.5 mile well bores before, right?
Could you repeat the question, please?
Civitas has completed 4.5 mile well bores before.
No, we have not completed 4.5 mile well bores before.
Have you planned for 4.5 mile well bores?
We have drilled lateral lengths that approach 4.5 miles. That is correct.
Okay. Is it typical practice of Crestone when doing an alternative location analysis to analyze a location that is clearly unpermittable?
When undertaking an alternative location analysis, we start with a blank canvas.
Okay. So, I mean, even in this case, wasn't it obvious that locations 2 and 3 were not going to be permittable from the beginning because they didn't meet Arapahoe County setback regulations?
No.
Did you not know the regulations or just weren't aware before you started the analysis of how far they would be from the reservoir?
As I believe has been testified to today, the planning process for development in and around Lowry Ranch has taken many years. Over the course of that timeline, there have been significant regulatory change, both at the local and state level, that ultimately influence the development plan we are presenting here before you today.
Okay, that makes sense. So it sounds like you would have in fact known then about the new setbacks from the Aurora Reservoir under Arapahoe County regulations at the time of putting together this alternative location analysis, right?
As I mentioned, this process has taken many years to accomplish. That includes siting of locations. In addition to the regulatory change that I referred to, there is an exemption process available via the Arapahoe County Land Development Code that in some instances may or may not have applied to certain locations.
Okay, and you indicated in the narrative for the alternative location analysis that there may have been an opportunity to pursue that variance for Alt 3, but not for Alt 2, right?
I believe my testimony stated that alternative location number 3 had field verified wetlands located less than 500 feet from the proposed alternative location, which is not an exemptable siting under Arapahoe County Land Development Code.
And was there a particular reason why you chose 2 and 3 as opposed to a location that was a little bit, say, farther to the south or farther to the east of Alt 3?
As has been mentioned in our testimony today and read into the record yesterday, the Colorado State Land Board has a number of different stewardship commitments and stipulations that apply to this lease, including areas that have been previously deemed to not allow, surface occupancy.
Okay. Can we turn to slide 28 then? I'm sorry, I don't have control of the slide deck, so I can't do it myself.
Sorry, Mr. Foot. Oh, there we go.
No worries. Okay, Mr. Bennett, there's not a key on this slide about what the orange and the red and the green means, but when you were talking about the no surface occupancy by the State Land Board, does this map reference what you're talking about there?
It's my understanding that this map, yes, represents the various zones, if you will, that the State Land Board has put forth in their management plan for Lowry Ranch.
Okay. And so am I to gather that the red on this map is the no surface occupancy area as designated by the State Land Board?
That's my understanding.
Okay. And then the orange is designated as limited surface occupancy, right?
The verbiage may be slightly different, but generally speaking, it's off limits unless you seek express permission. That's my
Okay.
understanding.
And the green area on this map, there's not a restriction on that, correct?
I believe, and Mr. Harrington may be able to correct me if I misspeak. I believe that the green areas, or what appears to be a green area, are those zones with a less restrictive surface use. Mr.
Okay, that's
Harrington, do you
fair.
have anything to add?
Yeah, I can jump in on this. If you're talking about the green at the upper right of the map, that is tier 4. That is preferred service occupancy. Is generally tied to areas that have previously been disturbed in Lowry Ranch. As you can see, we cited our La Plata site, which is that color you see up there within tier 4. There's no tier 4 down here. So we go to tier 3, which is managed service occupancy. That is, you can think of it as a generally more preferred surface siting. Orange is controlled surface occupancy. So that requires a little bit more review by the State Land Board. And then the red is the tier 1.
Okay, understood. Yeah, thanks for that explanation there.
Sure.
Right. So if we're just talking about the no surface occupancy or the limited surface occupancy, tier 1, tier 2, tier 3, et cetera, there's a fair amount of orange and green on this map where you could have looked at other sites, right?
This map doesn't tell the whole story, and I'm happy to jump into specific areas if you'd like.
Well, of course, but let's talk about that. I mean, you took a look at the Alt Sunlong, which is designated in the orange part of this map. You can go a little bit farther to the north, a little bit farther to the east. You can go to the south. There's a lot of space in this section 26 where you could be looking instead of Alt Sunlong, correct?
Well, I'd start by noting if you look at the segment in the south half of section 34 there, which is not State Land Board land, that's a massive housing development right now. So every single one of those houses will carry a 3,000-foot setback once built. So that's a large chunk of 35 and southwestern 26 completely off the table. Next, you have Coal Creek. Coal Creek is a very sensitive wildlife area. Regardless of the NSO polygons there, we want to stay away from that. And then moving north and east, you could call that Alt Sunlight Long 1B, but that will still carry the same access issues and the same lateral reach issues as Alt Sunlight Long as shown here.
Now, the access issues, those issues are not necessarily determinative though, aren't they? Because you can get a waiver from the State Land Board in order to access some of those lands, right?
I am not clear that the State Land Board would necessarily grant us building a pipeline corridor through Coal Creek. That seems like a pretty environmentally irresponsible thing to do.
Okay, but you are clear though that Crestone did obtain a waiver for no surface access back in June of this year for this particular project, correct?
We did, and that was up in section 15, and that was tied to NSO area, tied to the Aurora East Reservoir, which is no longer being built. That's very specific.
Okay.
It might have been a different story had we requested a bill through Coal Creek or through Blackshack Creek. In fact, I imagine it would have been.
Right, but it sounds like it can happen because it did happen. Other than that, you haven't tried, correct?
It can happen if we can justify it based on the driver of the NSO and the disturbance we're likely to do. In this case, the State Land Board took a very close look at what we were asking and determined it was acceptable. Again, we tried to plow a road right through Coal Creek. I do not anticipate that would be an approval.
Well, You also wouldn't be required to put a road straight through Coal Creek either. The road could go in different areas, correct? It doesn't have to go through Coal Creek.
Well, if we went to the west, that's through Blackshack Creek, and as we know from your petition, that's a sensitive northern leopard frog area, so we wouldn't want to do that either.
Mr. Harrington, while I have you on here, I wanted to ask you about slide 31, since I think you testified to that before. Okay. Okay, slide 31, that is the surface use agreement, correct?
On the right, yes.
All right. And on the left is the letter dated April the 28th, 2024 from the State Land Board, giving approval to what you had proposed at that time for Sunlight Lawn, correct?
Yeah, it's we start with the site visit with State Land Board expert. You can think of the letter on the left as a green light to proceed, and the SUA on the right is the result of that.
Okay. Now, Crestone in some of its filings has referred to the State Land Board mentioning that the currently proposed Sunlight Lawn site is the quote preferred site. Is there anything in these exhibits that says from the State Land Board that they think the currently proposed Sunlight Lawn site is the quote preferred site?
I think the signed SUA would be indicative of that.
Well, the signed SUA says that the site is satisfactory, doesn't it? Not preferred.
I'm looking for the satisfactory word. I don't see that.
Let's look at the small print on the bottom of the left side. It's hard to see. Right by the signature.
Yeah, so that on the left side again, that starts the process, right? And at that stage, they're simply confirming that the site is viable, let's say, with respect to the lease.
Right. Okay. In fact, the State Land Board has been clear that it defers to the ECMC when it comes to the siting of oil and gas locations, right?
I think it's a dual responsibility. The State Land Board enforces its lease and surface use occupancy rules, but the ECMC is responsible for enforcing its rules, and I'll add in Arapahoe County as well.
Well, in the letter that was read into the record yesterday, it indicated the State Land Board defers to the ECMC's regulatory authority over siting oil and gas locations, right?
Yeah, but that's only after a site that's been approved by the State Land Board from the lease perspective. So I just want to be clear, we need to satisfy both parties.
Right, okay. But I guess the bottom line is if the commission determines that this site is not protective of public health, safety, and welfare, and they ask the Crestone to go back and do it over again, the State Land Board is going to be okay with that, aren't they? Because they're deferring.
I think the ECMC enforces its rules and the State Land Board enforces its lease requirements.
Okay. And the State Land Board has been clear with this commission, in their opinion, that it's entirely within the commission's discretion to order an additional alternative location analysis for this site. Do you agree?
If that, I don't think I can speculate for the State Land Board.
Okay, did you listen to the reading of the letter into the record yesterday?
I did.
And do you not recall that from the letter that was read into the record yesterday?
I don't recall that specific part.
Okay.
Whether they referred to existing or theoretical new ALAs.
Can we go to slide 32, please? Mr. Harrington, I believe you testified to this slide as well, if I'm not mistaken.
That's correct.
Okay. Again, same kind of question here. These entities that have letters represented on this slide, they did not opine that the currently proposed Sunlight Lawn location is a quote preferred location. right?
That's not their function. Their function is to evaluate the site we show them relative to their needs and their requirements.
Right, the same as the state land board then.
Yeah, I
Right.
mean, a range view cannot be the arbiter of ECMC rules. That's I don't think that's their job.
Okay. If we could turn to slide 34, please. Mr. Harrington, you talked about this as well, the different movements that occurred. And if I'm understanding, the red is the sunlight pad and the blue is the long pad. Is that correct?
Correct, until you get to the combined site, which is a red 4 and the blue 3.
Right. Okay. And in your narrative over to the right, if I understand it, there were these movements that you indicate. These movements were a result of evolving Arapahoe County regulations. Fair to say?
Actually, as I testified, the movement from 1 to 2 was proactive modifications by Crestone in response to stakeholder feedback. It was prior to the Arapahoe County rulemaking starting.
And which stakeholder feedback was that?
The public, essentially the public. We heard that, hey, those sites are too far west. We said, we hear you. We're going to move them further east, and those are the sites too.
And you would agree that since April 2024, there's been a lot of public feedback negative to the currently proposed location for Sunlight Lawn, right?
I'd agree. I would agree with that.
And there has been no movement since April of 2024 of the proposed location of Sunlight Lawn.
As demonstrated, the ALA, there's limitations to how far we can go. And of course, the current location meets or virtually every case exceeds our setback requirements.
Okay, slide 40, please. Mr. Harrington, you talked about the Bennett Watkins fire. Well, both you and Mr. Bennett did, but I want to ask you some questions about the wildfire risk. I guess first, maybe we can start off on the basics. You would agree that fire is a known risk of oil and gas operations, right?
There are fires on oil and gas sites, and they're virtually always contained on the site, if that's what you're asking.
And you would agree that grassland fires pose a significant risk to people and property along the Front Range?
There have been some examples of damaging fires. My understanding, not linked to oil and gas, though.
And those fires can spread quickly.
I can't speculate. I'm not a firefighter.
Okay. Well, so I guess based on Crestone's statements as well as your testimony here today, you're not then disputing Starr's assertion that wildfire on grassland can spread as quickly as 6 miles an hour with a 30-mile-an-hour wind, right?
I'm deferring to the judgment of experts at Bennett Watkins Fire on that matter.
Okay.
And Mr. Foote, if I may, it seems like your questions are more pertinent for Mr. Bennett on this because he specifically addressed the wildfire risk.
That's fine. I'm sorry, I'm not seeing Mr. Bennett up on the
Mr.
screen.
Bennett's up and he's unmuted and he's
Okay.
ready for questions.
All right, thank you. Okay, Mr. Bennett, are you disputing Starr's assertion that wildfire on dry grassland can spread as quickly as 6 miles an hour with 30-mile-an-hour wind gusts?
I cannot speculate.
Okay. I mean, subject to check, would you agree with me that something moving 6 miles an hour translates into a moving 528 feet per minute?
I haven't done the math, so I can't confirm that that's correct.
Okay. And can you or can you not confirm that it's correct that a fire moving 6 miles an hour would move just over 3,000 feet in 6 minutes?
I haven't done the math, sir. I cannot speculate.
Okay, Mr. Bennett, it sounds like, if I recall correctly from your testimony, you're aware that Bennett Watkins has ability for as many as 365 square miles in their jurisdiction,
Can you
correct?
can you please repeat the question? The audio dropped out momentarily.
Oh, apologies. You're aware that Bennett Watkins has a jurisdiction of 365 square miles.
I don't recall the size of their jurisdiction precisely, but I do know they are a fire district.
Does it sound correct to you, or would you agree that over that Bennett Watkins jurisdiction, they have responsibility currently for 347 active wells within that jurisdiction?
Did you say wells or well pads?
Wells.
I cannot confirm that well count, sir.
Okay. Would it surprise you, that number?
I don't think it would surprise me necessarily, no.
And are you also aware that according to ECMC statistics that wells in the Front Range area average about one fire or explosion per month?
I was not aware of that.
Could we turn to slide 54, please? Okay, Mr. Bennett, am I remembering correctly, you testified to this particular slide in the wildland fire mitigation plan?
That's correct.
You're not aware of anything in the record, are you, that indicates that Bennett Watkins has even reviewed over Crestone's wildland fire mitigation plan, are you?
I'm not sure I understand your question.
The question is, you're not aware that there's anything, are you aware if there's anything in the record currently that would indicate that Bennett Watkins has even reviewed over this wildland fire mitigation plan?
If by record you're referring to the ECMC proceedings relative to the oil and gas development plan, a wildland fire mitigation plan is not required under the rules for an OGDP. However, if you are referring to the Arapahoe County permit, where we were required to submit a wildland fire mitigation plan, that plan was submitted, it was reviewed, and it was approved.
Okay, that was approved and reviewed by Arapahoe County, right?
I cannot speak to exactly who reviewed or approved that. I will say that we have a will serve letter from Bennett Watkins Fire, which is issued upon their understanding of what we are proposing to do, and more importantly, their review of our operations and the fact that what we are contemplating doing conforms with their code.
And does that will serve letter that you just referenced indicate what kind of emergency response plan Bennett Watkins has in case of a fire at Sunlight Long?
I don't recall.
Do you recall if that will serve letter indicates whether Bennett Watkins has coordinated emergency response with Arapahoe County or the city of Aurora related to fire at Sunlight Long?
Based on our continued relationship with Bennett Watkins Fire, it is my understanding that all of the agencies I recited in my testimony are part of a cooperative response. Those are my words. In the unlikely event that multiple districts need to respond.
Are you aware of what the response time would be from Bennett Watkins in case of a fire at Sunlight Long?
I'm not aware of that.
Mr. Bennett, would you agree with the general premise, though, that moving Sunlight Long farther away from homes could provide more protection against wildland fire?
I can't speculate on that.
Mr. Chair, that's all the questions I have for these two. Thank you.
All right. So we've gotten through cross-examination for the first tranche of witnesses. I think next up we would do commissioner questions, and Ms. Jost, then after that we would allow for any redirect. It is 1:10. I think we should take a break for a quick lunch break, stretch your legs break. Let's return at 1:45.
Great. Thank you, Chair.
All right, we are back. This is the Energy and Carbon Management Commission 145 on November 20th. We are taking up docket 241200313. We had the first tranche of evidence from the case in chief for Crestone. We've had cross-examination. I believe that if we could elevate Mr. Bennett and Mr. Harrington again, or visualize them, we will allow for an opportunity of questions from commissioners. Commissioner Messner?
Thank you, Mr. Chair. Thanks for the information. I did have a few clarifying questions to make sure that I understand what's being presented. And I may get the slides wrong here, so bear with me, but there was a couple of slides. One was slide 34, one was slide 37, all part of Exhibit A90. But there's a proposed reservoir that's in there, in those. I'm trying to understand what that proposed reservoir is, where the information was provided to you associated with the specifics to that proposed reservoir, as I'm not seeing anything provided by the State Land Board that, at least in their most recent submittal, that identifies that as a proposed reservoir.
Thank you, Commissioner. I can handle this one. So if you look in slide 34, there is that sort of teal polygon in the upper right, and it's pretty hard to see, but that reads planned reservoir B. Planned reservoir B is one of the potential future reservoirs considered by Rangeview Metro District, and it is currently in their plan. The polygon associated with that was provided to us by the State Land Board and confirmed by Rangeview. So in the Arapahoe County 2023 rulemaking, planned reservoirs count the same as existing reservoirs. And in this case, we're not topographically, there's no ridge in the way there is between State Sunlight Long and Aurora Reservoir. So that kicks us into a 1 mile setback. And that little black call out line, you absolutely can't read that, is 50 to 80 feet or more.
So the specifics on this was provided to you by the State Land Board?
The shape file, yes.
Okay. But not provided to us in any exhibits that they provided?
I would need to go review their letter again. It might not be on there.
So, and this is where I'm struggling. The only thing I've gotten from the State Land Board that shows this proposed reservoir B is during the CAP hearing, and it's got a very different shape than what you're showing in this exhibit.
I don't know that I can speak to the land board, but I can say that the blue filled polygon you're seeing there is consistent with what we showed at the CAP hearing. In fact, this slide.
I'm not saying you. This was a submittal from the State Land Board as part of a presentation at the CAP hearing that I'm looking at. And that reservoir B, at least on that submittal, goes significantly further south than what you're showing on this. And so I have there's some confusion here for me that I don't know where this information came from. I don't see anything in the record, at least at this point, that identifies that this is an accurate depiction of where the proposed reservoir B is being contemplated. My understanding is it hasn't been determined at this point. And so I guess I'm a little confused on this one.
If I may ask, does the polygon you're looking at from the State Land Board seem to actually match the red boundary you see here? Is it that far south?
It could be. It could be.
Yeah. So I can address this one. The red boundary here, and probably what you're looking at in front of you, is the outline of the Aurora East Reservoir. At one point in the history of Lowry Ranch, that was a contemplated reservoir. Plans for that were completely abandoned some years ago, and it essentially was replaced with planned Reservoir B. So that isn't really I think you're looking at an old version of the State Land Board's map.
Okay. For the record, I asked the state land board to provide specifics on this, and I did not get it in the letter that they provided, and so I don't have any information on the record as to where this is exactly going to be. And so that does cause me a little bit of challenges as far as determining the accuracy of the setbacks that are being contemplated in this slide, and the potential to look at different potential arguments around any alternative locations or anything like that, because I feel like I'm missing information on the record as to the specifics on both Reservoir B and Reservoir C for that matter. Not that I think that Reservoir C may even play into this, but I have some information that contemplates that there's 4 reservoirs. I don't know exactly where these are. I was provided a map as part of the lease that you have with State Land Board that is completely unclear as to where the reservoirs are going to be. And so this is a little bit of a challenge for me. So I don't expect you to solve my challenge today, but I'm identifying it as a challenge.
Yeah, I can just add on that the outlines of planned reservoirs B and C have been stable throughout the Lowry Ranch CAP process. We've confirmed those locations with both the State Land Board and Rangeview Reservoir. So those are what we've been planning around. And as to my, whether or not what was provided a year ago about the State Land Board accurately represents those, I can't speak to, but I can say here that this is what they're planned to be.
Yeah, in your opinion, and I appreciate your opinion, but I don't have that information in front of me right now that's verifiable, and so I am struggling with that. But thank you, and I'm not saying you're wrong. I'm just saying I'm not seeing any clear information or verification of that. So, in fact, and this is where I scratch my head a little bit, is you did indicate that the East Aurora Reservoir was no longer being pursued. I saw an email chain during the CAP hearing that said that it was no longer being pursued, but the letter that was provided by the State Line Board identified that as still something that could be constructed. And so this is where I start to scratch my head a little bit. In page 5 of the letter they provided us, talks about Tier 1 lands, and it includes 2 proposed reservoir sites, one proposed by Rangeview, expanded Reservoir C, and one proposed by the City of Aurora, East Aurora Reservoir site, subject to surface occupancy if agreed on by the board and the lease operator. And so there is confusion here for me as to what is being proposed, what's not being proposed, what the location of it is, and how it potentially impacts or does not impact this or other alternative sites. So, and so I can leave it at that right now, but I'm going to throw it out there as this is a big question for me. And the other question I have is, and I'm asking an honest question here, because I look at this location. Maybe we could pull up the one that shows the alternative locations. I think that's slide 27. Yeah, this one will work. So, I mean, it appears to me that the step outs on the preferred location and this potentially alternative location are almost the same in order to be able to access the minerals with a 1.5-mile step out. So I'm struggling a little bit understanding the technical feasibility argument. I understand that one may be longer laterals, but I'm also not seeing any evidence, unless I'm missing it in the record, that really goes into depth about the technical feasibility of or potential technical challenges of it, or compares and contrasts it with other approved applications that you have that propose some similar technical capabilities, at least in my recollection. And so this is also a little bit of a challenge for me, understanding, and Mr. Bennett, that answer that was, there's guys from Civitas that know their stuff and they say it's not technically feasible. That's not enough for me. I need evidence that actually indicates that this is not really technically feasible and why, in order to be able to understand why a mile and a half step out doesn't seem to be possible for this location, but it seems to be substantially similar at another location. So I throw that out there as you can, I mean, you would want to answer it now, but my understanding, Mr. Bennett, is that you don't feel like you can answer it.
If you don't mind, I can probably offer a few comments that hopefully will be helpful.
Sure.
You're absolutely correct that the lateral step out here between State Sunlight Long and Alt is substantially similar. However, when it comes to modeling torque and drag on a wellbore, everything matters, right? Longer step outs are more difficult, and longer laterals after the landing point are difficult. And it's the combination of both from Alt 1 that makes these infeasible. You did speak about other wells Redstone has drilled. One example pretty close by is the Invictus site. The Invictus site had 4.5 mile deltas between the pad surface and the toes, but there's some key differences there. One is the Invicta only developed a 1 mile swath north to south, and the site was centered in that swath, right? So your side sails are significantly smaller here. The other is that those wells did what we call a sail in. So if I can use my hands, right, they didn't come straight down and do this. They kind of came in like this. The landing point, the top point in the Niobrara Formation, was actually 1.5 miles west of the pad site, from which we drilled into a 3 mile completed lateral. So if you can think about it, this is a gentler wellbore than drill. In this case, the landing point is literally at the heel, right? So it's a much more difficult wellbore.
Okay. And then there's some mention of Swift Fox. Is there evidence that you've provided that talks about this, or have you had conversations with CPW about confirmation of Swift Fox concerns of particular sites? And I'm asking this, understanding that you've done at this point a voluntary alternative location analysis, and so may not have provided the level of detail of a full alternative location analysis, but any additional information that to help me find that in the record as far as this Swift Fox concern?
Commissioner Mesner, if you don't mind deferring that question for our wildlife expert who's next up to speak on our behalf, I think she'd be better to address that.
Okay. That's just fine. Thank you.
Thank you.
I think that's my questions right now. So thank you. I do appreciate, just FYI, the drone video. I think more utilization of that makes sense to me in these hearings. And so thank you for that.
You're welcome.
All right, looking around the room, other commissioners with questions? Commissioner Cross?
Thank you, Mr. Chair, and thank you for this presentation. I want to build on a little bit of what Commissioner Messner was just talking about there. For one, I appreciate Commissioner Messner going back and looking at what the State Land Board previously proposed, because I honestly forgot that it was slightly different than that. But what was previously proposed, if it's still a proposal, would be far enough south that it would interfere with the 1 mile setback because it's on the other side of that ridge, correct?
Could you ask that question one more time, Commissioner?
So you said that Arapahoe County has the 1 mile setback from proposed reservoirs. And so if there is indeed still a proposed reservoir that goes further down the Aurora East or East Aurora Reservoir, I can't remember how it was phrased, that would be the current location as well as the alternative location, both would be within the 1 mile setback set by Arapahoe County, correct?
Yes, if the Aurora East Reservoir were still a planned reservoir, either by state land board or Arapahoe County rules, we wouldn't have an SUA and we wouldn't have an Arapahoe County permit for this or all one.
Okay. And then I want to try and, again, build off a little bit, and maybe we can go to, I think it was slides 27, 28 there with the alternative location analysis, at least with respect to alternative one. Because I do want to delve into this issue a little bit more. And I'm not sure, as Commissioner Messner indicated there, I'd appreciate some more information, and I think it will probably come up with respect to some of the arguments in response to Maverick as well, in terms of ability to drill that. And so I don't want to go too far into depth on the operational feasibility. The one question I do want to ask on that to begin with is, what were the step outs for your Draco pad?
So the Draco, that's a very good question. Thanks for bringing that one up. The Draco pad does develop a DSU that's 2 miles north to south, but the pad is closer to is essentially at the center line, right? So we're about
it's just the 1 mile step outs.
Mile north, and it doesn't do this, it does this. Okay. And from a torque and drag standpoint, that matters, right? It's a gentler landing.
Okay. And again, I appreciate Commissioner Messner's comments on this as well, because I was definitely having some of the same conversations. And I'll just say, maybe as a forewarning, hopefully there's some engineers that can speak to this a little bit more as well. And as I anticipate, it'll probably be with respect to some of what is talked about with respect to Maverick as well. But I'll also probably be looking for some testimony on that issue. I next want to go into some of the issues 2, 3, and 4 with that alternative location 1. And so maybe we can go to slide 28 next as that goes into those separate issues. And so what I want to understand with this is, I was particularly intrigued by issues 2 and 3 in terms of road access and in terms of the pipeline connection. So to start with the road access, I was a little confused about Civitas does not have rights to existing lease road, that last bullet there, because you do have the lease road that's going down to the Beaver location. So I'm a little curious as to why, continuing under that NSO, you wouldn't be able to extend that access road from there.
That's a really good question. Couple things with that. If you look at the red segment of the road, which by the way we're no longer planning to construct, that's a problematic road. It crosses Muchie Creek. Muchie Creek is actually it's within the 100-year flood plain. And once you get past the creek, that is quite a bit of topography getting up that road to where the Beaver site is. All those elements, actually, for what it's worth, went into our cancellation of the Beaver site, right? So while that road doesn't cross the mapped NSO, which again we've kind of talked about, probably really shouldn't be NSO anymore, we're still having to cross a creekway, and that's still a very challenging road build into a hillside.
Okay, and I believe there was discussion of this at the CAP hearing, but I don't want to try and misspeak about this. But can we go into more as to why County Line Road to the south was not an acceptable access point? Because looking at this again, I'm curious as to why an access road would have to go up and along the reservoir as opposed to being able to go south to County Line Road.
Sure, that's a good question. For one thing, if you look at the road as it ties into County Line Road onto a little well pad there in Southwest 35, that's not our well, that's not our road, that's not our pad, right? So we don't necessarily have rights to use that road. That's one. Two is we really like our proposed haul route, which goes on Quincy Avenue, which is essentially an industrial road, and up Watkins Road, which is a 4-lane road, relatively few homes up there, right? County Line Road actually has some homes along it. So we like the haul route better as well. And third, even if you solve for the problem of the road, we still need to get a pipeline over to our system. And the connection point there is either La Plata, which you can see on this map, or the future Blanca site, which is north of Section 15 there. Either way, you need to build a pipeline through some sensitive areas.
Okay, and that will lead into my next set of questions in just a minute, but I do want to touch on, you talked about less houses to the north going to Quincy as opposed to going to County Line Road. Were there any conversations with Arapahoe County about the use of County Line Road, or was that just never addressed with them?
Honestly, we did not address that. We spined up on Quincy to Watkins pretty quickly. That's again a very good haul route. It keeps the traffic well away from the Aurora neighborhoods. So that was our plan A.
Okay. And so with respect to the pipeline as well, obviously you talked about the fact that the closest tie-in is the state La Plata, which is to the north. You don't want to have the boring go through the NSO, through the creek, et cetera. And so I'm again curious, are all of the proposed sites and all of the infrastructure that's set up for the Lowry Ranch cap, is it all heading north or is anything heading to the south?
We're planning to construct essentially a pipeline spine east-west along Quincy Avenue. And I don't know if maybe we could jump to slide 29 quickly, please. There we go. This is not an outstanding diagram actually, but there's an east-west spine along Quincy. You can see the road in sections 12 and 13. That's the road down to La Plata. The La Plata tie goes up that road to the Quincy spine. You can see our black tie up here from Sunlight Long past Blanca, which is where you see that kink in section 10 to that spine. Basically, everything goes onto that spine in Lowry Ranch with the exception of the State Wilson site, which is 2 miles north of Quincy and sort of has its own connection to the Box Elder system.
Okay, so everything further east is also not going to have anything south.
Yeah, there's an eastern spine that goes from the Wetterhorn site to the Yale site to Quincy Avenue and then west. And there's a T junction not far from the State Harvard 1H remote location where it all meets.
Okay. And I think this map is actually probably helpful as well. There was also some cross-examination question that went into some of the road changes and pipeline changes that is through what was previously designated NSO. And I was hoping we could talk a little bit more about that because I want to make sure that it's clear to everyone. There were some minor changes to the no surface occupancy, but you're saying that no surface occupancy, the change to it was agreed to, at least in part, because the reasoning behind that extent of the no surface occupancy had changed. Is that correct?
Yes, I think it's important to note if you look in the Lowry lease, there are exceptions to no surface occupancy, and they have to be done for good reason. So in the case where we were able to get the state land board to agree to move the access road a bit eastward where it's close to Aurora Reservoir, it intersected what was the former Aurora East Reservoir NSO area. We actually went to a state land board vote on that one. And because the Aurora East Reservoir is no longer planned, they were comfortable permitting that.
And and for clarification for everyone listening in as well, that the road as main as now proposed is on the other side of the hill that was shown in that flyover that Commissioner Messner asked about as well. So it would not be directly above the reservoir.
Yeah, the original Ridge Road we proposed followed the existing Lowry Ranch East Ridge Road, which it is out there, right? And it does follow the ridge line pretty closely. In places that was closer than 1,000 feet to Aurora Reservoir, both CDPHE and Aurora Water told us it would be far better if you can maintain a 1,000-foot setback from the reservoir. The added advantage is that moves the road off the ridge line down the hill to the east, so additional topographic isolation. So once we had that feedback from CDPHE and Aurora Water, we had to consult with the state land board to ensure it was permissible. As I said, we went to a board vote, they approved it, and the resulting plan is amenable to Aurora Water, CDPHE, the city of Aurora, and the state land. So kind of thought it was a win getting everyone to agree on that plan.
Okay. That is helpful as well. I want to also go a little bit into, there was some discussion about the fire emergencies. And again, I part of my questioning here is trying to make sure that for the 210 people listening in, that we also make sure there's transparency about how this process works as well. And so I believe Mr. Foote said there was, and maybe it's better to talk to Mr. Bennett here as well, because I know he was speaking to that issue. But I believe he asked a question about 357 well bores, not well pads, is what the Watkins fire emergency was handling. Do you remember that?
Thank you, Commissioner Cross. Yes, what you recited is consistent with my memory.
Okay. And do you know if there would be one, if a large fire was to break out, if there would be additional help beyond the Watkins Fire District?
Thank you for the question. It's my understanding that there would in fact be other first responding agencies, other fire districts, etc., that would also respond to an incident should a response be necessary. Yes.
Okay. And beyond just additional districts responding to any kind of emergency, I also want to talk a little bit about your emergency response plan. And I think maybe it's appropriate to talk about other instances where we have seen potential issues. So for example, this summer, there were some fires on the West Slope that were near oil and gas locations as well. Are you aware of any issues with any of the locations being spreading from locations, or locations being directly affected by either fires on the Western Slope this year or other fires similar to that in the past?
I appreciate the question, Commissioner Cross. And to the best of my knowledge, there was no damage to any locations as a result of those unfortunate wildfires on the Western Slope earlier this summer.
And as part of a process of, you have remote monitoring capabilities for this, remote shutting capabilities, does that remote shutting capability help mitigate any potential spread or impact from fires either started on site or from other sites that approach your locations?
Yes, it would. Thank you for the question. In the event that we had to actuate remote shut-in controls, the location would be secure. And so any additional fuel would not be made available to a neighboring wildfire or fire of any kind.
So similar to a lot of things, we're not able to eliminate all potential dangers related to any fire dangers, but the remote shutting capabilities, you're able to kind of cut off any additional accelerants that could feed the fire or help it along.
Yes.
Okay. Okay, I think those are my only questions for now. Thank you.
Thank you.
Commissioner Oath?
Thank you. I would start by saying I had a lot of questions, most of which have been covered either through cross-examination or through my fellow commissioners' questions. I have some remaining questions on topics that have already been broached, so at the risk of belaboring them, but they are kind of things I maybe want to ask a little bit differently. So first topic with respect to alternative locations. I guess first I would just note I had very similar questions around the feasibility of drilling further from the east and questions about, why a 1.5 mile side sail and 4.5 mile lateral are not feasible, particularly as has been brought up in light of the Draco OGDP in particular. So I will also be listening in for that. But with respect to a couple of the, I guess, reasons that Crestone provided for why alternative number one is not feasible. Another argument was that you would not be able to develop all of the minerals. And this came up during the cross-examination, but I guess I'm going to ask it in a different way because I was not really satisfied with how it was answered during that time. So, but can you point me to a rule or a statutory provision that requires the development of all minerals in a DSU?
Commissioner O, thank you for the question. I will do my best to answer it, and I will encourage Mr. Harrington to chime in as needed. I cannot recite the rule or regulation verbatim, but the assumption maybe is a better way to put it, that a proposed drilling and spacing unit is intended to develop the minerals that are contained within. And so for the example we have here, for the boxes, if you will, that we have designed as part of this OGDP, our intent is to develop those minerals prudently and effectively. And Mr. Harrington, if you have something to add, please chime in.
Yeah, on the regulatory front, I don't, but what I can add is we would anticipate likely the westernmost half mile at least would have to be left out here.
Okay.
Commissioner Oath, if I may. So we look to statute 3460-116-1 as well as rule 305 when we're looking to propose a drilling and spacing unit application. And those statutes and the rules are what governs our ability to not only submit an application, but what's necessary for that submittal. And as part of that submittal is rule 505 testimony that includes land geology and engineering testimony to support why we are seeking to develop the entirety of the drilling and spacing unit for the benefit of the mineral interest owners within that unit. So I would guide you to the statute as well as the rule, as well as rule 505.
Yeah, and thanks, Ms. Jost. I didn't write it down quickly enough. Can you restate the statutory provisions and the rule provisions that you're relying on for this?
Absolutely, Commissioner. That'd be statute 3460-116-1 and 2, sections 1 and 2.
Okay.
Rule 305 and rule 505 and probably rule 503G, I believe it's 1 or 2, which sets forth the requirements for drilling and spacing unit applications.
Okay, thanks.
You're welcome.
Thank you. Okay. The other or another part of the alternative location that I wanted to follow up on is Crestone's basis for claiming that it is the county, that this, the proposed location is the county and the state land board's, quote unquote, preferred location. And the reason I want to follow up on this is, to me, this really goes to credibility, right? Crestone spent a significant part of your responsive pre-hearing statement on this topic and using, kind of what I would term those words of art, the preferred location. And yet the state land board's letter, which was read into the record, specifically says that the lease does not create a basis for determining whether one location that meets the Lowry lease criteria is preferred over another. And so I guess for me, despite this, during cross-examination on this topic, Crestone didn't back away from this assertion in your responsive pre-hearing statement, but at least to me, seemed to continue to be testifying that it is the preferred location of these other entities. So I would ask you to again explain what you're basing that on.
Thank you, Commissioner Oath. I think I'll start by saying maybe there's a little bit of a semantic issue with preferred here. So the end result is we have an approved site from the state land board and an approved site from Arapahoe County. Were those ranked in any kind of specific way with the state land board or the county? Probably not, no. However, I will say, as we testified to, we go out with the state land board and we look at sites, and that leads to that kind of preliminary siting approval. And I can tell you that during that process, we kind of looked around and, the state land board surface staff is thinking about a lot of things, right? They're looking at the position of existing infrastructure, existing water lines, eyeballing wildlife, wetlands, that kind of thing, right? So the fact that we even moved on to this site in the first place meant that the state land board preferred it to other potential sites that wouldn't have been as good. And they weren't even documented in that sense. They were just bad sites. From a county standpoint, all 7 versions of the site shown on this diagram were showed to the county, right? And 1, 2, 3 red and 1, 2 blue were rejected. So I think the fact that the combined site 3, 4 got an approval where the other ones were rejected tells me it's preferred by the county.
Well, maybe as to those sites, but not all potential sites.
I mean, there's an infinite number of potential sites we could line out here, but all the other ones have deficiencies, and we think this is the best option.
Okay. Noting that and the ALA criteria were not triggered here, and so an alternative location analysis was not technically required under the rules. I'm curious if one had been required, would you have analyzed additional sites or analyzed these more robustly or any differently than you did in this voluntary analysis?
If you don't mind, could we go back, please, to site? Let's go to the ALA slide. If you forgive me for 1 minute, I'm going to give Jeff a number here. There we go. Yeah, thank you. That's a really good question. I think it's important to note that there's a lot of area out here that is worse. So agree that some of these sites, well, we concluded sites 2 and 3 aren't going to work, and 1 is problematic, right? But there's a lot of other ones that are even worse. So we're not showing sites 4 through 10, but way of a few examples, right? A site to the west of the proposed Sunlight Long would be within Arapahoe County's RBU setback, so non-viable. Something to the south would be within Arapahoe County's 3,000-foot setback for the platted houses in South Half Section 34, kind of in that yellow rectangle. So we can't go south. Really anything into the north would get us to within setbacks of Aurora Reservoir, Plain River Reservoir B. And then going east, again, gets us into this issue of our Wellbar Reach, crossing Coal Creek and or Black Shack Creek with road and or pipeline. So we're kind of boxed in here.
So in other words, you don't think there are any other sites to consider?
I don't think there are any other good sites that meet all the regulations required and allow for development.
Okay. Switching to just the second topic I wanted to revisit, it does have to do with these proposed reservoirs, and I think my questions are a little bit more zoomed out, in particular, given that I was not a part of the CAP hearing. But these reservoirs are certainly of interest. And I guess you mentioned, well, noting that it's proposed reservoir B that shows up on your slide, and that there was discussion about some reservoirs C and D. Was there a reservoir A?
My understanding is that a very long time ago, there was a reservoir A and D, and the plans for those have long been abandoned.
Okay.
May I pull up a map?
Are you asking me? Is it a map that's part of the record?
Commissioner Oath, if I may jump in here just for a second. So the map that Mr. Harrington wants to pull up is from a publicly available document. It's from the Lowry Ranch Management Plan. That again is publicly available, and it illustrates the questions that both Commissioner Messner and you are asking about Reservoir B. This was additional information we were going to prepare for you after Commissioner Messner's questions, so I think we have the ability to address it now.
And Ms. Jost, was this an exhibit that
It was
you
not,
tendered?
oh, Chair, it was not an exhibit because this Reservoir B, from our standpoint, was kind of set. So this is a new question from commissioners that we are providing information for from a publicly available document from State Land Board, your sister agency.
Yeah, go ahead and pull it up. I'll let you pull it up.
Great, thank you, Chair. Mr. Harrington?
Thank you. Jeff, if you don't mind starting with page 1. So this is the Lowry Ranch Asset Management Plan, which was prepared in January 2020. This is it's a long document, 77 pages. It covers their stewardship plans for the Lowry Ranch going forward. This is a publicly available document. It's on the State Land Board's website. Jeff, if you could jump to slide number 49. Thank you. Maybe zoom on the map a little bit. So this is the current plan for, obviously the Aurora reservoirs on there, but the planned reservoirs. The red one is planned reservoir B, and the blue one is planned reservoir C. You can compare it on your own, but the red polygon pertinent to the State Sunlight site does match the polygon we're showing on our map. So that's that teal finger that was on the map that Commissioner Mesner and I discussed. So that is the current. Those are the current planned reservoirs on Lowry Ranch, B and C, and the other ones are not on here. And Jeff, if you don't mind jumping down to the next page here, and actually zoom out so we can read the slides a little bit. I would just read here this last paragraph for the before the break. Between 2010 and 2018, Aurora Water investigated the feasibility of developing a new East Reservoir on Lowry Ranch. So that's that larger, partially coincident polygon that you've seen on some of the older maps. It was planned to be 3,500 acres in the general location of Rangeview Reservoir B. But in 2018, Aurora Reservoir notified the State Land Board that it was abandoning plans to develop the East Reservoir on Lowry Ranch. The State Land Board consequently notified Aurora Water that it considers a 3,500 acre reservoir site to be available for other uses. And that's, of course, accepting the footprint that's currently under planned Reservoir B.
Okay, thank you. And so what are these reservoirs? What are they going to be used for?
They'll be part of the Rangeview Metro District. They'll be used for, I honestly can't say where they're going to pipe them to or what they're going to use it for, but they are general freshwater reservoirs.
So storage for municipal use, like drinking water.
I don't know off the top of my head if it's going to be used for drinking water, ag water, or what.
Oh, okay.
Yeah. But we are staying a minimum mile off them, which is again, Arapahoe County does not treat setbacks from planned reservoirs any different from existing reservoirs like Aurora Reservoir, and we're compliant with a setback from the planned reservoirs if they're ever constructed, if and when they're constructed.
Well, and I guess that leads a little bit to my other questions, which is So that plan, and thanks for pulling that up. It looked like it was from 2020 and noting that there was historically other reservoirs in different locations that were contemplated that have evolved over time, which absolutely makes sense. I guess these are, still in flux. So what do we look at to have certainty, I guess, that the proposed reservoir B, the one that does comply with the setback, that there's not going to, I'm not asking this well, but basically what kind of certainty can we have that there's not going to be a change in the location of proposed reservoirs closer to the proposed location?
Well, I would direct you to the letter we have from Rangeview Metro District, which is in the record and is included on page. It's in the slide deck. We can tell you the slide number in a moment.
Yeah, I know which letter you're referring to.
And Rangeview Metro District is a sophisticated entity. This is their business. If they felt our pad was going to be a risk to their reservoirs or any change to their contemplating to their reservoirs, they could have simply written, "Hey, we don't like this oil and gas site." That's not what they said. They said we're totally fine with it.
So but the plan that you showed was a state land board plan, but you're saying it is Rangeview's determination about the location of the reservoirs.
That's correct. And of course, the state land board could have objected as well if they thought the reservoir polygons were going to change. But obviously, they look back to the records, retraction of Aurora Reese Reservoir. They're in constant negotiation and conversation with Rangeview Reservoir. They're well aware with their plans, and they aren't contemplating any changes to the future relative to what you've seen.
Okay. All right. Thanks.
Welcome.
Commissioner Messner.
Thanks. So this brought up just a couple of more questions for me. So, there's nothing in that Rangeview letter that says that this is where the proposed reservoir is going to be. And I also don't know if there's a signed lease between the state land board and Rangeview that has been completely executed to know exactly where they're going to be. And so I'm struggling a little bit with your confidence and, knowing it that this is exactly where it's going to be. I do appreciate that you brought up the land management plan that was provided by the state land board on their website, because was not provided by the state land board to us. But I'm still not seeing any certainty that leases have been signed and that we know for sure where the reservoir is going to be. My understanding is it's still in negotiations. And so, I guess I'll just reiterate, I'm struggling with that one a little bit from a certainty standpoint, right? Because it doesn't matter what Rangeview thinks, it matters whether or not it meets our setback requirements and the ECMC rules. And so, so certainty into the location of that's going to be critical for me. And so I just want to indicate that. And I also don't know for sure that Reservoir A is off the table. Man, I'm not saying you're lying, right? I'm sure you had conversations, but I've got nothing in the record that says Reservoir A is off the table. I know where Reservoir A was initially contemplated, and it's not. It's very close to this proposed pad. And so I'd also like some confirmation that that's off the table, which it may very well be. But the letter that I got from the state land board confuses things, I think, a little bit, unfortunately. And so I don't know if that's a question, but
I can offer maybe a couple. I don't know if you're going to love them, but I can offer a couple of things. One, I can confirm there is a lease between the state land board and Rangeview. I'm not privy to the details of it, right? Secondly, we can really only speak to what is reasonably foreseeable. And what data do we have for what's reasonably foreseeable? Well, we have the 2020 State Land Board Management Plan, and we have direct consultation with the entity who would build those reservoirs. And I just reiterate, this is their business. If they thought our pad site was going to interfere with their plans, either Plan Reservoir A or a modified Plan Reservoir B, all they needed to do was send a letter saying, hey, we don't approve what Creststone's doing right now. And I'm quite certain if you had that letter in hand, we wouldn't even be at this hearing today. Instead, they sent a letter saying, yeah, we're fine with this.
No, I appreciate that. They could also send a letter that said, here's where the reservoir is going to be. And then I know that it meets our rule requirements, which is really the only thing that I'm looking at. And so,
Well, I would also note that the ECMC reservoir setback requirement, I think, is something like 1,000 feet,
right.
and our current setback from Plain Reservoir B is over a full mile. So we're over 50 to
I
5,300
don't
feet, something
disagree,
like that.
but I also
Yeah.
see other maps that say that it's going to be closer than that. They may be inaccurate maps, but it's it's all gray to me right now. So,
Well, as pertained to the Aurora East Reservoir as contemplated by the city of Aurora, I would refer back to that Lowry Management Plan paragraph on page 49 that is pretty ambiguous. As of 2018, that was completely off the table.
yeah, I agree. Until I got the state land board letter 2 days ago that said that it is still possible. So this is where I get confused. I want to talk just a little bit about and thank you, Commissioner Oath, for asking about Reservoir A, so that one's there. But I do want to just talk a little bit about technical feasibility and rules. Because while I appreciate the statute that was brought up associated with the drilling and spacing unit, I do just want some confirmation that you understand that, under the new definition of minimize adverse impacts, which is to the extent necessary and reasonable to protect public health, safety, welfare, the environment, and wildlife resources, which is CRS 3460 103 5.5. The new definition does excludes now cost effectiveness and technical feasibility and replaces wherever reasonably practicable with to the extent necessary and reasonable. And also in CRS 36-60-106 2.5A, which is Section 106 of the Act provides that in exercising the authority granted by this Article 60, the Commission shall regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and shall protect against adverse environmental impacts on any air, water, soil, or biologic resource resulting from this oil and gas operations, that it no longer does not include the phrase cost effectiveness and technical feasibility. So I do want to bring that up as entity elements in older versions of the act that may have anticipated technical feasibility and cost effectiveness. And this is all found in the statement of basis and purpose for the mission change rulemaking. In the mission change rulemaking and in SB 19-181 implementing modifying the act does remove cost effectiveness and technical feasibility from a number of sections of the act. And then last question, and this is going to go back to the kind of alternative location analysis. Do you recollect during deliberations and the conclusion of the CAP hearing, Commissioner Ackerman in particular, but I think generally agreed to by all the commissioners, that the importance of exploring in depth alternative locations to the east for this pad in particular?
I do remember that, yes.
And do you feel like what you've provided for an alternative location analysis meets that expectation coming out of the CAP hearing?
I think it does. And the reason is I think it's important to note that the location we're bringing to you today and doesn't trigger an ALA, has three-phase takeaway, reduced facility footprint, full electrification for drilling phase, and a number of other voluntary BMPs on top of it. So if we were starting with a challenging site, I think it would be a little bit of a different story. And I also think it's important to consider the impacts that eastern site would have, right? We've testified to the fact we need to build pipeline through a very sensitive area. We need to put roads to very sensitive areas. And then The converse is the currently proposed site, which meets and exceeds all requirements. So we did think about that, yes.
Okay. Thank you. No further questions.
Commissioner Ackerman?
Thanks, Mr. Chair. I think all of my questions have been addressed by the commissioners. The last one that I had remaining was just touched on by Commissioner Messner, but I do want to expand on that just a little bit and ask the operator for a little more information. I did state, I noted that the placement of the proposed well sites on the boundary of the Lowry Ranch property in general was troublesome, as I felt it unnecessarily minimized the distance between surface locations and residential development. And I specifically noted that the Sunlight Long Pad was a concern for that reason. And I stated, if this cap is approved, I would expect there to be significant continued and ongoing efforts to work with county leaders and the community regarding practices that are found to be acceptable to the county and to the community as a whole during its future consideration of oil and gas specific sites. Specifically, I'd be looking for continued best efforts to minimize impacts on residents, especially on the State Sunlight Long Pad. And so, following up on Commissioner Messner's question there, you did discuss pad evolution earlier in this hearing. I believe that all took place prior to the CAP application. When I made that statement, what significant continued and ongoing specific efforts has Crestone made to work with county leaders and the community while considering siting of this location between the CAP process and now? Is it just the ALA that you presented, or are there other efforts that you would highlight that took place between the CAP and now?
Thank you for that question. I can go through a few, and this may not even be the exhaustive list. Number one, I might be a little off in the timing, but we did commit to the full wrap sound wall, despite not being required doing a noise modeling. Number two, we worked with, as we just testified to, Aurora Water and CDPHE to relocate our planned road and pipeline corridor to increase the setback from the reservoir. Number three, in very specific negotiation with Arapahoe County, we agreed to air quality monitoring for the life of the wells. That was specifically their ask, and we agreed to it. Trying to think of any other. We did agree to a single rig occupation for the Sunlight Long Pad as opposed to multiple occupations, and that was another ask of the county. Oh, and I've been reminded of one more. We did convert our facility to a multi-separator, so that's one separator for each well, 32 wells, to a new technology, a three-phase meter. So there's a smaller three-phase meter for each well, and those feed into a limited number of bulk separators. And that has emissions advantages, and it has advantages for like the literal footprint of the facility when it's all done.
Thank you. I appreciate that additional information. I think the full wrap sound wall was requested by CPW, if I'm not mistaken, and the relocation of the planned road and pipeline corridor, as you mentioned, was CDPHE and Aurora. The air quality monitoring with Arapahoe County demonstrated some cooperation with county leaders. The single rig occupation, I don't think you were specific as to how that evolved. And then the multi-separator, also, it's hard for me to see if that was a result of community or county request, or whether that was just an efficiency that was adopted by the operator. So can you expand on those last two, the single rig occupation and the multi-separator?
Sure. The single rig occupation wasn't asked of the county, so that's simple there. The converting to three-phase meters versus separators, that wasn't a specific request from any municipal government. However, it has advantages in terms of the community, like I said, in terms of emissions, in terms of the size of the facility. So that might have been something that they didn't know to ask for, but we gave just in response to general feedback about the site.
Understood. Thank you. And I would also, this isn't a question, but I would note Commissioner Messner's comment that I also feel like the ALA that was provided was not significantly responsive to that, and certainly can elaborate on that further in the future in these hearings. I did have one other clarification that maybe you can help me with, and I apologize for going back to slides here, but this is the one that showed the tier 1 and tier 2 and the tier map of state land border. Are you able to pull that up again?
That might be slide 34, Jeff.
That's right. And thank you. As we were having these discussions, as you were being responsive to commissioner questions, you mentioned a couple of times portions that probably shouldn't be tier one anymore. My understanding was that they probably shouldn't be tier one because they were mapped out for previous reservoirs that have since been discontinued in philosophy. Can you be specific as to which of these red tier one areas you're referring to when you say they shouldn't be tier one anymore? And I get that that's just your opinion, not necessarily that of State Land Board.
Thank you for that question. If you don't mind, I'm going to go to a different version of the map here. Slide 27, if we could. 28, excuse me, Jeff. Right. So on the east side, Bull Creek is a real creek with real wildlife, sensitive wildlife areas around it. That tier area is not changing. That's real. The sort of out, tier one outline you see to the west is tied to the east reservoir that has been abandoned in 2018. So that is not happening. My
So sorry to interrupt you,
anticipation,
Mr. Harrington, but are you talking about that entire west thick finger from kind of the middle of Aurora Reservoir down, or?
well, let me, so,
Oh, go
uh,
ahead.
so that's coincident with the original outline of Aurora East Reservoir, which was bigger. Um, uh, Shrunken from that is planned Reservoir B, and then we have Black Shack Creek, right? So I anticipate that NSO will shrink, and the resultant polygon, again, my opinion, this is the state land board's call, not mine, is that the ultimate NSO would eventually look like planned Reservoir B and some potential buffer along Black Shack Creek. But again, I'm not, that's not for me to decide.
Yeah, thank you. Since it was brought up in that context, just wanted to clarify exactly what land you were talking about there. I do recognize that that's currently still listed as tier one, and that's the state land board's purview as to whether or not that changes. But I appreciate you elaborating on your thought process when you were talking about that. The remainder of the questions that I had are probably more appropriate for the next section, Mr. Chair. So that's it for me for now. Thanks.
Okay, appreciate all the questions. Uh, Mr. Harrington, I'm gonna make an ask, and you don't need to answer it now, but if you could develop it up before this hearing is over. With regard to the Alt one and the fact that it is going to diminish the ability to develop all the resources. On cross-examination, you indicated that there were other people that would understand or know what that percentage was or what that value loss is. And then just offhand, you sort of suggested the west half mile. I'd like more particular information about that at some point before we make a decision. If you could get your team to analyze that and bring that back to us, that would be appreciated.
Yes, sir.
Commissioner Cross?
Thank you, Mr. Chair. If I could just ask one quick set of questions, if we could go to slide 21, which shows some of the existing well bores in the area. Could you provide a little bit more detail as to, you talk here about there will be some decisions made in the future about potential plugging, and kind of where that stands. Could you provide a little bit more detail on that?
Of course. So the wells you see to the east in sections 24 and 25, those aren't ours. Those belong to a different operator. Ditto for that single north-south lateral at the east edge of section 24, right? So as you know, during operations, sometimes we see new well borers bracketing old well borers, and they go offline, and we wind up P&Ing them. And sometimes wells continue to produce. So I can say with confidence the wells due north of State Sunlight, which are recently drilled State La Plata wells, will continue to produce after State Sunlight is drilled. The fate of those eastern wells is a matter of negotiation with the other operator and their philosophy for cleaning out wells, frac protecting wells, or calling it a day with those wells. I'd also note that most of those verticals are not Niobrara producers. They produce among other things, J sand. So they might be a little more likely to continue to produce. But following offset Niobrara fracturing.
Okay. And has there been any evaluation done with respect to the existing, and I know there's a bullet here about the legacy P&A verticals. Has there already been any analysis done on kind of the integrity of the prior plugs and whether anything needs to be done with it, or is it just something that you plan on looking at later?
That's more to come, but obviously we're going to comply with the OWB process. So that's done in consultation with ECMC engineers, as you know. Either the plugs are deemed sufficient, or we need to replug, or we need to set back our fracs off those wells by a certain radius. So one of those three.
Okay. Thank you.
Okay. At this point, Ms. Jost, if you care for any redirect for this panel, I think that's the next step. Otherwise, we can move to your next witnesses.
Yeah, thank you, Chair. I don't have redirect, but I do have one question about the Lowry Ranch management plan we just pulled up. I have a copy of that. Would you like me to upload that to e-filings?
Yes, please.
Okay, thank you very much. And then Commissioner Messner, if I may, and this goes to Commissioner Oath as well. I have one more rule reference. It's 304B2C that requires a look at targeted minerals for purposes of development with alternative locations. Chair, that it would wrap up tranche 1 for purposes of our presentation. We have folks teed up for tranche 2. I will say that it's a little bit longer than tranche 1, so I don't know if you want a 5-minute break in here.
Yeah. Okay. That's a couple things. The rule that you cited, 304B2C, is that what you just said?
I did, Chair. Yes, and that reference, it's under the ALA, even though an ALA was not required here. There was a question from Commissioner Oath about where basically it says in your rules to look at your minerals to be developed, and that rule requires an operator to look at the target minerals to be developed from the site.
Okay. I just wanted to add it to my list of other rules.
Right.
Yeah, we are going to take a short break, but Attorney Mr. Foote, you have your hand raised?
Yes, thank you, Mr. Chair. While we're in the process of setting rules, I would like to also bring the commission's attention to 3460-103 sub 11, which is the definition of waste, and the fact that waste does not include gas or oil that's not produced as a result of protecting the public health, safety, and welfare. I think that's relevant to the discussion that you all have been having, so I wanted to cite it as well. Thank you.
Okay. Otherwise, we'll let you do your case in chief during your case in chief. So, all right. It is 2:53. Let's return at 3:03. That'll give us 10 minutes. Go ahead and get the next set of witnesses up and running, and then we'll come back for the next presentation.
Great. Thank you, Chair.
All right. We're back on the record in the Energy and Carbon Management Commission Thursday, the 24th or the 20th, and we are taking docket 241200313. All right, we have gotten through the first tranche, I think we call it, of witness testimony from Crestone. We are up for the second. What is the topic of this one, Ms. Jost?
Yes, thank you, Chair. In this section, we are going to discuss wildlife resources, noise, as well as air resources and public health impacts. And it's quite robust. So I would say we're probably looking at about an hour and a half to an hour and 45 minutes for direct presentation.
Okay, well, let's go ahead and get started.
Great, thank you. All right, could I have Ms. Huning please join me on screen? Excellent, thank you so much. And then Mr. Annabelle, can we start the screen share at slide 55? Wonderful, thank you. Well, good afternoon, Ms. Huning. Can you please state your full name and business address for the record?
Good afternoon, Lila Huning, 555 17th Street, Suite 3700 in Denver.
And who is your employer and what is your title?
My employer is Civitas Resources and my title is Natural Resource Specialist.
And how long have you been in your current role at Civitas?
A little over 2 years.
And where did you attend school and what degrees do you possess?
I attended UCLA and I have a Bachelor's of Science in Ecology, Behavior, and Evolution.
Okay. And are you familiar with Crestone's approved Lowry Ranch Comprehensive Area Plan as well as the State Sunlight Long Oil and Gas Development Plan up for hearing today?
I am.
Thank you. Can you please present your portion of the testimony to the Commission?
Thank you. Good afternoon, commissioners and members of the public. I will go over information related to wildlife species and habitats and some of the BMPs associated with this project. First, a bit of context. Our wildlife consultant for this project, HWA Wildlife Consulting, has been conducting annual wildlife surveys at Lowry Ranch for over a decade to help understand and monitor wildlife activity at the ranch. HWA's database with over 10 years of wildlife data from this property has been a significant resource to us, the State Land Board, and Colorado Parks and Wildlife throughout the siting, planning, and consultation processes. Additionally, HWA conducted multiple surveys that focused specifically on the State Sunlight Long Pad area. Now let's jump into some specifics. There are several mule deer and pronghorn high priority habitats throughout the Lowry Range, but this pad was successfully sited outside those HPH areas. A portion of the existing main road off Quincy Avenue does overlap mule deer severe winter range HPH. To minimize impacts to wintering mule deer, improvements to that portion of road have been scheduled outside the mule deer wintering season. Additionally, Crestone will use wildlife-friendly fencing around the location. Next, let's talk about avian species. There has been historic documentation of burrowing owl nests near the Sunlight Long Pad. However, none of those previously documented nest sites have been active for the past several years. Additionally, 2 red-tailed hawk nests have been previously documented in the area, but both are greater than a third mile away, which is CPW's recommended buffer distance for this species. If construction begins during the raptor nesting season, HWA will resurvey for new raptor nests. We will consult CPW if any are identified within their recommended buffer distances. Suitable nesting habitat for other migratory birds can include trees, bushes, grass, structures, and even bare ground. All locations technically have suitable surface for nesting, and the ground surface is the most suitable surface at this location. If construction begins between April and August, HWA will conduct migratory bird nest surveys, and we will consult CPW if any active nests are identified. Next, we'll discuss the prairie dog town that exists around the proposed location. The maximum disturbance area for this development overlaps approximately 8% of the town, while the working pad surface overlaps less than 1% of the prairie dog town. Prior to construction, the prairie dogs that overlap the work area will be passively relocated outside the work area boundaries. In other words, they will not be euthanized or relocated to another property. They will just be encouraged into other burrows in the colony outside the work area. Lastly, the closest documented swift fox den is greater than a mile from the proposed pad. HWA will survey for new den sites at the location prior to construction, and they will survey out to a half mile for den sites if construction will begin during the denning season per CPW recommendation. Again, CPW will be consulted if an active den is identified. Northern leopard frogs have been brought up by the local community as a species of concern relative to this development. We are dedicated to protecting local wildlife, and we appreciate the community's dedication to protecting wildlife too. First, a brief general background about these frogs. They rely on aquatic habitats for breeding and overwintering, and they are known to feed in adjacent uplands. They disperse from their breeding areas, often following drainage pathways. Through the past several years of data collection on the ranch, northern leopard frog presence has been confirmed in all the main creeks at the ranch, including Blackshack Creek, Coal Creek, Box Elder Creek, and many smaller drainages associated with these creeks. Northern leopard frog populations have been declining as a result of various factors, including habitat conversion and predation by American bullfrogs. They are Tier 1 species of greatest conservation need in CPW's State Wildlife Action Plan, but they are not listed as threatened or endangered federally or in the state of Colorado. HWA has been collecting data on amphibians, including northern leopard frogs, at Lowry Ranch since 2012. In 2025, they conducted multiple surveys for northern leopard frogs focused specifically on the areas around the proposed pad. HWA will provide more details about these efforts in upcoming slides. CPW reviewed HW's data and consulted with internal subject matter experts, including their statewide amphibian coordinator and Platte River Basin native aquatic species biologist. Multiple on-site and virtual wildlife consultations occurred with CPW, and staff from State Land Board, including their biodiversity team, also participated in the field visits with CPW. STAR hired Adaptation Environmental to conduct a northern leopard frog survey as well. Their survey focused on the local area around the Sunlight Long Pad, including part of Blackshack Creek and the southern end of the reservoir. We appreciate this additional data collection, and their northern leopard frog sightings were consistent with previous data collected by HWA. Our team, our consultant, and CPW all reviewed the available data and public feedback, and we worked with CPW to improve our protection BMPs for northern leopard frogs. I will go over these BMPs shortly. This slide provides visual geographical context of the area and several relevant aquatic features. Blackshack Creek and Coal Creek are 2 of the main drainages in the ranch that have confirmed northern leopard frog presence. Aurora Reservoir and the 2 catchment ponds tucked between the reservoir and the residential homes were discussed in Adaptation Environmental's report as likely sites for northern leopard frog breeding and overwintering. The proposed pad is greater than 500 feet from all these aquatic resources. This slide provides the same view, but with previous imagery from 2014 to show some historical context. There has been significant permanent development around several drainages connected to Aurora Reservoir, which may provide suitable habitat and dispersal paths for northern leopard frogs. In comparison, the proposed Sunlight Long pad will cover a very small fraction of similar habitat and will be positioned much further from aquatic features. Additionally, this pad is a long-term development, but overall it is temporary and will eventually be reclaimed back to habitat. This is a summary of the BMPs specific to northern leopard frogs. Many of these, especially the mitigation measures, are newly developed BMPs by CPW experts, and these BMPs go above and beyond protecting the species during development and will actually help collect new data and inform future efforts. First, avoidance was prioritized by setting this location outside any aquatic native species conservation waters HPH, for which, quote, aquatic native species, end quote, can include northern leopard frogs. The proposed location is also greater than 500 feet from Blackshack Creek and all other wetlands and water resources. It is worth noting here that should Blackshack Creek be mapped as aquatic native species HPH in the future, this pad would still be outside that future HPH. Additionally, the beaver pad that was part of the cap and would have required directly crossing Blackshack Creek has been removed from Crestone's plans. Minimization measures will include using three-phase takeaway to reduce traffic, setting the pipeline on the eastern side of the road away from the reservoir, conducting additional clearance surveys proposed by the operator, installing protective stormwater controls and a sound wall, and constructing the majority of the remaining areas, the southern section of road and pad, during the northern leopard frog brumation or hibernation period. For further clarification, we cannot complete both the southern section of road and pad during the brumation season due to duration. However, the pad is a larger portion of that remaining area and will be constructed during the northern leopard frog brumation season. I would also like to take a brief moment to clarify some questions that came up earlier. In CPW's summary, they refer to the timeline discussed in their summary as the current schedule at the time, and we did have a brief exchange with them in November about the updated timeline. This was actually a result of CPW reaching out requesting a timeline update, further demonstrating their awareness that schedules often change throughout the permitting process. Overall, the construction timeline for the main access road and pad was carefully planned and separated into multiple periods based on the different wildlife priorities in different areas, including mule deer HPH and northern leopard frogs. And CPW's input was a major component of the timeline development. Per recent consultation with CPW, we are also committing to the following BOP specific to pipeline construction. If installation of the southern mile of pipeline requires a trench to be left open for more than one day between March and November, outside northern leopard frog brumation season, Crestone's consultant will survey for northern leopard frogs in the trench prior to backfilling. Lastly, several new mitigation techniques were proposed by CPW to further protect northern leopard frogs and help inform future decisions. Crestone will monitor the northern leopard frog breeding season in spring 2026, monitor water quality, address excessive erosion, conduct weekly mortality surveys during development, and install culverts to provide safe tunnel crossings below the road. New data that is collected during these efforts will be provided to CPW. Lastly, Crestone will also reclaim the existing two-track road that lies within aquatic HPH. We hope the additional data that has been collected and will continue to be collected will help support conservation efforts and prevent this species from requiring ESA protection. The wildlife BMPs discussed here were results of many conversations and consultations with a variety of experts, especially CPW staff. So we'd like to thank all groups, CPW, State Land Board, ECMC, HWA, and STAR and their consultant for their time and feedback on this project. Thank you for your time today, Commissioners.
Thank you, Ms. Mooney. I'd like to now go ahead and pull up our third-party wildlife biology expert, Mr. Logan McConnell. All right, Logan, thank you for joining us on screen. I'm going to start with a series of questions for purposes of qualifying you as an expert in the field of wildlife biology. Can you please state your full name and business address for the record?
Yeah, Logan McConnell, 2308 South 8th Street, Laramie, Wyoming.
Okay, and what is your title?
And then if I didn't mention HW Wildlife Consulting. And what was that question, my title?
Yes, and what is your title with HWA?
It's Natural Resource, Senior Natural Resource Specialist and Co-owner.
Okay, and how long have you been in your current role at HWA Wildlife Consulting?
For 5 years, I've been the Senior Natural Resource Specialist, and an additional 11 years as a Natural Resource Biologist and Project Manager.
Okay, and what are some of your duties with HWA?
My primary duties include senior project manager, lead wildlife and plant researcher, threatened and endangered species assessor, avian biologist, amphibian research lead, and bat and sage-grouse trapping coordinator.
Okay, great, thank you. And will you please describe your previous places of employment and titles at each employer?
Yeah, I worked for the USGS as a field technician. My work focused on locating threatened and endangered shorebird nests along the Platte River in South Dakota. I worked for Colorado Parks and Wildlife as a field technician. My work focused on trapping, tagging, and tracking greater sage grouse near Meeker, Colorado. I worked for Western Ecosystems as a field technician. My work focused on identifying fall raptor migration patterns in Virginia. I worked for the University of Minnesota as a research specialist. My work focused on locating California spotted owl nests in Northern California. And I worked for Bison Associates as a field biologist. And there my work focused on locating threatened and endangered plant species in Northern Utah and Western Colorado.
Thank you. Where did you attend school?
Colorado State University.
And what degrees do you possess?
A Bachelor of Science degree in wildlife biology.
Okay. And do you specialize in a particular field?
I would say plant identification, avian research, amphibian research, bat research, and reclamation.
Okay. And what specific training do you have in the area of your specialty?
I'm certified and permitted by the U.S. Fish and Wildlife Service to trap Preble's meadow jumping mice, trap northern long-eared bats, survey for black-footed ferrets, and survey for several T&E plant species. HWA holds state permits for conducting amphibian surveys in Colorado and for trapping greater sage grouse and Frugious hawks in Wyoming. I've received training from CDOT for providing and assessing stormwater management plans and for being a transportation erosion control supervisor. And I've received wetland delineation training through the Army Corps of Engineers.
And do you have experience in oil and gas development projects in Colorado, specifically Arapahoe County?
Yes, over 5 years of experience.
And do you have experience with oil and gas development projects on the Lowry Ranch?
Yes, also 3 years or 13 years in Lowry Ranch.
And are you familiar with Crestone's approved Lowry Ranch Comprehensive Area Plan?
I am.
And how are you familiar with that plan?
I wrote the biological assessments associated with it.
Okay. And are you familiar with the Crestone State Sunlight Long Oil and Gas Development Plan and location subject to this application today?
I am.
And are you familiar with Crestone State Sunlight Long Oil and Gas Location Wildlife Mitigation Plan?
I am. Yeah, I wrote the wildlife mitigation plan and I conducted most of the wildlife field surveys that are included in the report.
Okay. Did anyone assist you in preparing your report?
No.
Can you please explain the materials you reviewed in creating your report for purposes of today?
Yeah, I ran a U.S. Fish and Wildlife Service IPAC analysis to identify threatened species, endangered species, and birds of conservation concern that could occur in the area. I reviewed CPWs, sensitive species, habitats, and their ranges. And I used the 13 years of wildlife data that HWA has collected within Lowry to determine what sensitive species are in the area and what the potential impacts could be.
Okay, and after you completed your report, did you arrive at a conclusion on the project's impacts to northern leopard frogs?
I did.
Okay, and will you be presenting your conclusion to the commission today?
I will.
And when coming to your conclusion, did you rely on specific scientific or technical principles or methods that are widely used in your field?
Yes, our wildlife studies, including the amphibian studies, followed survey methodology that was widely used and accepted by the scientific community.
And do you believe that your testimony will be helpful in assisting the commission to understand the facts of this case?
I do.
Chair, at this time, I would tender Mr. Logan O'Connell as a witness and as an expert in the field of referenced expertise.
Okay. Does either Mr. Foote or Mr. Prescott have concerns about that request? Mr. Foote?
No objection.
Mr. Prescott?
No objection.
He's qualified as an expert witness, as you indicated.
Thank you,
Please
Chair.
proceed forward.
Okay, Mr. McConnell, can you please provide your testimony to the commissioners?
Yes, thank you, Ms. Jost. Good afternoon, commissioners. Thanks for allowing me to present today. I'll be talking about amphibian data that HWA has collected over the years with a focus on northern leopard frogs within the Lowry Ranch. For purposes of an efficient presentation, I may skip a few of my slides and we'll be focusing on the main takeaways from our research. However, I will provide substantial detail on HWA's work related to northern leopard frogs within the Lowry Ranch. When operator acquired mineral leasing rights within Lowry in 2012, they asked HWA to conduct Lowry project-wide amphibian surveys during 2012 through 2015 and 2018. These surveys were designed to determine where sensitive amphibian species and habitats occur within the entire Lowry Ranch. This was a unique approach compared to only conducting site-specific surveys around proposed developments. This also allowed us to survey and monitor amphibian populations over a 5-year study. This data has been shared with the State Land Board and included in wildlife mitigation plans to help plan future developments outside of the most sensitive northern leopard frog habitats within the Lowry Ranch. The figure in this slide includes all of our amphibian detections and amphibian habitat map during our 5-year study. We collected over 1,000 amphibian detection points during our study, and that included over 500 northern leopard frog detections. I want to highlight the blue diamonds in the figure that represent northern leopard frog detections, the orange square that represents the state sunlight long pad, and that no amphibians or amphibian habitat has been documented within the pad. Our primary northern leopard frog detections occurred along Blackshack Creek, Coal Creek, and Box Elder Creek. The slide illustrates wetland occupancy by each amphibian species and highlights that northern leopard frogs have been the most common amphibian species documented within Lowry. Within the graph, the green line represents northern leopard frogs. During 2024 and 2025, HWA collected additional amphibian data within and around the state sunlight long pad. Northern leopard frog specific surveys included documenting potential breeding habitat and overwintering habitat within and around the pad. In this figure, the blue diamonds represent prior northern leopard frog detections, and the green diamonds represent northern leopard frog detections during 2024 and 2025. As you can see, the prior and more current detections are all along Blackshack Creek, and there were no northern leopard frog detections or breeding habitat documented within the state sunlight long pad or along the pad access road. During the fall of 2025, HWA surveyed Blackshack Creek to identify potential overwintering habitat for northern leopard frogs. We used CPW's habitat scorecard for assessing northern leopard frog overwintering habitat. We focused on identifying pools of water that had the appropriate pH, water quality, submergent vegetation, dominant vegetation, and water depth to support northern leopard frogs. 13 potential overwintering habitat features were identified and assessed during the survey. Among the 13 features assessed, 9 of them were considered potentially suitable northern leopard frog overwintering habitat. These 9 features are displayed as yellow polygons in the figure. Here's an example of a potentially suitable northern leopard frog overwintering pool that was documented during our survey. Here are some more examples of potentially suitable northern leopard frog overwintering habitat. And here are some more examples. And here's one last example. The figure in this slide displays the area that was surveyed by STAR's consultant for northern leopard frogs, with the blue line being their survey route. The red box highlights their survey area along Blackshack Creek. STAR's consultant only covered approximately 0.6 miles of Blackshack Creek and came to the conclusion that northern leopard frogs overwintering habitat does not occur within Blackshack Creek, that northern leopard frogs must migrate from Blackshack Creek to Aurora Reservoir due to the lack of overwintering habitat. HWA surveyed the entire creek from Quincy Avenue to the southwest corner of Lowry Ranch, which covered approximately 4 miles of stream habitat. And we found the 9 potentially suitable overwintering habitat patches along the creek. And again, these 9 features are displayed as yellow polygons in the figure. The U.S. Fish and Wildlife Service Northern Leopard Frog Overview page says, streams are an important corridor for dispersing juvenile northern leopard frogs. and I, most amphibian biologists, would agree with this based on the literature. And since we identified 9 potentially suitable overwintering habitat patches and numerous breeding habitat patches along Black Shack Creek, I believe that the majority of our northern leopard frogs in this area spend most of their time within and near this drainage. Based on the northern leopard frog data that HWA has collected over the years, we predict that northern leopard frogs primarily breed, disperse, and overwinter within Black Shack Creek. Habitat within and adjacent to the state sunlight long pad and access road would be considered unsuitable to support northern leopard frog populations. Crestona has implemented numerous BMPs to further protect and monitor northern leopard frogs within and around the state sunlight long pad and access road. HW believes that due to the lack of suitable habitat within the proposed pad and access road and the BMPs that have been implemented, that negative impacts to northern leopard frog populations in the area are unlikely. Within the entire Lowry Ranch, HWA predicts that northern leopard frogs primarily breed, disperse, and overwinter within the primary drainages, including Black Shack Creek, Coal Creek, and Box Elder Creek. These are the most important features to protect within Lowry Ranch to support northern leopard frog populations. The state sunlight long pad and access road avoids these important habitat features, and impacts to these areas are not anticipated from the project. That concludes my presentation. Thank you for your time today.
Wonderful. Thank you, Mr. McConnell. With that, Chair, we'd like to go ahead and transition into our noise portion of this tranche. I'd like to go ahead and bring up Mr. Nathan Bennett, Dr. Brian Puckett, and Mr. Vince Ginter.
Thank you, Ms. Jost. To demonstrate compliance with ECMC Rule 423, Crestone commissioned a noise impact analysis in addition to collecting ambient baseline sound readings, which are integral to the analysis itself in and around the proposed sunlight long location. Urban Solution Group conducted the necessary surveys and prepared the noise impact analysis in compliance with ECMC rules and acoustical engineering practices, principles, and standards. As previously noted, Crestone will employ a full wrap sound wall during pre-production operations. Based on the ambient baseline sound assessment, the use of sound walls is not required. However, Crestone will employ these walls to further attenuate noise during drilling and completions operations. These maps clearly depict the anticipated sound levels utilizing the appropriate mitigation technique. The cooler the color, the quieter the sound. Simply stated, Crestone will be compliant with state and county regulations on both A scale and C scale spectrums. The excerpts shown on this slide were taken directly from the noise mitigation plan submitted as part of the OGDP application and from the approved county permit. I will now turn the presentation over to Dr. Puckett by way of Ms. Jost.
Wonderful. Thank you, Mr. Bennett. Chair, I would like to go ahead and just have our 2 acoustical experts come on screen. I see Dr. Puckett and Mr. Ginter. Can you please come on video?
Ms. Jost, are you going to qualify them as experts?
I am, Chair.
Do you mind if I see if we're going to have any objections, and if not, then we can just go ahead and admit them? Or do you feel you need to get all their stuff on the record?
I think that would be great. There's a couple questions I might ask them, but if the other parties are willing to accept qualifications, I'm okay with that.
Mr. Foote, Mr. Prescott, any objection to these experts?
No.
Mr. Prescott?
Nope.
All right. I appreciate it from everybody's perspective. We got a long day and a half ahead of us. So they are qualified as experts. You can ask whatever you want, Ms. Jost, but you don't need to go through the full litany.
Great. Thank you very much, Chair. I appreciate that. And I appreciate the full legal qualification of these 2 as experts as well. So thank you so much. I'm going to go ahead and start with Dr. Brian Puckett. So Mr. Ginter, you can go ahead and go off screen for a few, if that's okay with you. Dr. Puckett, just a few qualifying questions, not that you're not qualified already, but just background questions so we can familiarize you with the commissioners. Can you please state your full name, employer, and business address for the record?
It's Brian Puckett. My employer is Urban Solution Group. My business address is 3301 Lawrence Street, Suite 3 in Denver, Colorado.
Wonderful. Thank you. And can you please describe what school and you attended and what degrees you possess?
So I hold a BA in physics from Hastings College and a PhD from the University of Nebraska-Lincoln, with a concentration in building acoustical systems, also known as architectural acoustics.
And are you a member of any professional associations?
I am. I'm an active member of the Acoustical Society of America and the Institute of Noise Control Engineering.
Okay, and do you specialize in a particular field?
I would say my specializations are in human perception of sound, as well as acoustical data acquisition, data processing, and reporting. I also specialize in noise control, acoustical design, statistical analysis, and research methods.
Okay, and do you have any publications or research?
I do. I've published 2 peer-reviewed journal articles that came out of my dissertation, with a 3rd article in progress. I've also presented research findings at several symposiums, poster sessions, professional conferences, most of which were directly related to noise and acoustics.
Okay, thank you. And do you have experience with recent oil and gas development projects in Colorado, specifically Arapahoe County?
I do.
Okay, and are you familiar with Creststone's approved Lowry Ranch CAP or Comprehensive Area Plan and with Creststone State Sunlight Long Oil and Gas Development Plan application up for hearing today?
Yes, I am.
And are you familiar with the State Sunlight Long Oil and Gas Location Noise Mitigation Plan?
Yes, I am.
All right, great. Thank you. And just 2 final questions. You did present a report to the commission as part of this hearing, correct?
Yes, that's correct.
And do you plan on presenting your conclusion to the commission today?
So, along with Mr. Vince Ginter.
Okay. And when coming to your conclusion, did you rely on specific scientific or technical principles or methods that are widely used in your field?
Absolutely. Our conclusions relied heavily on methodologies described in several applicable ANSI and ISO standards, widely accepted industry best practices, as well as the requirements outlined in the ECMC Rule 423 noise regulation.
Wonderful, thank you. So we'll now go ahead and turn to your testimony. Will you please provide the commission with a background on Urban Solution Group's experience in noise mitigation plans and noise monitoring in Colorado, specifically Arapahoe County and the Watkins area of the DJ Basin?
Sure. Yeah. So Urban has conducted over 500 noise studies in the DJ Basin across roughly 8 years of experience. We've provided noise engineering and/or noise mitigation services for 17 oil and gas locations, specifically within Arapahoe County or the Watkins area. We've done about 11 noise mitigation plans, around 13 noise monitoring studies, whether that's background ambient surveys or continuous noise monitoring. And we've provided noise mitigation products on 7 locations.
Okay, and will you please provide the commission with the ground and technical analysis that goes into creating a noise mitigation plan with specific focus on the State Sunlight Long oil and gas location?
Absolutely. So first, I'd like to address something that Mr. Foote stated in the opening statements. It was stated that data in the form of sound power level ratings were not provided in the noise mitigation plan for State Sunlight Long. However, the numeric sound power levels used in our analysis are not required information in the noise mitigation plan according to ECMC Rule 423A. In fact, this information has never been required for any of the jurisdictions' noise mitigation plans in Colorado. And we do, in fact, address where the sound power level information came from and how they're derived in Section 8 of the Noise Mitigation Plan. So to create the Noise Mitigation Plan specifically for State Sunlight Long, Urban completed 3 individual analyses. The first was a 72-hour background ambient noise survey conducted at 3 locations near some of the closest residential building units to the State Sunlight Long location. This involved 2 of Urban Solution Group's field engineers, one of whom was myself, having boots on the ground at the ambient monitoring locations to properly install and field calibrate the sound level meters and necessary weather station equipment. The noise monitors and weather station were located in an open area away from any localized noise sources or objects that could have impacted any ambient noise level measurements, such as building facades or dense vegetation. The monitoring locations followed widely accepted acoustical engineering best practices, as well as the requirements of the 2020 version of the ANSI S1.13 standard, as well as the monitoring procedures required by the ECMC Rule 423 noise regulation. Ambient noise levels were measured at all three of these locations for 72 hours in accordance with the requirements of ECMC Rule 423, and this is also an accepted measurement duration according to the ANSI S12.9 Part 2 standard. Ambient data was processed to remove data points acquired with wind speeds above 5 miles an hour, as well as to remove extraneous noise events not associated with the naturally occurring ambient environment, which is a widely accepted industry best practice. Some examples of these types of sounds are thunder, rain, wildlife, like a bird chirping directly into the microphone, or other short-term or transient types of sounds. And to do that, Urban utilized audio files recorded by the noise monitors to identify and then remove these extraneous noise events from the resulting data sets. Overall, daytime, nighttime, and average LEQ ambient noise levels for both A scale and C scale noise were presented for each of the three individual monitoring locations. And we did this to provide transparency into any variation or differences between the measured noise levels at each location. The second analysis Urban conducted as part of the noise mitigation plan for State Sunlight Long was predictive environmental noise modeling for all the proposed operations. This is also sometimes known as a noise impact assessment, noise impact analysis, or a noise impact study. And really, this involved creating a site-specific noise model which accounted for detailed equipment technical information, location-specific topography, ground cover, and environmental variables. And the results of the model were presented in the form of noise contour maps for each operation, which demonstrated compliance with both the ECMC Rule 423 and Arapahoe County noise regulations. The final analysis included in the noise mitigation plan was specification of best management practices designed to prevent or reduce noise impacts on the environment and wildlife, and to minimize adverse impacts to public health, safety, and welfare. Best management practices that Crestone plans to implement for the State Sunlight Long location are: all planned operations are compliant with permissible noise levels required by both the state and local regulations without noise mitigation. However, prior to commencement of drilling and completions activities, a full perimeter engineered sound wall will be installed around the edge of the well pad to further reduce the environmental noise impact on the area. The sound wall will consist of 32-foot tall engineered sound wall rated at STC 32 around the entire edge of the well pad. The drilling rig that will be used to drill the wells to total depth will be powered by utility grid power. Therefore, the three gen sets that are normally operating drilling operations will be completely shut down and only used for emergency backup in the case that the grid is temporarily unavailable. And this, of course, will further reduce impact on the area. Crestone plans to utilize a low noise completions fleet for all completions operations. Perimeter sound walls will be left in place until drill out is complete and flows are initiated to manage noise levels for the flowback operation. Crestone will conduct continuous noise monitoring at the three ambient monitoring locations throughout the duration of pre-production operations, as well as any construction lasting longer than 24 hours. And finally, Crestone will post contact information to receive and address noise complaints arising from pre-production operations around the clock 24 hours a day, 7 days a week. Upon receipt of a complaint, a Crestone representative will contact the associated stakeholder within 48 hours.
Thank you, Dr. Puckett. And based on the testimony you just provided, can you please describe how Crestone's noise mitigation plan for the State Sunlight Long oil and gas location is protective of the surrounding area?
Absolutely. So, like I said, Crestone's planning to implement a full perimeter sound wall for all drilling and completions operations to further reduce the environmental noise impact on the area. The model results in the noise mitigation plan showed that all operations are actually 4 times quieter on a dBA basis than where Crestone is allowed to be. Similarly, for long-term production operations, they're 2 times quieter on a dBC basis. And so this shows that Crestone has met and exceeded their obligation of what's considered protective for this type of development. Having said that, the model results in the noise mitigation plan for drilling operations included the drilling rig running on gensets. And as I mentioned, Crestone's committed to running the drilling rig on utility grid power. Therefore, the actual noise levels will be lower than what was originally predicted on both a dBA and dBC basis. It's important to note that because the State Sunlight Long location and the ambient monitoring points are in close proximity to several airports, including Denver International Airport, Colorado Air and Spaceport, Buckley Air Force Base, and other regional airports, there are frequent audible aircraft flyovers in the area, which we observed while processing the recorded audio files for the background ambient survey. And the naturally occurring ambient levels are already elevated in this area because of these flyovers. With all that said, the results of the comprehensive analysis show that with full implementation of the best management practices listed in the noise mitigation plan, the State Sunlight Long location is predicted to be fully compliant with the requirements of ECMC Rule 423 for all operations planned. Crestone has done the proper due diligence to meet and exceed what the ECMC code deems as protective of the environment and wildlife and minimizes adverse impacts on public health, safety, and welfare for noise impacts.
Wonderful. Thank you, Dr. Puckett. Commissioners, I'd like to now go ahead and move on to Mr. Vince Ginter. Dr. Puckett, you can go off screen for a few, if that's okay.
It's just.
All right, Mr. Ginter, thank you for joining us on screen. I'm just going to do a few questions to familiarize you with the commissioners. Can you please state your full name and business address and employer for the record?
The address is 3301 Lawrence Street, Suite 3, Denver, Colorado. And I'm employed with Urban Solution Group out of Denver, Colorado.
And what is your title with Urban Solution Group?
I'm the Vice President of Engineering.
Okay. And what are some of your duties with Urban Solution Group?
In addition to providing technical direction for the company, I lead all the efforts of the engineering team and I'm directly involved in all the technical aspects of client projects. I'm also active in technology development for both design and mitigation projects, as well as modeling, measurement, data processing methodologies, those sorts of things.
Great, thank you. And where did you attend school and what degrees do you possess?
I attended the University of Calgary in Calgary, Alberta, Canada, and I have a Bachelor of Science degree in Mechanical Engineering and I have a Master of Science degree in Mechanical Engineering.
And what licenses do you possess?
I am a registered professional engineer since 2007.
Thank you. And have you conducted any scientific or technical studies that would relate to these proceedings?
You bet. So I've completed like literally hundreds of noise impact assessments, including environmental noise modeling, using 3 different commercially available software packages, including the Predictor Lima A, Cadna A, and SoundPlan. I've done hundreds of ambient sound level surveys, including field measurements, data processing, report writing. I've done noise characterization studies using measurement methodologies per applicable ISO and ANSI standards for North America. Hundreds of noise mitigation plans, including specification and sourcing of off-the-shelf silencers, acoustic enclosures, sound walls, as well as sometimes designing custom silencers and high reduction, low frequency acoustic enclosures for very difficult and unique applications. General applications include natural gas compressor stations, gas plants, drilling operations, completions operations, production operations, as well as data centers, solar farms, carbon capture and sequestration, mining, power generation, and those sorts of things. I've also conducted tool analysis and troubleshooting for large equipment groupings to identify offending pieces of equipment and how to fix them, as well as some vibration analysis for equipment, including use of accelerometers and a custom-built data acquisition system that I had designed and built, including measurement uncertainty analysis, error quantification, as well as spectral analysis to carry out root cause, failures, problems, and proposing solutions to the problems. But I'd say those are probably most relevant to these proceedings.
Wonderful. Thank you, Mr. Ginter. And specifically related to today, do you have experience with oil and gas development projects in Colorado, specifically Arapahoe County?
Yeah, so in Colorado, I've completed just over 500 projects specific to Colorado oil and gas, noise mitigation plans, noise impact assessments, ambient studies, compliance reporting, complaint troubleshooting, source characterization studies. And with respect to the Watkins area and Arapahoe County, basically the exact same list that Dr. Puckett just provided as well.
Wonderful. Thank you. And just a quick question. You've presented a report for purposes of this hearing, and will you be presenting your conclusion to the commission today?
Yes, I will.
And when coming to your conclusion, did you rely upon specific scientific or technical principles or methods as they're widely used in your field?
Yes, you bet. So our conclusions rely on the principles and methodologies, described in several applicable ANSI and ISO standards, as well as widely accepted industry best practices requirements, and those requirements outlined in the Colorado ECMC Rule 423 noise regulation.
Great. Thank you, Mr. Ginter. So let's go ahead and turn to your expert testimony. Have you reviewed and evaluated the Thornton Acoustics Save the Aurora Reservoir Community Ambient Sound Study that purports to summarize the results of, quote, an ambient sound study performed to characterize the existing sound environment at the frontier of South Shore community, end quote?
Yes, I have.
And based upon your experience in the acoustic engineering field, do you agree with the findings in the Thornton Acoustics report?
No, I do not.
Will you please explain to the commission why, in Urban's experience from conducting over 500 noise studies and 8 years of experience in the DJ Basin, Thornton's ambient sound study report is not helpful to this commission to understand the facts of this case?
Sure, you bet. First, I wanted to address something stated by Mr. Foote, that Urban seems to have missed kind of the main point of Thornton's report that was titled Star Ambient Sound Study. Was that moving the State Sunlight Long oil and gas location further from the Aurora South Shore community would reduce noise levels. And yet Thornton explicitly states that the purpose of his report is to characterize the existing sound environment at the frontier of the South Shore community and to provide ambient data to evaluate future noise impacts. These are their stated purpose. And this is stated in both the cover letter of the report and the introduction to the report. So yes, Thornton comments in the body of the report that moving the oil and gas location further away will reduce associated noise levels at the Aurora South Shore community, but moving any noise source further away from receivers will reduce noise levels at the receivers. So given that this is self-evident and the fact that there are many more considerations that go into the alternative location analysis other than simply noise, that specific point did not require any further comment from Urban. With respect to the ambient sound study, again, Thornton conducted an independent ambient sound study and presented the results in the Star Ambient Sound Study report. However, the methodologies employed in Thornton's study contained fundamental errors which yield inappropriate, misleading results, making the Thornton report, Ambient Sound Study report, unusable. Thornton installed noise monitors in 2 locations that do not follow best practices for characterizing ambient noise levels. They do not follow the requirements of ANSI S1.13 2020 version of the standard for measuring sound pressure levels, and they do not comply with the noise monitoring requirements outlined in the Colorado ECMC Rule 423 noise regulation. Thornton's noise monitors were located too close to large reflective residential structures, which also provide blockage effects to the microphones, thus lowering the measured overall ambient noise levels. Therefore, these measured levels represent the noise levels for those particular house facades alone. Do not, and this is due to the tight geometry of the adjacent houses, reflections off the deck, and the space immediately around the monitors. And thus, they cannot be generalized to represent the ambient sound levels, and I quote from the Thornton report, at the frontier between the Aurora South Shore community and the lands east of the community subject to oil and gas development, which is the stated purpose of Thornton's sound study report. As outlined in the introduction, again, of the sound study report. Further, Thornton did not process the measured noise level data to remove data points with extraneous transient noise events using audiophile analysis or other means. Noises such as lawnmowers, thunder, those sorts of things. There's no mention in the report of audiophiles that are required to be able to remove extraneous noise at the monitor locations. And given the lack of discussion in Thornton's report around the removal of extraneous noises, as well as the presence of drastic fluctuations in Thornton's data, shown in figure 14 and 15 of their report, reaching up to approximately 12 dBA and 10 dBc between consecutive hourly averages, it is clear that Thornton failed to take this into account while processing the data set, highlighting the lack of a specified methodology to process the data for transient noise events. This also effectively renders the study unusable. Thornton reported ambient noise levels using a single data set, when in fact, 2 separate monitoring points and data sets were required for the study. And it's unclear which approach Thornton took to present only one set of noise levels in the report. If Thornton chose to present noise levels for only one of the monitors and not the other, then this is misleading, as it could introduce skewed or biased results to artificially strengthen Thornton's claim that the actual ambient noise levels are lower than those reported in the urban noise mitigation plan. If Thornton chose instead to present the average of the noise levels from both monitors, then the situation is even worse, as it is completely inappropriate to average noise levels over multiple measurement locations, since ambient noise levels by their very nature are location specific, and thus convention is to present ambient levels for all monitor locations separately, so no information is lost or hidden. Given that Thornton measured the ambient noise levels at 2 specific residential locations that could have significantly different local ambient noise sources and levels due to the significant difference between the 2 measurement locations, any deviation from reporting the measured noise levels for each individual monitor is a distortion of the overall ambient description. Finally, Thornton states that Urban's reported ambient noise levels are higher than Thornton's levels, quote, due to the brevity of the Urban study, end quote. The 72-hour duration of Urban's background ambient noise study is in accordance with the requirements of the Colorado Rule, ECMC Rule 423, and is also the recommended measurement period duration according to the ANSI S 12.9 Part 2 standard. As already noted, Thornton's monitor locations are too close to the residence walls, which provides shielding effects for local ambient sources, which is in fact the main source of the disparity between the reported ambient levels in Urban's ambient report and Thornton's ambient reports. For Thornton to suggest that differences between Thornton's and Urban's reported ambient noise levels are simply due to the difference in durations between the 2 studies, given the systematic and fundamental flaws in Thornton's methodology, data processing, and reporting, as outlined in Urban's memorandum on this subject, is inappropriate, misleading, and erroneous.
Thank you, Mr. Ginter. Chair, that fulfills our noise portion of this tranche of testimony. We'd like to go ahead and turn to Mr. Bennett to kick off our air monitoring and air resources overview.
Very good.
Thank you, Ms. Jost. In addition to the commitments made to monitor air quality for the life of the wells, Crestone is committed to other BMPs intended to reduce or eliminate impacts to air quality. These commitments were made to Arapahoe County and CDPHE and include emissions controls with 98% or greater efficiency, compressed air pneumatics, pressure-suitable separators and vapor recovery units, and pipeline maintenance practices that route unavoidable emissions to a vapor collection system. Note, several of the BMPs listed do not apply as Sunlight Long is a tankless facility. The Lowry Ranch cap order recites the previous findings of this commission relative to air emissions potential impacts and the use of best practices. Crestone's Form 2B expressly addressed air resources in accordance with Rule 303. CDPHE's consultation letter affirmed the proposed BMPs to avoid, minimize, and mitigate potential impacts to air resources. I will now turn the presentation over to Mr. Dan via Ms. Jost.
Thank you, Mr. Bennett. And Mr. Randy Dan, if you can come join me on screen. Wonderful, thank you. Can you hear me okay, Mr. Dan?
Yes.
Okay, wonderful. Thank you so much. Chair, similar here, I was planning on qualifying Mr. Dan for purposes of Air Quality Control Commission regulations and air quality expert matters. Is this a chance to ask the other council if they have any objections?
Yes. Mr. Foote, Mr. Prescott.
No.
No objection.
All right.
Wonderful. Thank you so much, Chair.
Designated as an expert.
Great. Thank you. Well, good afternoon, Mr. Dan. Can you please provide your full name, business address, and employer for purposes of the record?
Hi, Rainy Dan. I am employed by Davis Graham and Stubbs, located at 3400 Walnut Street, Denver, Colorado.
And what is your title, and how long have you held your current role with Davis Graham and Stubbs?
I'm a partner at Davis Graham, and I've been a partner for the past 11 years.
And where did you attend school, and what degrees do you possess?
I received my undergraduate degree from the University of Florida and my law degree from Georgetown University,
Okay. And where do you hold your bar license?
Colorado.
Okay. And do you have a focus on any particular area of law?
Yes, I'm primarily an environmental lawyer, specializing mostly in air quality law.
Okay, wonderful. Thank you. Do you have experience with oil and gas development plans in Colorado, including Arapahoe County?
Yes,
And are you familiar with Creststone's approved Lowry Ranch Comprehensive Area Plan, as well as the state Sunlight Long Oil and Gas Development Plan up for hearing today?
yes,
And you submitted a report in support of Creststone's Oil and Gas Development Plan application, correct?
correct.
And do you believe that your report and testimony will be helpful in assisting the commission understand the facts of this case?
I do.
Okay, thank you. Mr. Dan, can you please provide the commission with an overview of your expert report and the conclusions relating to Creststone's development of the state Sunlight Long Oil and Gas location?
Yes, my expert report primarily provides a summary of relevant Colorado and local air quality laws and regulations. And my conclusion is that together, this state and local scheme ensures that new facilities are subject to rigorous enforceable controls and oversight, demonstrating that the division and Arapahoe County regulate these facilities in a stringent and protected manner.
Wonderful. Thank you, Mr. Dan. And at this point, I'd like to go ahead and just turn it over to you for purposes of providing your testimony to the commission.
Okay, thank you, Ms. Jost. Good afternoon, commissioners. Again, my name is Randy Dan, and I'm a partner at Davis Graham and Stubbs, LLP in Colorado. I'm a Colorado licensed attorney and have been practicing air quality law in Colorado for approximately 15 years. During that time, I have represented oil and gas companies in nearly every significant air quality rulemaking before the Colorado Air Quality Control Commission. I also regularly counsel oil and gas companies regarding compliance with Colorado and national air quality regulatory and permitting requirements. And I regularly represent oil and gas companies in enforcement actions with state air agencies, the United States Environmental Protection Agency, and the United States Department of Justice. My testimony today will provide an overview and summary of Colorado air quality regulations and permitting requirements applicable to the oil and gas industry. In Colorado, the state agencies primarily charged with air quality monitoring, regulation, and permitting are the Colorado Air Pollution Control Division and the Colorado Air Quality Control Commission. These agencies have staff that are uniquely trained and qualified to assess and monitor air quality issues and have been leading the way in Colorado on consequential regulatory development for the oil and gas industry. The Air Quality Control Commission is the agency charged with adopting new air regulatory requirements in Colorado. As discussed in my expert report, the Air Quality Control Commission has been extremely active for more than a decade in adopting new emission control, inspection, maintenance, and monitoring requirements for the oil and gas industry. In fact, Colorado is a national leader in oil and gas air quality regulations and in many cases serves as the model for federal air quality requirements. The Air Pollution Control Division is the agency responsible for issuing air quality construction and operating permits to regulated sources. The division is also responsible for enforcing Colorado air quality regulations and permitting requirements. First, I will generally summarize the air quality permitting requirements for new and modified sources. I should note, however, that based on my understanding of the anticipated design and operation of the facility, most permits typically applicable to oil and gas production facilities will not be required due to the state-of-the-art design and operation of the facility that eliminates most of the typical emission sources found at oil and gas facilities. Any emissions that will exist at the facility will be minimal and will be subject to relevant permit requirements. In Colorado, Regulation Number 3 establishes a permitting program for the construction and modification of new and existing sources in all areas of the state. Regulation Number 3 air quality permits apply to the construction and modification of these new and existing sources and require stringent emission control, modeling, inspection, and monitoring requirements. These requirements ensure that under the Clean Air Act, legally enforceable procedures are in place to prevent construction or modification of any source where the emissions from the projected activity would violate control strategies or interfere with attainment and maintenance of the national ambient air quality standards. Indeed, the Air Quality Control Commission regulations provide that the division may grant a permit only if it finds that the proposed source or activity will not cause an exceedance of any national ambient air quality standard, and the source or activity will meet any applicable ambient air quality standards and all applicable regulations. This allows the division to continue issuing permits for future development while continuing to ensure progress towards the attainment with the national ambient air quality standards. Individual air quality construction permits include robust emission control requirements, emission limitations, facility inspection and maintenance requirements, and record keeping and reporting requirements. Next, I will highlight some of the extensive air regulatory requirements applicable to oil and gas facilities. For more than a decade, Colorado has been developing and implementing the most robust air quality regulations and standards applicable to the oil and gas industry. Indeed, these Colorado regulations are the gold standard in the country and have been a model for EPA's national emission standards for oil and gas operations. The majority of the regulatory requirements for oil and gas facilities and operations are located in Regulation Number 7, entitled Control of Emissions from Oil and Gas Emissions Operations. Some of the more significant requirements include storage tank emission controls, inspection, maintenance, and monitoring requirements, comprehensive leak detection and repair requirements for well production facilities, control requirements for liquids loadout and downhole well maintenance, enclosed combustion device performance testing, and emission reduction and control requirements for pneumatic controllers. As I mentioned before, based on my understanding of the anticipated design and operation of the facility, many of these regulatory requirements typically applicable to oil and gas production facilities will not be required due to the state-of-the-art design and operation of the facility that eliminates most of the typical emission sources found at oil and gas facilities. Next, I will summarize the state's Regulation Number 7 requirements applicable to pre-production operations. Regarding pre-production operations specifically, the Air Quality Control Commission regulations include requirements for air quality monitoring, controls on emissions from flowback vessels, and certain specified use and operational restrictions on drill rigs and fracking operations. For air monitoring, operators must begin monitoring at least 10 days before pre-production starts and continue throughout pre-production, and for 6 months after the well can consistently produce either separable gas or saleable liquid hydrocarbons. Monitoring must follow an air monitoring plan approved by the division and the local government. The plan must specify the pollutant to be detected, evaluated, and reduced. The plan must also include a site plan showing where sensors and monitors will be located relative to pre-production activities, measurement intervals, response levels, and quality assurance and quality control procedures. The Air Quality Control Commission's pre-production monitoring program was initially adopted in 2020 in response to Senate Bill 19181 and most recently revised and enhanced by the Commission just this year in February to standardize monitoring equipment calibration and testing procedures, monitoring sampling and data reporting intervals, and monitoring plan and reporting formats to improve the quality of the monitoring data. Notably, Earthworks was a party to the February Air Quality Control Commission rulemaking this year and submitted much of the same monitoring-related reports and arguments submitted in this proceeding. Earthworks also submitted an alternative proposal in that rulemaking requesting that the 6-month monitoring period in the state Regulation Number 7 program be extended to 3 years. The Commission denied that proposal. The division also just finalized in May of this year an air quality monitoring guidance document that addresses, among other things, monitor siting, calibration, and testing. The division is required to provide a status update to the Air Quality Control Commission in 2027 regarding the pre-production monitoring program. Regulation Number 7 also includes other pre-production emission control requirements. For example, operators must also collect and control emissions from each flowback vessel by routing emissions to air pollution control equipment that achieves at least 95% hydrocarbon control efficiency. Each flowback vessel must be inspected, tested, and refurbished to ensure it is vapor tight, and operators must monitor liquid volume in the vessel. Pre-production activities are also subject to use and operational restrictions, including requirements to use grid power for drill rig engines. Notably, regulation number 7 does not identify grid power as an option for hydraulic fracturing pumps because it's my understanding that the use of grid power for fracking is not readily available or technically feasible. In December 2023, the Air Quality Control Commission approved a comprehensive NOx intensity program that includes NOx intensity targets for upstream oil and gas operators in the ozone non-attainment area for the period of May 1st through September 30th. Developed through significant collaboration between the division, the oil and gas industry, and multiple stakeholders, the NOx intensity program identifies NOx intensity targets for specific operators designed to achieve a 30% reduction in upstream oil and gas NOx emissions per the governor's directive. The Air Pollution Control Division and the Air Quality Control Commission determined that a NOx intensity program is the best method to achieve this 30% reduction, as it allows for a determination of a numeric mass limit for the ozone season that can then be equitably allocated amongst operators based on production levels. The targets apply for calendar years 2024 to 2026, but the Air Commission is currently considering draft regulations that would extend those targets to 2030. Arapahoe County has also developed an air quality monitoring program that is stricter than the state program. Operators must submit an air quality mitigation plan with an application for a new oil and gas facility. The plan must demonstrate how the facility will be designed and operated to avoid or minimize adverse air quality impacts to public health, safety, welfare, and the environment. It must also provide for more frequent, broader, and longer duration air quality monitoring than the Air Commission's regulations require. The county also requires operators to implement air quality best management practices, some of which are more stringent than the Air Quality Control Commission standards. These practices include controlling liquids loadout, routing of emissions from reciprocating compressors to vapor collection systems, electrification equipment where feasible, and adopting indirect measures such as reducing truck traffic and minimizing vehicle idling. In conclusion, Colorado's comprehensive regulatory framework, rooted in the Clean Air Act and implemented through the Air Quality Control Commission's and Arapahoe County's regulations and the division's robust permitting program, impose rigorous obligations to eliminate and minimize air emissions at oil and gas facilities. Taken together, this state and local scheme ensures that new facilities are subject to rigorous, enforceable controls and oversight, demonstrating that division and Arapahoe County regulate these facilities in a stringent and protective manner. Thank you.
Great. Thank you, Mr. Dan. At this point, Chair, we'd like to go ahead and turn back to Mr. Bennett for purposes of kicking off our Public Health and Welfare Resources position.
Very
Thank
good.
you. Sorry, Chair Robbins. Thank you, Ms. Jost. The Lowry Ranch cap order recites the previous findings of this commission relative to public health protections, associated avoidance measures, and BMP commitments. Page 219 of the mission change statement of basis and purpose reads in part, quote, "The commission determined that a 2,000-foot distance was necessary and reasonable to avoid, minimize, and mitigate potential impacts to public health and welfare," end quote. This decision was not made lightly, having considered a large body of evidence in the administrative record, consultation with subject matter experts, and is in line with the statutory mandate to protect health, safety, and welfare of the public. The proposed location meets the criteria set forth in Rule 604A and 604B. That is, no Rule 604B2B criteria were triggered. With no residential building units within 3,000 feet of the proposed location, Sunlight Long meets and exceeds the siting criteria established by ECMC, as well as that established by Arapahoe County. I will now turn the presentation over to Ms. Green via Ms. Jost.
Wonderful. Thank you, Mr. Bennett. And Chair, we do need to ask Mr. Thomas if he can lift, I guess, Ms. Linda Dell to our panelists. She had a reboot and she got kicked out of the panel list.
What's the witness's name?
Linda Dell.
All right, Mr. Thomas, if we could elevate Ms. Dell.
We found her and are working on elevating her. She should be on the panel now.
Wonderful. Thank you, Mr. Thomas. Thank you, Chair.
Yeah, let's get her to visualize herself. There's so many witnesses here.
Yes, I was actually going to see if I could ask Ms. Tracy Green to do the same thing. Let's see. I see both Ms. Green and Ms. Dell. Can both of you hear me okay?
Mhm.
Wonderful.
Yes. Yes.
Okay, Chair, thank you. Okay, well, wonderful. Well, thank you so much for joining us today, Ms. Green. Actually, let me take a step back. Chair, we were going to and would like to qualify both Miss Tracy Green and Miss Linda Dell as qualified experts in the field of public health, one in toxicology and one in epidemiology.
All right. Same questions for Mr. Foote and or Mr. Prescott.
No objection.
No objection from Star.
Okay, they are deemed experts in whatever field you just mentioned that they were experts in.
Great, thank you, Chair. All right, Miss Green, can you please provide your full name and business record or business address for the record?
Tracy Green and 3107 Ormond Street, Monroe, Louisiana.
Okay, and who is your employer and what is your title?
I'm employed by Ramble America's Engineering Solutions, Inc., and I'm a senior managing consultant.
Okay, and how long have you been in your current role with Ramble?
Since 2015.
Okay, and what are some of your duties at Ramble?
I manage a team of toxicologists participating in various technical projects, including risk assessment, human health risk assessment. I'm also the technical lead on several risk and safety assessments.
Thank you. And where did you attend school and what degrees do you possess?
I attended school at the University of Louisiana at Monroe, and I have a Bachelor's of Science degree in toxicology.
And are you a member of any professional associations?
Yes, the Society of Toxicology.
Okay, and just by way of background, and then we'll move on to your testimony, do you specialize in any particular field?
My work over the last 30 years is focused on qualitative and quantitative human health risk assessments. I've also got experience in systematic literature review, weight of evidence evaluation, and scientific data integration.
Okay. And what licenses do you possess?
I am a diplomat of the American Board of Toxicology.
Great, thank you. And do you have any publications or research from your own?
Yes, I've either been the principal or co-author of approximately 20 peer-reviewed publications.
Okay, and do you have experience in oil and gas development plans in Colorado?
Yes,
And
I've been. Oh, go ahead.
Go ahead.
I've been consulting on oil and gas development projects for about a year now in Colorado.
Okay, and have you consulted on oil and gas development projects prior to Colorado?
No.
Okay. Are you familiar with Creststone's approved Lowry Ranch Comprehensive Area Plan and the State Sunlight Long Oil and Gas Development Plan application up for hearing today?
Yes, I am.
And did you prepare a report in this case?
I did.
And when coming to your conclusion, in your report, did you rely upon specific scientific or technical principles and methods that are widely used in your field?
Yes, I relied upon risk assessment methodologies used by many different regulatory bodies, but notably the United States Environmental Protection Agency.
Okay, and thank you for that background and familiarizing yourself to the commission. I'd like to just go ahead and turn to your testimony. So would you please provide the commission with an overview of the work you performed regarding health risk assessments that have been conducted at or near oil and gas development sites?
Yes, and thank you. Again, commissioners, my name is Tracy Green, and I'm a board certified toxicologist with over 30 years of experience in human health risk assessment. My experience is focused on the synthesis and analysis of published toxicology, epidemiology, and genetic toxicology literature, and the assessment of potential health risks from chemical exposures. I'm also familiar with literature surrounding potential health risks from exposures to chemicals originating in part from oil and gas development sites, including volatile organic chemicals such as benzene. Today, I'd like to present a brief overview of work I performed that included a synthesis of data of the results of quantitative human health risk assessments that have been conducted at or near oil and gas development sites. And I'd also like to discuss a bit about how these data can be used to estimate potential health effects at various distances from these sites. There are generally two types of scientific studies that can be used to predict potential health effects related to air emissions from oil and gas development sites. The first type is epidemiology studies, which are observational studies in human populations. However, the actual exposure concentrations in these studies are usually unknown and are estimated using surrogate measurements such as living within X miles of an oil and gas development site, which doesn't always consider potential chemical exposures from other sources within the area or health factors within the population. The other type of study applies human health risk assessment principles to air concentrations collected through actual measurements, and then compares these measured air concentrations to conservative health-based benchmarks set by authoritative bodies, such as the United States Environmental Protection Agency. The advantage of these risk assessments is that they use air emissions data from defined monitoring locations from oil and gas development sites to better characterize actual exposures at specified distances from the site. In addition, when conducting these types of quantitative risk assessments, estimates of potential adverse health effects are based not only on well-defined exposure measurements, but also on toxicity values estimated using high-quality scientific studies. These benchmark values include safety factors that make them often hundreds or thousands of times below the actual concentrations reported to be associated with health effects. And because of this degree of safety built into the benchmarks, they are assumed to be concentrations at which exposed people will not have appreciable risk of adverse health effects. These benchmark values are meant to be protective of all people, including the most sensitive individuals in the populations. Importantly, this does not mean that any exposure concentrations above these benchmark values will result in adverse health effects, but that exposure to concentrations above the benchmarks may potentially lead to elevated risk in certain sensitive individuals.
And Ms. Green, have you reviewed other health or other risk assessments as part of your report in this case?
Yes, I have reviewed several published risk assessments that all incorporate actual air monitoring data and actual distance the air monitoring data was collected from the sites. And these studies include a comprehensive list of chemicals identified as risk drivers for each site, health-based cancer and non-cancer toxicity benchmarks recommended by regulatory agencies, and cancer and non-cancer quantitative risk and hazard estimates, both for individual chemicals as well as cumulative estimates. These assessments consider both short-term and long-term non-cancer effects, as well as long-term cancer health effects. Non-cancer hazards refer to adverse health effects that are due to adverse alterations in the structure or function of various organ systems. To evaluate the potential for adverse health effects from individual chemicals, the chemical air concentrations are compared to the individual chemicals' acute or chronic toxicity values. The ratio of the two values produces an acute or chronic hazard quotient for that specific chemical. And if the hazard quotient exceeds 1, we can assume that there may be concern for potential non-cancer effects from the specific chemical. Also, because there is potential for multiple chemicals to elicit an effect on the same target organ, the individual hazard quotients from chemicals with similar target organs are summed to estimate a hazard index. If the hazard index is less than or equal to 1, then no adverse effects would be expected from exposures to multiple chemicals with similar target organs. Lifetime cancer risk is defined as the probability of developing cancer after a lifetime of continuous exposure to a chemical, and is estimated by regulatory agencies using available cancer risk values such as cancer slope factors and inhalation unit risk factors. Cancer risk is calculated for carcinogens by multiplying the estimated exposure concentration for each chemical by the respective cancer risk value. The EPA has established a range of generally acceptable risk from known or suspected carcinogens as 1 additional cancer risk in 1 million individuals to one additional cancer risk in 10,000 individuals, expressed as 1 times 10 to the negative 6 to 1 times 10 to the negative 4. Cancer risks less than 1 in a million are generally not of concern, whereas risk levels exceeding 1 in 10,000 are usually considered unacceptable. So my review included 10 risk assessments. 7 were conducted in Colorado, 1 in Pennsylvania, 1 in Ohio, and there was 1 screening risk assessment that evaluated counties in Arkansas, Colorado, Ohio, Pennsylvania, and Wyoming. I reviewed each risk assessment and synthesized data according to distance of the sampling sites from the oil and gas sites. Most of the risk assessments considered multiple oil and gas sites with air monitoring data collected at various distances, both less than or equal to a half mile or greater than a half mile from the oil and gas sites. 8 of the 10 risk assessments that were included in my review considered air monitoring data within a half-mile of an oil and gas development site. And 3 of these risk assessments reported exceedances of chronic, subchronic, and acute non-cancer hazards. The first of these 3 studies was conducted by McKinsey and others in 2018 and included 2 sampling locations located between 528 feet and 2,112 feet from the nearest oil and gas site. A chronic hazard index of 5.4, indicating an increased potential for adverse non-cancer effects, was reported for the sampling location near 528 feet. However, at distances greater than 528 feet up to 2,112 feet, no hazard quotients for any individual chemical or the cumulative hazard index exceeded 1, indicating potential for non-cancer effects decreased as the distance from the site increased from approximately 500 feet to approximately 2,000 feet. The second risk assessment reporting non-cancer exceedances at less than half a mile was conducted by McKinsey and others in 2012. The results of this risk assessment indicated no exceedances in chronic non-cancer hazards. However, a subchronic hazard index of 5 was reported at a site located less than 500 feet from an oil and gas site. And the third risk assessment reporting non-cancer exceedances at distances less than half a mile was conducted by McMullen and others in 2018 and included air monitoring data collected at 10 different sites across Colorado. A chronic hazard index of 1.1 and an acute hazard index of 1.2 were estimated on air concentrations across all sites, based on air concentrations from all sites. There were no chronic hazard quotients for any individual chemical that exceeded 1, but N-nonane was recognized as the driver for the chronic hazard index with an individual hazard quotient of 0.84. 5 of the 10 risk assessments evaluating non-cancer risk from oil and gas sites included air monitoring data from sites that were greater than half a mile from the nearest oil and gas development, and only one of these risk assessments reported an exceedance of a hazard index of 1. CDPHE's 2007 risk assessment reported 2 subchronic and 1 acute hazard index exceeding 1 for 2 sites located greater than a half mile from an oil and gas site. However, CDPHE also noted that the exposure estimates for this risk assessment were based on extremely conservative assumptions, and the likelihood of these exposure assumptions was uncertain, leading to the need for further investigation. So to sum up the non-cancer findings, based on these findings across all of the risk assessments reviewed, results indicated that there was no increased long or short-term non-cancer hazard for residents located at a distance greater than a half mile from the nearest oil and gas sites. 7 of the 10 risk assessments that I evaluated estimated cancer risk for sites located within half a mile of the nearest oil and gas site. Of those 7, 2 reported lifetime cancer risk that exceeded the unacceptable range of 1 in 1 million to 1 in 10,000. The first of these was a risk assessment conducted by Macy and others in 2014 that reported concentrations of 1,3-butadiene, benzene, formaldehyde, and hydrogen sulfide exceeding the air concentrations corresponding to EPA's cancer risk levels at various counties of Arkansas, Colorado, Pennsylvania, and Wyoming. The lifetime cancer risk of these sites exceeded the acceptable risk range, indicating an increased cancer risk at distances of a half mile or less from sites. The risk assessment conducted by McKinsey and others in 2018 reported a cumulative excess cancer risk of 1 in 10,000 for air concentrations collected from sites in Colorado, and a cumulative excess cancer risk of 8.3 times 10 to the negative 4 at a distance of 528 feet from the site, exceeding acceptable range. However, at locations greater than 528 feet up to 2,112 feet, cumulative cancer risk were within acceptable risk range. 2 of the 10 risk assessments I reviewed included cancer risk estimates at locations greater than a half mile from the oil and gas development sites. Minor exceedances of 1 times 10 to the negative 4 and 1.6 times 10 to the negative 4 were reported in one of the assessments conducted by CDPHE in 2007. However, as noted previously, the exposure estimates for this risk assessment were based on extremely conservative assumptions and likely overestimated cancer risk at these locations. Overall, the majority of cancer risk reported in the risk assessments conducted at locations greater than a half-mile from the nearest oil and gas site indicated cumulative cancer risk fell within the acceptable risk range.
And Ms. Green, are there limitations to the risk assessments you just described?
Yes. When considering results from quantitative risk assessments, it's always important to consider the limitations of each of these assessments. Quantitative risk assessments that estimate risk to humans from airborne chemicals are inherently linked to and limited by various types of uncertainty associated with exposure assumptions and toxicity factors. Uncertainties surrounding the results of these risk assessments were noted by all of the authors and are inherent to any quantitative risk assessment. In regard to the air monitoring data used for each of these assessments, one must consider the uncertainty due to the inability to realistically monitor continuously at all places of interest. In addition, for those chemicals reported as not detected in the air monitoring data, a conservative assumption is typically made by the risk assessor that the non-detected chemicals are present at half the detection limit, which may overestimate the air concentration used in the risk assessment. Concerning the toxicity benchmark values for both cancer and non-cancer risk, uncertainties are inherent and can result in over or underestimations of risk. However, these values are generally derived in a way that is intentionally conservative and are more likely to overestimate risk. The general uncertainty for these values comes from a number of sources, including uncertainties related to limited toxicity databases, use of animal studies to predict effects in humans, use of dose response information from levels of exposure to predict adverse health effects at low levels of exposure, use of dose response information from homogeneous animal populations or healthy human populations to predict effects in a diverse general population with a wide range of sensitivities, and the use of models and upper bound assumptions to estimate cancer risk.
Thank you. And Ms. Green, can you please provide the commission with your conclusion based upon the data reported in the risk assessments?
Yes. In conclusion, based on the data reported in these risk assessments, I've concluded that the risk for non-cancer and cancer effects associated with air emissions from oil and gas development sites tends to decrease with increasing distance from the oil and gas site. Only minimal exceedances were reported at distances of a half-mile from the oil and gas development sites and greater. And finally, recent implementation of improved practices at oil and gas sites in Colorado, as noted in previous testimony and slides, would be expected to reduce potential emissions and in turn decrease the potential for any adverse effects at distances even closer to oil and gas sites. Therefore, I believe that considering the minimal public health effects identified at a half-mile and greater from oil and gas sites, along with improved practices being implemented by Crestone and the fact that Crestone's operations will be well over half a mile at 3,100 feet, the state sunlight long pad is very unlikely to negatively impact public health.
Thank you, Ms. Green. With that, I'd like to go ahead and turn to Ms. Linda Dell. Let's see here. Make sure I can see you, Linda. There we go. Wonderful. Ms. Dell, can you hear me okay?
I can, yes.
Okay, thank you very much. Well, you've been qualified as an expert for purposes of the record. I just will go through a couple of questions to get you familiar with the commission. Can you please state your full name and business address and employer for the record?
Yes, my name's Linda Dell. My business address is 28 Amity Street, Suite 2A in Amherst, Massachusetts. My employer is Rambo America's Engineering Solutions, Inc.
And what is your title and how long have you been in your current role at Ramball?
I'm a principal and I've been here as a principal for over 3.5 years.
And where did you attend school and what degrees do you possess?
Yes, I have an undergraduate degree, Bachelor of Arts in Economics from Albion College, and I have a Master's of Science in Epidemiology from the University of Massachusetts.
Thank you. And are you a member of any professional association?
I am a member of the American Industrial Hygiene Association.
And do you specialize in a particular field?
I'm focused primarily on occupational and environmental epidemiology. I've conducted epidemiological studies of workers in different manufacturing environments. And in more recent years, my work's focused primarily on systematic and critical reviews of the literature, interpreting epidemiological literature for its use in data integration and dose response assessment in regulatory science.
Great. And do you have any publications or research?
Yeah, I have approximately 30 or just over 30 publications in peer-reviewed journals.
Okay. And do you have experience with oil and gas development projects in Colorado?
Yes, I have reviewed and interpreted epidemiological literature and contributed to reports that have been submitted to committees and boards.
And are you familiar with Crestone's approved Lowry Ranch Comprehensive Area Plan as well as the State Sunlight Long Oil and Gas Development Plan up for hearing today?
Yes.
Okay. And you have prepared a report in this case, and will you be presenting your conclusion to the commission today?
Yes, I will.
And when coming to your conclusion, did you rely on specific scientific or technical principles and methods that are widely used in your field?
Yes, I did.
Wonderful. Let's go ahead and turn to your testimony. So my first question would be, can you please provide the commission with an overview of your expert report and certain epidemiological studies regarding living near oil and gas development?
Yes, thank you, Ms. Jost. Good afternoon, commissioners. I appreciate the opportunity to discuss some of the epidemiological studies of living near unconventional oil and gas development sites. I recognize that many communities are concerned about emissions from these sites, and they want to understand whether living near oil and gas development sites could impact their health and well-being. Over the past decade or so, many epidemiological studies have tried to answer whether living close to oil and gas development sites is associated with health conditions or diseases. These epidemiological studies have looked at a number of health outcomes, most frequently birth outcomes, like preterm birth or low birth weight and birth defects. There's also been research into whether living near oil and gas development sites increases the risk of childhood leukemia or the risk of respiratory symptoms and certain heart conditions. Many of these studies, but not all of these studies, have found statistical associations between living near oil and gas development sites and an increased risk of these conditions. I reviewed many epidemiological studies identified in a recent scoping review of oil and gas development that was conducted by Aker and colleagues in 2024. A scoping review is an exploratory review of existing literature to identify what topics have been studied and to identify data gaps. It differs from a critical review or a systematic review that assesses the quality of the literature. As Aker and colleagues explained, there were a wide range of outcomes, exposure, and methodological approaches included in the studies, and they did not explore the quality of the studies. Aker and colleagues identified 27 epidemiological studies that used a cohort or a case control study design. Cohort and case control study designs are superior to cross-sectional study designs. In a cross-sectional study design, exposure is measured at the same time as the health effect is measured. So in cross-sectional studies, we do not know which came first, the exposure or the health outcome. Cohort and case control study designs, however, are able to assess the timing of exposure to ensure that the exposure occurred before the outcome. Each of these epidemiological studies used how close someone lives to an oil and gas development site as a stand-in for their exposure to emissions from those sites. They assume that the closer you live, the more you're exposed. These studies consider residential proximity as a surrogate of the true exposure, which was unobserved and unmeasured. The use of surrogates of exposure, however, can limit the conclusions drawn about health risks. Some simple examples of surrogates of exposure include using coffee consumption as a surrogate of caffeine intake, using duration of employment as a surrogate for exposure to a specific chemical, or using prescription data as a surrogate for medication use. In each of these examples, you may be able to see how using a surrogate provides an imperfect estimate of exposure. For example, if you rely on coffee consumption to estimate caffeine intake, you may miss the fact that some people drink decaffeinated coffee. Other people may not drink any coffee, but may drink energy drinks that are laden with caffeine. Other people may drink caffeinated coffee and energy drinks. Relying on coffee consumption solely could underestimate or overestimate their caffeine intake. Similarly, duration of employment may not accurately account for changes in jobs or actual exposures over time. And not everyone who is prescribed a prescription fills it. Some people fill prescriptions and then don't take their medication, or they don't finish their medication. Living near oil and gas development sites is also an imperfect measure of exposure to oil and gas development emissions. The study investigators of each of the epidemiological studies acknowledge that they're relying on living close to oil and gas development sites as a surrogate of exposure. In some cases, when study investigators report a statistical association between living close to oil and gas development sites and a specific health outcome, they will then explain that the association is biologically plausible based on hypothesized and unmeasured substances that are used at or emitted from oil and gas development sites, despite having no knowledge as to whether the substances were emitted or at what concentrations they were emitted.
Thank you, Ms. Dow. And can you please explain the influence of residential proximity and confounding factors for risk of disease to the Commission?
Yes, so using residential proximity to a site can also result in a confounded estimate of the risk of disease. Confounding is a distortion of the relationship between an exposure and an outcome, and it's caused by a third variable that is independently associated with the exposure and the outcome. For example, an epidemiological study might show a relationship between coffee drinking and lung cancer. In this case, smoking may be a confounder of that association because it is associated with both coffee drinking and lung cancer. A more relevant example comes from an epidemiological study in California. In this study, the investigators wanted to evaluate whether the risk of mesothelioma was increased from environmental exposure to naturally occurring asbestos. Naturally occurring asbestos is found in certain rock formations. The study investigators measured the distance from the residential location of over 1,000 mesothelioma cases and 890 control subjects to the nearest ultramafic rock as a surrogate of exposure to naturally occurring asbestos. This study was conducted by Pan and colleagues in 2005. Now, ultramafic rock is a source of naturally occurring asbestos, but similar to the fact that not all coffee contains caffeine, not all ultramafic rock contains naturally occurring asbestos. The statistical analysis adjusted for potentially confounding variables such as age, sex, and occupational exposure to asbestos. The study investigators reported that the odds of mesothelioma decreased by 6.3% for each 10 kilometers that a person lived from the nearest deposit of ultramafic rock. This is a statistically significant result, which meant that it was unlikely to be explained by chance. In a separate analysis, Cox and colleagues and Berman and colleagues in 2013, they simulated the data used by the California investigators. In these simulation analyses, Cox and Berman also measured proximity from residents to nonsense sources, such as fatal traffic accidents, which we know do not cause mesothelioma, and independent sets of randomly generated locations. In each case, there were positive and statistically significant associations between proximity to nonsense sources and the risk of mesothelioma. These investigators concluded that false positive associations were generated when relying on residential proximity to ultramafic rocks as a surrogate of exposure to naturally occurring asbestos. They concluded that these results were confounded by occupational exposure to asbestos. As I stated, the authors had assessed low, medium, or high probability of exposure to asbestos based on the job title of the longest held occupation or industry for each case and control. They reported there was a nearly 15-fold increase in odds of mesothelioma for workers with the highest probability of occupational exposure to asbestos. The odds ratios were much higher for occupational exposure to asbestos than they were for living near ultramafic rock. Many factors affect where people live, including where their workplaces are located. Individuals who work at a factory where asbestos was used may live closer to that factory than individuals who did not work at the factory. In this case, there are two factors that are associated with each other: occupational exposure and mesothelioma, and they are each associated with geographic location.
And Ms. Stout, can you please explain how exposure has been measured in these studies of residential proximity to oil and gas development sites?
Yeah, so one of the measures used is called an inverse distance weighted well count. This is a mathematical method to assign more weight to wells that are closer to a residence than wells that are distant from a residence. However, this approach results in a similar pattern of well density, meaning the number of wells per mile, based on different residential proximity scenarios. As explained by McKenzie and colleagues in 2014, an inverse distance weighted well count of 125 wells per mile could be computed from 125 wells, each located 1 mile from the maternal residence, or 25 wells each located 0.2 miles from the maternal residence. To extend that further, an inverse distance weighted well count of 125 wells per mile could also be computed from 375 wells located 3 miles away from the residence, or 625 wells located 5 miles away. In this surrogate method, these 4 individuals with different residential distance profiles, meaning how close or distant they live to a number of wells, they're assumed to be exposed to the same concentrations of chemical substances over time. In another example, the study investigators, Casey and colleagues in 2015, used an inverse distance squared weighted model that adjusted for well activity or the phase of well development. In this study, the investigators created an activity index that was standardized over the different phases of well development. The study investigators explained that women living closer to several pads under development but far from any producing wells could have a similar exposure as a woman living near only producing wells. Other exposure metrics that have been used include the inverse distance squared weighted well count, or an inverse distance squared weighted measure of the area of nightly flares, or the number of nightly flares, or oil or gas production volume. These are all relatively easy measures to collect data on using information from state databases or other sources that identify well locations and/or well development phases or production volumes. But these are indeed crude estimates of exposure for study subjects. These exposure models do not account for factors like different emissions, different substances or chemicals, or different dispersion patterns. It does not account for the fate and transport of chemicals. Some chemicals react, and the reaction consumes the chemical that was emitted, or perhaps creates a different substance entirely. These inverse distance weighted measures also do not account for different time activity patterns for individuals. As our day progresses, we move through different spaces. We go to work, we go to school, we go home, we run errands, we may go grocery shopping, and we move in and out of the outdoor ambient environment. So I hope it's clear that these subjects who are assumed to have the same exposure profile based on how close or how far they reside from wells are not exposed to the same concentrations of chemicals, or possibly even the same chemicals. Even if we were to measure exposure at their residence and found that they were exposed to the same concentration of chemicals, it doesn't mean the source of the chemicals are from the oil and gas development sites. For example, we can be exposed to various chemical substances in our homes from cooking or using consumer products.
And can you please also explain what other factors may impact public health in an area near an oil and gas development?
Yes, there are a lot of factors that affect our health and well-being. Where we live can also be indirect measures of social determinants of health that vary with geographic location. These are factors like economic stability, like where we work, as I talked before, but also access to quality education, access to quality healthcare, neighborhood safety, housing equality, access to nutritious food, as well as the air quality. We often live in neighborhoods that reflect similar backgrounds to us or similar social determinants of health. Almost all of the studies adjusted for factors such as age, sex, ethnicity, and some indicators of socioeconomic status. This was important because the study investigators showed that there were important differences between these variables and the outcome. But adjusting for these variables does not address the potential for residual confounding when these confounding factors are incompletely measured. In addition, there were other factors that were not measured and could confound the association between living close to oil and gas development sites and a health outcome. For example, risk factors for low birth weight include chronic health conditions such as maternal high blood pressure, placental abruption, pregnancy with multiples, smoking, drinking alcohol, and abusing drugs. Other factors complicate the comparison of results between studies. In addition to the different surrogates of exposure, there are considerations related to the statistical analyses used and the timing of exposure in relation to the development of the health outcome. So it's always important to discuss what comparisons are being made, and sometimes these can be somewhat challenging to disentangle. Recently, McKenzie and colleagues in 2025 published an epidemiological study of 451 children who were diagnosed with acute lymphoblastic leukemia between the ages of 2 years and 9 years, between 2002 and 2021. They chose 2,706 controls that were matched on birth date and Hispanic ethnicity. They used an intensity-adjusted inverse distance squared weighted exposure model as a surrogate for exposure. They then log transformed the exposure because the distribution of intensity-adjusted inverse distance squared weighted was skewed, measures were skewed. They divided the exposure into 3 groups as follows. People had low exposure if their intensity-adjusted inverse distance squared weighted well count fell below the 20th percentile of the distribution of the weighted well counts. People had medium exposure if their intensity adjusted inverse distance weighted well count fell between the 20th percentile and the 80th percentile of the distribution of the well counts. And people had high exposure if their intensity adjusted inverse distance weighted well count was greater than the 80th percentile of the distribution of the weighted well counts. In plain language, the low exposure category represented a cumulative monthly well count of 1 to less than 5 wells per square mile. The medium exposure category represented a cumulative monthly well count of 5 to less than 245 wells per square mile. And the high exposure category represented a cumulative monthly well count of 245 to 362,217 wells per square mile. These cumulative monthly well counts are all based on distance from the birth residence of the cases and controls to wells within 10 miles. These well counts were summed over the months of the relevant exposure window, for example, conception to the beginning of latency, where latency began 1 year before diagnosis. Each of the categories were then compared to the referent category comprised of children who lived greater than 10 miles from an oil and gas development site well at the time of their birth. Although the study investigators adjusted for several different factors, included inverse distance weighted measures of other sources of air pollution, there's still the issue of confounding by geographic locations. People who are close together may be more alike on a number of social determinants of health, not including the exposure of interest, than people who are far away. Also, these analyses assume that the cases and controls did not change residences between the time they were born and the time the cases were diagnosed with acute lymphoblastic leukemia. An earlier study by the same investigators, McKenzie in 2017, had evaluated acute lymphoblastic leukemia in children ages 0 to 24 years. These children were diagnosed from 2001 through 2013. In this study, controls were children who had been diagnosed with cancers other than leukemias and lymphomas. The investigators used a simpler incidence density well count measure. They measured the wells within a 10-mile buffer of the residents at cancer diagnosis. In this study, they found an increased odds of acute lymphoblastic leukemia overall, as well as for the low and medium exposure categories, but not for the high exposure category. In plain language, these exposure categories were less than 4.9 wells per mile for low exposure, 4.9 to 33.6 wells per mile for medium exposure, and more than 33.6 wells per mile for high exposure. Again, the comparison here was to children who lived more than 10 miles away from an oil and gas development well at the time of the case's diagnosis. Also, when stratified by age group, there was no association between the odds of acute lymphoblastic leukemia in children aged 0 to 4 years old over each of the exposure categories, low, medium, and high exposure. According to the American Cancer Society and the National Cancer Institute, the incidence of acute lymphoblastic leukemia is greatest in children under 5 years old. Arguably, the residents of children diagnosed with cancer under age 5 may be more likely to be their birth residents than the residents of young adults who are diagnosed with cancer in their teen years and young adult years.
Thank you, Ms. Dell. And can you please provide the commission with your conclusions on this issue?
Yes, so many epidemiological studies report statistical associations between living close to oil and gas development and adverse health effects. Nevertheless, these findings alone are insufficient to conclude that current setback distances are inadequate for protecting community health. Factors that affect the quality of the individual studies include the study design, the characterization of exposure, the ascertainment of outcomes, the exposure comparisons, or the contrasts. There's also the potential for residual confounding or confounding by unmeasured co-exposure or risk factors. Epidemiologists consider a variety of factors when making judgments about whether exposures cause health effects. These include factors such as the magnitude of association, the consistency of the association, biological plausibility, and whether a dose-response relationship exists. Importantly, some studies may report statistical associations between exposure and disease, but the biological plausibility has not been evaluated. And by biological plausibility, I don't mean whether or not an exposure to a chemical is capable of causing a health effect. Instead, I'm talking about what do we know about the range of exposure concentrations that are capable of causing a disease? At what level do those need to be? A well-known tenet of toxicology is it's the dose that makes the poison. The epidemiological studies of oil and gas development sites evaluated surrogates of exposure and did not use actual exposure data. They did not estimate concentrations from models or measure exposure concentrations that residents are exposed to, whether or not they are associated with emissions from the oil and gas development sites or other sources. There are many factors that are unaccounted for in these studies that assess living close to oil and gas development sites and health effects. Where we live is associated with numerous determinants of health that can confound the association between residential proximity to oil and gas development and health effects. Separately, residents have different activity patterns over time. Distance to oil and gas wells does not capture our true exposure to chemicals as we move throughout the day. In addition, there have been an increasing number of engineering and administrative controls placed on oil and gas development sites over time that significantly limit exposure to emissions. The exposure surrogates measured in epidemiological studies do not measure the true exposure, if any, to the emissions from the oil and gas development sites. So research is needed to explore alternative and non-causal explanations for the statistical associations that are seen between living near oil and gas development sites and different health effects. In addition, there are exposure studies that could be done to evaluate time activity patterns or to estimate exposure concentrations using models. These include the measurement or estimation of concentrations of chemicals at any distance from the oil and gas development sites to evaluate whether it is plausible that emissions from oil and gas development contribute concentrations beyond the ambient exposure levels at the residence. Epidemiological studies that rely solely on surrogates of exposure, such as living near oil and gas development sites, cannot be used alone to determine whether oil and gas development emissions cause any particular health effect.
Thank you, Ms. Dell. Much appreciated. Chair, that wraps up our second tranche of testimony.
All right. To my fellow commissioners, we're closing in on 5 o'clock. We could try to get through cross and commissioner questions. That might be, I don't know how long it's going to be. Or we could wrap it up and start back at 9 a.m. in the morning. Any thoughts from anybody? Commissioner Messmer?
I'm fine going into the evening. I do need a 15-minute break if we do. Well, not even 15 minutes, maybe a 10-minute break between like 5:20 and 5:30.
All right. I'm more in the camp of probably wrapping it up, but let's just poll the rest of them. Commissioner Oath, Commissioner Cross, Commissioner Ackerman, thoughts?
Mr. Chair, I'm okay with going on as well, but I think we still have a lot in front of us, and so if we continue on today, maybe I would suggest just cross and start with questions in the morning.
Okay, let's do that. Mr. Prescott, do you have any cross for the witnesses?
I do not. Thank you, though.
Oh, lovely. Mr. Foote, cross for the witnesses.
Yes, thank you, Mr. Chair. I guess we can start with Ms. Dell. She's got the slides 96 up anyway, so I wanted to ask a couple questions about that. Ms. Dell, the last sentence you have on here, it says additional evidence must be assessed and alternative hypotheses postulated, tested, refuted before residential proximity to UOGD can be considered to represent a causal relationship between exposure and disease. Did I read that right?
Yes, you did.
Okay, so my question is, when would we know when a causal relationship is established between UOGD and exposure and disease?
Well, I think that there are a couple of ways we can do this. So we've seen some epidemiological studies now that have shown these statistical associations between living close to oil and gas development sites and a particular health effect. Just because we see consistency, though, or some of the same associations, it doesn't mean that there isn't alternative explanations or bias that could explain the result, such as by confounding factors that we've talked about. So that is one thing that could be done, is to actually postulate, well, what are the non-causal factors that could explain this associations, the associations that we see, and then they can be, formulated and tested. Similar to what I described with the asbestos example of living near ultramafic rocks.
Okay. I guess also maybe another way to ask this is we have seen at this point 15 years of studies showing statistical associations between UOGD proximity and disease. Do we need another 15 years for that to be causal, or do we
Oh, no,
just
not
not
at
know?
all. No, I don't think we do. First of all, I think that we are already protecting public health as we should, even though we don't understand whether a causal relationship exists. We really do need actual concentrations of exposure. We need to understand what the concentrations of exposure that people are exposed to, and could those concentrations be from oil and gas emissions versus other sources that they're exposed to as well. So certainly there could be exposure studies that are done to better understand that. But just by virtue of the fact that you live near an oil and gas site doesn't mean, and these studies that have shown these statistical associations, they are assuming that that's what they mean when it's not necessarily true. There are other factors. Where we live are very important factors that, with social determinants of health, the different factors that also affect our health and well-being, and that can be where actual the geographic location is confounding the relationship between those social determinants of health, age, sex, our occupations, access to nutritious food. All of those things could be confounded by geographic location to oil and gas. It just hasn't been explored well enough.
Okay. So I guess theoretically this could go on indefinitely, right? Because it doesn't seem like it's ever going to be explored thoroughly enough.
Well, I would hope that there aren't any more studies actually of living close to oil and gas sites without actual exposure concentrations or modeling or something that, or testing alternative hypotheses. We don't need more studies of living close to oil and gas sites because they keep finding associations without exploring what other sources of bias could explain them. So I don't think that we need additional studies of living near oil and gas sites. What we need are to understand what are the concentrations that people are exposed to. Can they be, are those concentrations that they're exposed to, can they be attributed to the emissions from oil and gas development?
Okay, yeah, actually, I do agree with you that we don't need more studies of people living close to oil and gas operations, right? I mean, that's just not a good idea for people to live next to oil and gas operations. right?
No, I wouldn't say that. I mean, right now we've got protections in place. There are setback distances. We heard Ms. Green talk about the risk assessments where they actually did evaluate chemical concentrations near the receptors that are distant from oil and gas sites. You know, we don't have to have the epidemiological evidence can be weak and we can still protect public health. We can still do things to protect public health. And that is essentially what setback distances of 3,000 feet are protective of public health, as we heard from Ms. Green.
And you mentioned earlier that there are limitations, of course, to this type of study. Clearly, you can't expose a person to a whole bunch of benzene and see what happens to them, right? I mean, those are just inherent limitations with having human subjects. You have to find another way to figure out if something's dangerous than exposing them to the chemical on purpose and then figuring out what happened to them, right?
Well, epidemiological studies are observational studies. We don't intentionally expose anyone. That wouldn't be ethical. But
Correct.
we do have occupational studies of people who have been exposed to benzene in the workplace, and we can understand at what concentrations benzene is associated with their cancers, with their leukemias, for example. So just because we don't expose people doesn't mean that we can't find and that we don't have studies to support concentrations and to see or to what we know about the relationship between benzene and leukemia, for example. That's really based on occupational exposures for the most part.
Okay, that's all I have for you, Ms. Dell. Thank you. And maybe going in reverse order, we can call Ms. Green next.
Okay.
Ms. Green, I just have one question, one-ish questions for you. You mentioned in your testimony there's a risk assessment study limitation that you mentioned. One of them is that it's tough to monitor these emissions continuously. Am I getting that correct?
Yes.
Okay. Also, I think related to that, isn't it the case that it all depends on the air monitoring instrumentation, correct? If the instrumentation is bad, you're going to get bad data out of it. Fair to say?
I suppose I'm not an expert at monitoring it.
Okay. But I mean, in general, I guess what I'm saying, it's kind of the old saying, garbage in can lead to garbage out. Would you agree with that?
Yes.
Okay. That's all I have for you, Ms. Green. Thank you. If we can call Dr. Puckett next.
He's up.
Okay, great. Dr. Puckett, one-ish question for you as well. You indicated in your testimony that Section 8 of your initial report included enough information by which a third party could figure out your modeling or something to that effect. Am I sort of getting, it's been a while, but am I sort of getting that right?
Don't believe I said that.
Okay. Well, I guess let me ask you this. Do you believe that a neutral third party can recreate your noise models with the information provided in your report?
Not unless they had the proper noise emissions information from the specific equipment proposed by Crestone here.
Okay. So they would need Crestone's equipment in order to perform the noise models that you performed in your study. Correct?
Or similar equipment, yes.
Okay. That's all I have for you. Thank you. Mr. Ginter is next.
He's up.
Great. Sorry. I apologize. I would like to share screen. And I'm going to pull up Exhibit C12, Table 5. If it all works as expected. Great. Okay. Mr. Ginter, this is, just for the record, this is Table 5, page 30, the Thornton report. Do you recognize this that's in front of you?
I do.
Okay, and so Table 5 shows a comparison between your study, your ambient noise study, and the Thornton ambient noise study, correct?
Yes.
So the above it says USG, that stands for your study, correct?
Yeah, Urban Solution Group. That's correct.
Right. Okay, and TAV below that is the Thornton acoustics study.
Correct.
All right, and so it's comparing the different averages. On the top, it says comparison of USG 72-hour noise data and TAV 2-month data set results. I know you went over this in your testimony. You indicated that 72 hours is what's required by the rule. Wouldn't it be the case, though, that a longer study period could be better, even if it's not required by the rule?
No, not necessarily. If the sound levels are stable over the time period, which is what's clearly indicated in ANSI 12.6 Part 2, it's not required at all.
Okay. Well, I'm looking at the data on this table. It shows that the daytime and the nighttime dBA and dBc, A scale and C scale comparison between the two ambient studies. And it's accurate to say that the difference between your study and the Thornton study is no more than 10% on any of the A scale or the C scale measurements, correct?
Let me just look here. I would say roughly, but I have to point out that it's difficult to compare ambient data from completely different locations. That is relatively inappropriate to do.
Okay.
This is why I'm saying that ambient data by its very nature is location specific. So the ambient over here is going to be different than the ambient over there, and so on.
Right. Okay. Understood. All right. Thanks. That's all the questions that I have for you as well. And then
Okay.
finally, I have some questions for Mr. Dan. I'll stop sharing screen. Sorry. Okay. Mr. Dan. Is he
Am I
there?
on?
Yeah, there you
Can you
are.
see me? Okay.
Good afternoon, Mr. Dan, or good evening, whatever time we're at here.
Good evening.
Mr. Dan, you would agree that pre-production emissions releases still occur that go undetected by existing air quality monitoring systems, correct?
I don't know that to be true.
You don't?
That go undetected at a particular facility.
Well, I wasn't asking about a particular facility. I was just asking about the concept in general.
Do some emissions are they not necessarily detected?
Despite air quality monitoring equipment, yes.
I guess it's a hypothetical, but I guess I would agree with that.
Okay. And I guess you would also agree that air quality monitoring serves to inform the operator of a problem after a release occurs, not beforehand, right?
Of course.
Okay. And you would also agree that the farther away those emissions are for people, the less likely they will have an adverse effect on those people.
I'm not a public health expert. I can't answer that. I apologize.
Okay, no problem. Mr. Chair, that's all the questions that I have. Thank you.
All right. It's 5:10. I think we break for the evening, come back at 9 in the morning. Ms. Jost, you will have these 4 witnesses available for commissioner question.
Yes, sir.
Okay. And then well, why don't we just leave it at that? And then, so 9 o'clock in the morning, we're back. Do we need a motion, AG Boudreau? Ms. Jost?
Chair, may I ask for a time check? My apologies.
Yeah, let's do that for all 3 parties, actually.
Thank you, sir.
Mr. Elias?
Yes, Crestone, you currently have 3 hours, 12 minutes, and 30 seconds remaining. Maverick has 2 hours, 39 minutes, and 53 seconds remaining. And Star has 1 hour, 48 minutes, and 4 seconds remaining.
Ms.
Mr.
Jost?
Ellis, thank you so much. Can I have you just repeat mine? Thank you.
Sure. 3 hours, 12 minutes, 37 seconds.
Remaining?
Yes.
Okay, thank you so much. Thank you, Chair.
All right. Anything else, Commissioner Cross?
Yeah, I just wanted to double check. You said these 4 witnesses, this would also include the wildlife as well, though, wouldn't it?
Yeah, whatever this last panel was.
Okay. I just
Yeah.
wanted to make sure that I was on the same page. Okay.
No, that's a good catch. All right. I'd move to adjourn to 9 a.m. tomorrow morning. Do we have a second?
Second.
All those in favor?
Aye.
Signify by saying aye.
Aye.
Aye. We are adjourned. See everybody in the morning.